hand over all the slips. Original side, all the slips, and appellate side, when I call on the list, before that. Original side, all the matters hand over.
May I, Lordship's kind leave to mention a matter? I have mentioned it on Thursday.
Appellate side.
Original side, my lord. That is WPO 1103, my lord. I have mentioned it for withdrawal, my lord. My lord.
Oh, in your application form, the date is
My lord,
16.
that also I have mentioned, but it was supposed to come up on Tuesday. The difficulty is that, my lord, until and unless I withdraw with a leave to file, I cannot file the corrected copy, my lord. And
Let
there
it
is
appear tomorrow in the list then. 16th, in any event, it will appear. Let it appear.
as your lordship, please. I'm grateful.
My lord, may I permit it to mention?
Original side.
No, my lord. that's
Appellate
clear.
side, please wait when the appellate side matters are called on.
Choose to file today. File
No. My lord, I'm praying for leave to.
Leave,
I think she was wants to
Leave-
file it today. That's why.
leave to file what?
My lord, leave to file, move a recalling application by 17th, my lord. But my lord, if I file today by putting the date for listing on 17th, department will not, my lord, accept it. Because my lord, on 18th, my lord, CAC will shift my meter. And
File the date whenever the department accepts. Get it, have it filed and mention the filed number to my officer. I mean, to me. Whenever it is filed, please come back after filing and give the number. Give whatever date is accepted there.
Madam Mayor,
Thirdly.
just need to mention one matter for correction. Madam.
What? Appellate side?
Yes, appellate side.
Please wait for
Oh,
the
sorry.
appellate side is being called. Yes.
Item number 1.
Your Lordship, this for the notes of arguments.
Thank
you. I'm filing my notes of arguments.
Okay, Downey.
Shall close arguments. Learned counsel for the parties file their notes of written notes of arguments. Push up. Hearing is concluded in the matter. Let the matter stand. Let the matter. The judgment. The matter is reserved for judgment.
Item number 2.
Yes, this is my application, Miller. I filed the affidavit of service. If we dispose of it, what is the application for?
Yes, Miller, this is for recalling an order made in section 11, Miller,
Yes.
Appointing an arbitrator. Miller,
Yes.
apparently, Miller, an innocuous order at page 43, the impugned order. It's really, Miller, nothing more than appointment of the arbitrator.
But yes.
Miller, 4 grounds. First, Miller, in fact, Miller, I'll just make the entire thing easier for your Lordship rather than Miller. If your Lordship kindly takes page 8, paragraph 18. I've set forth the grounds, Miller, on which, Miller, the recalling I'm seeking.
See, it was passed in your presence.
No. Not even served.
You have taken that point in your.
All of it taken, Miller. These are, Miller, on the merits. If you take paragraph 21, Miller, the point of non-service, it's a rather serious, Miller, issue, which, Miller, I've taken paragraph 21 at page 9. A wrong address is, Miller, served. And that wrong address continues, Miller, before the arbitrator. I'll show your Lordship the minutes. Once he has entered into the reference, Miller, he keeps recording that wrong address. I don't blame him, but, Miller, the party who is doing it, Miller, is at fault.
What about these addresses were known to the parent?
My lord, may I just give you now that your lordship has an idea of what, my lord, I'm going to submit, my lord, the brief background on why it happened and why, my lord, this service becomes an issue. My lord, this is a company which is having a tea garden, engaged in tea business. My lord, this company entered into, my lord, a share purchase agreement whereby a new set of lordship wants to, new set of directors and shareholders, my lord, take charge of the office of directors and shareholders, buying out the entire shareholding of the earlier group. Well, the cutoff date is 30th of April 2021. This is of some importance. The consideration is this. I pay a particular sum, the total consideration about 12 crores and something. Well, I pay a particular amount, or that 12 crore something, particular amount is assigned as share purchase money. Well, the rest is assigned for all disclosed liabilities till 30th of April 2021. I'll show your lordship the agreement. On the basis of that, I make the payments. The respondent is a purchaser of tea. I enter into an agreement with him post 30th of April. He used to supply to the company. That's how he was known. Post 30th of April, I think on 4th of May, an oral agreement is entered into. I supply tea to him. I keep supplying. From 4th of May 2021 till this dispute is raised, not a single letter, not a single word saying you owe me money. There's a dispute between us. Not a single letter. My apprehension is this. This person, the respondent, and I'll show you, lordship, the invoices under the new agreement. This respondent has been set up by the earlier management. And earlier management of the petitioner. And I'll also show your lordship, the service is made to the office of the directors of the erstwhile management. And the registered office is deliberately, wrongly indicated. And it comes back with the endorsement left. And left under no circumstances can be, a good service. So there's a, insofar as I'm concerned, his disputes can only arise in respect of the second agreement, because the first agreement stands squared off. Everything was clear. If it is not clear, it has to go, to the money that I have already paid pursuant to that share purchase agreement. He doesn't raise any dispute with regard to the second agreement. His case is or the company, the petitioner owed him money under the first agreement. If that be the case, that the first agreement is what he's claiming under, in that case, there's a two-tier agreement.
Settlement first.
No, I'm sorry, I'll correct myself. Three-tier. Settlement first. If it fails, then Tea Traders Association. If that fails,
Timelines were given for each.
from what I can see, there are really no timelines. But the settlement has to be with me. I must be a party to it. I'll show you, in fact, kindly take the impugned order. Kindly see what is the stand. Kindly take, the impugned order. The paragraph, after the italics.
Yes.
He has further submitted that the dispute had arisen since the respondent had initially supplied tea in terms of the contract, respondent being me there, in terms of the contract, but subsequently he failed to supply. Therefore, the attempt for mutual settlement was made, which could not succeed. Not a shred of evidence or paper, at least to us, showing that this settlement failed or there was any attempt to make the
This
settlement.
entire proceeding was probably on the premise that you have been served and you have not controverted. They must have stated on oath. I mean, I'm just guessing.
Yes, you're absolutely correct. Absolutely correct. Lordship is absolutely correct. My lord, may I, my lord, show your lordship the agreement on which they placed.
So they say both the tires were satisfied.
yes, that's their case.
Right.
No, my lord, the first year they say, my lord,
Yes.
because it was that mutual settlement failed.
Yes.
They don't say yes, we sat for a settlement. It is
No, unless
almost-
they sat or stood
But
or
I-
whatever,
I don't.
how
know.
could it fail?
Right,
Something which-
but I don't know. I mean, I find that language quite deceptive, if I may use that term.
No, could not succeed has to mean, I mean,
Milord, kindly
never
take-
undertaken is different from could not succeed. There was a chance of success at
Milord,
least.
the reason for the could not succeed, I mean, that's the dispute. It's almost as if to say no, because this was the dispute, the mutual settlement did not happen.
Mutual settlements are like that, Mr. Mitra.
I
That's the
agree, but,
difficulty.
you-
Mutual settlement is very ambiguous. I mean.
But there'll be some Milord
Obviously,
thought-
there was no mutual settlement in the first place. So, any event, so they say that the second tier was also satisfied.
Yes, Milord,
Appellant had approached the calculator.
kindly take Milord page 49.
Hmm.
This Milord is the basis of the agreement. It's a letter.
Let me ascertain from Mr. Lal, would you like to use an affidavit to this?
Well,
Because certain
it-
facts, one allegation is that no service was properly effected on them. That's a very serious allegation because on that premise, probably many of the things proceeded also.
Correct. I would not want to file an affidavit.
Right.
I will just make my submissions because what my learned friend has said is partially correct. There are certain loopholes and certain gaps which I need to
No,
plug.
no, if you don't want to use it, then I'll hear it out right now.
That's right.
I'll continue.
Right.
Wait.
There are certain gaps which have to be plugged.
Wait.
Take
Take a seat, please,
Yes.
Mr. Lal. I'll just hear
If
you. Yes.
if there are gaps which require to be
No,
plugged-
gaps will be ascertained there. So I just give him the option so that we can proceed with the matter. 49.
Yes, Milord. No, then Milord, since I'll have to make my submissions in its entirety, Milord, let me start from the share purchase agreement at page 15. This is Milord, the share purchase agreement.
Right.
Now, Milord, I need to show Milord the two clauses. Kindly, Milord, take page 20.
Yes.
Milord, the clause number 3, it reads takeover date, purchase of sale shares, unsecured loans from purchasers. I'll just place 3.1 and 3.2, Milord. The parties here to have agreed to set 30th April 2021 as the takeover date. On this date, the existing management would ensure the appointment of at least one director of the purchaser and hand over the day-to-day operation of the garden. After the takeover date, the parties to this agreement would ensure smooth and unhindered transfer of ownership and management to the purchasers. Then Milord 3.2 is important. In accordance with and subject to the terms of this agreement, the sellers shall sell, transfer, convey, and the purchaser shall purchase from the sale of shares from the sellers on payment of purchase consideration on and with effect from the closing date. Now, free from all encumbrance and together with all accrued benefits, attached rights, and all dividends declared after the accounts date of the sale shares. So it's free from encumbrance. This has been qualified, Milord. Kindly turn over to the next page at 4.1. What would, Milord, be free from encumbrance? Milord, may I place 4.1?
Yes, please.
The total valuation of the garden and factory has been arrived at 1387, and the total valuation of 1,95,007 equity shares have been arrived at 1,28 crore. As per valuation report attached herewith. The value of the current assets as on the date of takeover date, that's 30th April, shall be paid by the purchasers to the sellers. The balance of the total value of garden and factory as reduced by the value of the share, value of shares shall be infused by the purchasers as unsecured loan over a period of time as and when required to pay off the liabilities of the company as determined and informed by the sellers to the purchasers. The total amount to be infused by the purchasers includes any amount already infused by them as on the takeover date. In case if the liabilities of the company, this is important, Milord, in case if the liabilities of the company as on the date of takeover is in excess of 12 crore 58 as informed by the sellers, then the same shall be borne by the sellers. So, Milord, any liability,
Limit was that.
that was the limit. Post 30th April, they have to take care. If it does not appear, they have to take care. Then, Milord, the consideration. Milord, this agreement also, Milord, has an arbitration clause, not really relevant for our purpose, but just to indicate, my lord, to your lordship, because we have already proceeded. My lord, at page 28, 11.10, there's an arbitration clause regarding disputes. Guwahati, Tripura. Yes. Now, my lord, kindly take page 33, my lord. On this very issue, I had, my lord, in December 22, my lord, lodged an FIR exactly on this issue. Lordship will find that at page 34. I don't, my lord, wish to waste your lordship's time with the entire thing. Page 34. Kindly, my lord, have a look at paragraph 5. After the takeover, we made further transfer of such and such. The amounts are given as unsecured loans from the payment of liabilities of the company in terms of our commitment. It is pertinent to mention we had also made payments of such and such on different dates for liability of the tea estate before signing the share purchase agreement of 30th, and which was also considered as part purchase consideration. Hence, an amount of such and such had already been infused by us till now. Thus, being situated as such, we are running the tea estate when all of a sudden we are shocked and surprised on receipt of a summons issued to me as an accused person from the court of judice when proceedings on the such and such, Assam tea plantations, etc. Now, my lord, kindly see 7, paragraph 7. After taking over, it has now come to our knowledge that the total liability of the old management is 17 crores, etc. And apart from the above, some more liabilities are arising one after another in form of claims and money suits being filed by various persons seeking to recover money that was owed to them by the old management. Such huge liability of the company was suppressed from us with an ulterior motive. So this, my lord, has been happening, my lord, for a while. Then, my lord, of course, the impugned order, I've shown your lordship already at page 43. Now, my lord, the issue is my knowledge. How did I get to know of all this? My lord, I have also stated in my affidavit. My lord, a mail was sent to me on 4th of April. Lordship will find that, my lord, at page 38 from my learned friend. And it is from this mail that, my lord, I get to know of the documents, and I get to know of these orders passed, the minutes of the meeting are held by the learned arbitrator. Now, my lord, if your lordship kindly sees yes, kindly, my lord, take page 41. This is, my lord, the minutes of the first sitting held by the learned arbitrator. If you take paragraph 4, I think, my lord, at page 41. Notices dated such and such issued by the tribunal to the respondent through speed post, both of its, I'm sorry, I'm reading, my lord, the third last line at paragraph 4 at page 41. Yes, yes. Is issued by this arbitral tribunal to the respondent through speed post to both of us are returned back with an endorsement left and addressee can't be located respectively. And he proceeds ex parte. But this was post facto after the appointment. What I'm trying to impress on your lordship is this: the addresses provided. So this was consistent. And they knew. They were aware and they knew that that was the, I'll also indicate that. I'll just indicate that. Now, my lord, the impugned order at page 43. My lord, if you come to page 45, there is, my lord, an interesting letter or mail, my lord, of May 25th. Kindly see, my lord, what the erstwhile group is saying, my lord. This is a mail given, my lord, to the respondent's director, I take it, my lord, Mr. Pankaj Baid. I'm surprised to understand why you're being ignorant about certain matters, and moreover, the letter of such and such is an afterthought. We've time and again addressed your concerns, and I've also replied. 1.
Respondent means present basis, my lord.
Respondent, my lord, I am the respondent in,
You are
I'm the-
T. You are the T
I'm the company.
company, yes.
Swiss Singapore, my lord, is the applicant in the
Obviously,
section.
yes, in the main
Section 11,
application,
yes. Kindly see the email sent, my lord, 1. The email sent on 11th May clearly states, there is no due pending on 4th May 2021. So the question of 25 lakhs is cleared between both the parties. This is the erstwhile management or director writing. After the payment was made on 4th May, such and such, it clears that the amount is totally adjusted with interest. Amount was cleared after receiving the email of Mr. Ankit, fine regarding fine. In fact, your accounts team has made mistake. We are supposed to receive such and such, which we have deducted 3%, such and such. And then, Millard,
You are erstwhile director.
my erstwhile Millard, kindly take page 48. This was probably this was the mail to which we had responded. This is of 1st of May 2021. Millard, the point I'm trying to make is, if I am the company and I am a juristic entity, separate and independent from my set of directors, I should have remained liable. Communication is to be made with the company. Kindly see with whom they are communicating. This email of at page 48 from Pankaj Baid to Rishit Patel, former director, former shareholder. Nothing to do with the company as on May 1, 2021. So, well, when I said that
But at the relevant time, Rishit, this person was the
correct. So, if it relates to Millard, a claim prior to 30th of April, which it seems it does, which is why they are communicating with Rishit Patel, that I don't have any liability. Let us, assuming for a moment that yes, they do have some claim. Millard, I would have thought if it's a, Millard, the interesting bit is, Millard, they are obviously aware of the share purchase agreement.
aren't these disputes to be raised before the
Millard,
arbitrator?
you're right.
We cannot go into.
You are right. I'm not joining.
A recall application of a
Millard, I
section.
am not joining issues. The
Hmm.
point I'm trying to make is, Millard, the surrounding circumstances are such that the giving the address which they gave assumes a malafide character. It is not such a mistake, an error. They didn't do it as if they didn't know. That's what I'm trying to, Millard, impress.
You have to establish yourself on very high ground then to recall the section 11 order, Mr. Mitra.
Yes.
Because if they show something to indicate that they had some basis of that,
And Millard, let us again.
That will be
let us,
sufficient.
Millard, say I don't take my case so high.
Hmm.
I restrict myself, Millard, to two things. One, they have not, Millard, they have not served me at the correct address. The presumption of section 3, subsection 2 of the Arbitration Act doesn't come into play. That presumption comes only when the correct address is given. I will show from the records that it was not served at the correct address. The second address where they serve is the personal office of the erstwhile director. That's admitted. Millard, if I can satisfy your lordship.
Personal office pertaining to the company.
No.
His personal office
Yes,
altogether.
they have left. Millard, they are now no more connected with the company. It's their office.
Very good.
Therefore, if they choose, Millard, to make a service, Millard, on their personal office, unconnected with the company, then Millard.
When did he leave the director? When was he
30th
was he
April.
removed?
No, share purchase agreement, Millard.
Oh, share purchase agreement.
So 30th of April 2021 is the cutoff date. So any communication post 30th of April 2021 or any communication at all should have been made to the company at its registered office. They choose, Millard, to give a wrong address in the registered office and they choose to serve on the erstwhile director's personal office. Whether, Millard, that can be construed, Millard, as a good service. Because I am also raising the issue that there is no arbitration agreement, and your lordship will have to see that
So
in a
if the
section
clause
11.
2, we have to look into with, I'm not, sorry, the section 21 notice was served at the right address. And the section 11 was filed, sent to the right address.
Moment the section, yes,
That is what we have to look into.
correct.
only.
But
Post fact or prior to that, during the
Well,
demand arising, why should you look into this? Even?
once the section 11 comes to your lordship,
Yes.
you will have to see that whether there's a subsisting or valid arbitration agreement or not.
True.
If that
Prior
is not
facie
there,
review. That prior facie review language is used
yes,
by the Supreme Court.
yes. So, my lordship will have to determine that.
These are either prior things, prior communications before the section 11 or the section 21 or
Correct.
subsequent, not the section 21 notice itself, service of that. If you cannot vitiate the service of that or section 11 application, then
Yes,
Mr.
I
Mitra,
I am on the section 11
service.
yes. Well, let
Say
me
it's a
produce.
wrong address, but you're showing some documents which are prior to the invocation also.
Well, the reason I'm showing the prior to invocation documents is this, that they chose to communicate with a group of persons who are not connected with the company.
Maybe regarding the dispute, they did so.
Correct.
That can be a ground of defense in the proceeding.
Now kindly, my lord, have a look, my lord, at the
Do you deny there was an arbitration clause in the
yes.
agreement? So that agreement itself was
My lord,
manufactured.
insofar as I am concerned, no. That's why I'm showing, my lord, the prior bit. If, my lord, for the prior agreement, my lord, I can't, my lord, justify if it's fraudulent or not, because I was not a party to it.
True.
I can't, my lord, say that. My lord, let us assume it was. My lord, as a juristic entity, I'm supposed to be bound by it. My lord, take my worst possible case. As a juristic entity, it is immaterial whether there's a X is the director, Y is the director, group A, group B, it's immaterial.
Previous service of emails on your erstwhile director.
The reason I'm showing is,
why?
yes, the reason I'm showing is, so they were communicating with the erstwhile directors for enforcement of rights under this agreement, which they are seeking to.
Suppose they did so. That
Correct.
might vitiate their dispute. I mean, as far as they are concerned. But
That-
what about we are only concerned with the section 21 and section 11? At the best, section 21 and section 11 definitely.
My lord,
At that service of
kindly, my lord, take the agreement once, my lord, which I already showed at page 49.
page 40.
9, my lord.
Yes, 49.
This, my lord, is the agreement
Uh-huh.
which they say is the basis for the section 11.
All right. What is the arbitration? Acha, this is the cause of action.
This is the agreement.
What is the arbitration?
Yes, kindly take F. This, according to them, F is the last clause on that page.
You showed something else as an agreement, and
That's the share purchase agreement.
that's the previous.
F, my lord,
Yes.
teas may be sold through auctions through the broker's catalog on privately or export in seller's name, etc. Kindly take the fourth last line. An escrow or separate bank account will be opened for this purpose, and the seller will pass necessary resolution and advise the bank to ensure that only the representative of SSIPL will be able to operate the account, will have control. Oh, I'm sorry, my lord. I'm sorry. Page 50 U. Sorry. I'm sorry, my lord. It's the last clause on the next page. I'm so sorry.
Oh, yes.
You. Buyer. sorry. I made one mistake of the page. Buyer and seller will endeavor to settle disputes and differences arising out of or relating to this agreement amicably and mutually. That's one. Second, in the event of failure to settle disputes mutually, the same will be referred to the Calcutta Tea Traders Association for arbitration. If there is no settlement, even thereafter, the matter will be subject to the jurisdiction of the Honorable High Court at Calcutta.
Mhm.
This, my lord, is the arbitration agreement. It's really not even two-tier, my lord, but a three-tier process. So, my lord, they will have to, my lord, show that there's a three-tier, or the two tiers prior to the third tier have, my lord, been performed, and it has failed, which is why the third tier. My lord, in my respectful submission, there's no such finding. Now, my lord, if your lordship kindly takes my petition once.
What about the service of their
Yes.
section 11?
My lord, I don't have the 21 notice.
That Mr. Mitra is a very,
No, let them show that they have,
why should they? After the section 11.
because I am
orders passed,
saying,
presumption is, it was done
let them,
judicial.
because
judicial
I haven't
acts.
got a copy. I haven't got a copy. Let them show where they served, my lord. I'd like to see. Which is exactly why I thought they would come up with the affidavit. I'd like to see where they've served. My lord, and why? Why should I? Lordship
No,
is
you have
right.
to show something, Mr. Mitra, to at least indicate from the section 11 application.
My lord, I don't have a copy of the application.
You could have taken out a copy from
No,
certificate.
my lord, it has been served. On their request, I have served it. They're fully aware of the contents of
Okay, this
section
is-
11.
Okay. Yes. I'm sorry. This has come subsequently, my lord. This has come subsequently.
That address is your correct address, the company's address.
No. This is given subsequent to my solicitors, my lord. After the mail,
The address of the section given in the section 11
I'll just
application. If
check,
that is the
I'll
correct
just
address,
check.
then there's a presumption of correctness.
Right. At that point of time, my lord, that was the address.
I'll just check. What?
Oh, thank you. Service টা কোথায়? ও আচ্ছা আচ্ছা।
আরে কোন একটু দেখাবে তো আমাকে। My lord, I find এটা তো section 21 notice. Is the notice. Slightly now handicapped, my lord, with a sudden
Mr. Mitra, you don't have a case. I have got the affidavit of service, you can go through it. Just go through it and decide whether you'll move the matter. or
of the
withdraw it.
section 11.
Decide whether you'll move it or withdraw it.
I'll just check. my
Because
lord.
I'll have to take these into consideration also.
Yes, of course.
Otherwise, there'll be no finality. Anybody and everybody will come up and say, we have not got served.
No, I just wanted to check, my lord, where they have served it. That's all. If I can't show it, my lord, it will be
So section 11 copy is also with me. Belsery
Yes.
Tea Company.
yes.
What is the address you have given in your present application?
My lord, the present
Sharad Bose Road, it's the same.
The same address.
Same address.
no, that's because
Because it was given in the section 11.
That I can hold it against me because he can't change the
Yes.
first title.
no, not holding against. I mean, I have to do it.
Mr. Mitra, costs against your client.
Kindly have a look at 21,
20.
which is what I had, my lord, of my recalling application.
Page 21.
Paragraph 21, my lord, at
Perfect,
page,
right.
page 9.
Achha. So you see, this is your address. "21 Rajendranath Mukherjee Road is common. Previously situated, all right.
That was previous. And they were aware of it. From 21, we've been in business. From 1st May 21, we've been in business. I'm not denying that. I have annexed the invoice.
Previously means from when? Since when was the office shifted?
That's the point.
And that's not stated here also. We are concerned only on the regarding the date when
Correct,
the service was effected.
correct.
And it was effected properly also, in fact.
Well,
First you give me back the service.
give it back.
That's more important.
That will be one of the more important premises of this is the assessment of costs.
No, let me just come back, my lord, with this when it was shifted.
Mr. Mitra, there's
Kindly keep
nothing
it
in your
tomorrow.
application. As it
My lord, with the
stands today, your application has
my
nothing.
lord,
in
if
it.
I can show, my lord, that the office was shifted thereafter, anytime after 30th of May, 30th of April,
In a recall application, I'll go into that inquiry, Mr. Mitra. I don't.
because it's a 2022 section 11. Well, service has to be effected. A section 21 notice is served at an address in 2022. My lord,
Regarding the agreement, let us see the agreement you were stating about. The agreement concerned.
this
Page
is the
45.
earlier agreement. Yes, madam.
What is the address given there?
This must be the old address. Has to be, because this is of 11th.
At least what they can proceed on that presumption that that is the correct. If you have changed your address,
But they are with, my lord, if you kindly see,
this is going too far in a recall application.
kindly.
And even in the section 11.
Your lordship will see page 49, what are the two addresses at the
Yes,
top
and
and,
there, and
and,
there.
the, and at the
Naturally,
bottom.
naturally, because then it's 11th of March. I'm saying 30th
Correct.
of April. So 11th of March, obviously those will be the addresses.
You shifted address between April and March. March and April.
Yes, yes, because 30th. Oh,
No presumption. There,
The 30th
there
of
can be a
April.
presumption of correctness.
No,
They need not know that.
30th of April.
Show
once
me any communication to you at your new address by
Yes.
them. By them.
None whatsoever.
My lord,
Obviously, otherwise Mr. Mitra would be ready with it.
kindly take page 66
66, right?
onwards.
Yes.
On the top left hand, Belsari Tea Company. Kindly see the address given, my lord. It's in Assam. They've received all of this. They've made payments on all of this. All of the invoices.
These questions cannot be gone into in this.
Lord,
regard.
to prove only the issue of address.
This is a very weak proof because your that letter, that agreement in question, that was entered into within say about a month before the.
Yes, yes, because my
the
lord, the
invocation.
share purchase agreement takes effect on 30th of April. It's only thereafter, my
Is there
lord,
anything to show that you have informed them the change of address? Must not be. Otherwise, you have
but,
to that.
if it's a public record, I need not inform. If I
Yeah.
formed a Form 8
You
with the
communicated
registrar of
the
companies.
agreement, Mr. Mitra, which was only a month back before that invocation,
Lordship.
that mentioned a particular address. They have mentioned that address only in their invocation and in the section 11. So that's
Which
fine.
is in 2022, after they were dealing with me from 21 till 22, my lord.
Hmm.
It's not as if it happened on 2nd of May. 2021, I've taken over from 1st of May. 1 year thereafter, my lord, we've been in business. The section 21 notice, my lord, which is annexed, my lord, is sometime in 2022. Give your lordship the exact
You're
date.
right.
Can't find it. 28th of September 2022 is the date of the section 11, section 21 notice. And they address it, my lord, to Sharad Bosch Road. My lord, my address, my lord, the reason I wanted, my lord, to show the malafide is my address is Grant Road. They merrily keep sending it to Grant Lane and it comes back as addressee not found and left. If they knew it, my lord, why would they write Grant Lane instead of Grant Road? Let us assume, my lord, on 11th of March, they send it to that address. Is that address also correctly given? If I may pose this question to myself.
Since a copy has been given to you of the section 11, Mr. Mitra, have you gone through it once?
No, my lord. I just received the copy now.
Because they had sent a demand notice. That was
All at Sharad Bosch Road.
these two. Sharad Bosch and Narayan Mukherjee Road, you replied to that.
That's right. That is the point I'm making.
Mr. Lal is waiting to pounce upon you on that.
No, I will wait for
That
him
is
to
a-
finish and thereafter pounce.
That is annexed at page 35.
My lord, I'll tell you, lordship, what happened. This reply was given by the erstwhile directors, not by me.
Sorry, my
This
understanding
is-
is wrong.
My lord, may I do this?
Do
To
that.
save any further embarrassment to me, may I come back? I'll just come back tomorrow. Let me have a look, my lord, at
Come
the
back.
section 11 and
Upon commencement of arguments, comma, it transpires that there is some doubt as regards some of the averments made in the application for recall of the order passed under section 11 of the Arbitration and Conciliation Act 1996. Full stop, next para, to enable learned counsel for the petitioner, learned counsel for the applicant in the present recall application to take further instructions on the issues, comma, the matter is adjourned for the day and shall next be listed tomorrow under the same.
I'm grateful,
Come
my lord.
Congrats.
Just go through this section
Yes,
11 once.
I will.
Item number 3.
My lord, I am for the petitioner, my lord.
Yes.
Well, for the
I'm
respondent.
appearing for the respondent.
Right.
My lord, may I file the affidavit of service? Second.
Yes, what is the matter? Why are you appearing online? Mr.
Lordship,
Saha?
I'm not well. I have been suffering from fever and there has been allergic rashes all over my body. So
Sufficient,
it's not
sufficient.
safe for me to
I can
go
see
in.
rashes also now. So it's sufficient.
Yes, but,
Yes, please.
Lordship, the petitioner is a trader in yarn and polyester fiber. Millard, the respondent is a manufacturing unit, Millard, who for conversion of polyester fiber and raw material into polyester yarn. My lord, what had happened is that the respondent in November 2020 approached
You
the petitioner.
produce the raw material, you supply the raw material.
I supplied, no, I orders by a third party and supplied them a raw material to supply the respondent the raw material
But
and the
in between the
process.
two. So you take orders and you get the supply from these manufacturers.
No, I supplied from third parties to the respondent, and so the respondent manufactures and convert those raw materials into polyester fiber yarns.
You are the supplier of raw materials then.
My lord, I actually is a trader.
What is
in
the relation
mid-
between
I'm
you and
middleman.
this respondent? You are a trader in raw materials,
Yes,
which you trade off with the respondent.
I supply them for conversion of the raw material into.
Obviously, otherwise it could not be raw material if there is no conversion. Anyway, then what happened?
Millard in
Agreement for job work. This is the
Yes.
agreement.
Yes.
Where is the arbitration clause?
At page 14, Millard.
Pages are not paginated in my copy.
Not paginated in my copy also, Lordship.
Not done. Very difficult. We'll have to come back day after tomorrow, paginate the copies. I'll give you leave today itself. And your copy, how can they paginate? You'll have to send it to some, or they will serve us fresh copy. Ask your clerk
No,
to.
I can get it paginated on my own.
That may not
I
tally.
can-
Very well. Have it tallied?
That's the difficulty. If it does not tally, that will be a difficulty.
Well, I'll ask them to paginate it today itself in the court's copy. They'll take down in their own copy and they'll communicate over the phone. They'll just tally the middle pages so that you know how it's done. It's seen at the outset that the application is not paginated. Full stop. Accordingly, the learned advocate appearing for the petitioner is requested to is granted leave to incorporate the relevant paginations in all the pages of the present application during the course of the day. Full stop. After carrying out such amendments for which leave is granted, comma, a fresh copy of the same shall be served on the learned advocate for the respondent. Full stop. The matter shall be taken up under the same heading day after tomorrow, that is on May 17, 2023. Try to serve. If not possible, then just communicate so that amounts to service. So do it during the course of the day in my copy.
Yes.
And have your copy paginated also according to this, so that you can give.
Lordship, one more leave, Lordship. The Vakalatnama, the client has sent it, but it has not reached me. And day after tomorrow, by that time, I'll file my Vakalatnama also.
Very
That
well.
leave may be.
But take instruction whether you have any strong objection to this at all. And if you don't have any objection, it will be a short affair then. Subject to the paginations, of course.
So I'll address day after tomorrow at the time.
Ready. Come back.
I'm grateful.
Item number 4.
Yes, Mr. Banerjee.
Yes, my
40.
lord, I appear on behalf of the respondent. My lord,
Respondent.
here, my lord, there was a case of section 11. My lord, I'm appearing on behalf of the railway authority.
Hmm.
My lord, it should be bona fide to my part. My lord, if I show 3 names, then my lord will select 4th name. My lord, we have, my lord, a panel of arbitrators, as your lordship knows.
So now under section 12, this is difficult. There are certain judgments also. So
Yes, for such reason, my lord, I cannot oppose that.
Who is appearing for the
My
petition?
lord, Banti, Arindam Banerjee, my lord, Banti. My lord,
I'll pass it over in the first call, Mr.
Lordship,
Banerjee.
lordship,
Since it can be
lordship.
disposed of in a
lordship,
minute.
lordship,
Just try to inform any
Yes,
of
yes.
his clerks or juniors so that I can take up in the second call.
my lord.
Passed over in the first call.
Item number 5.
5, 6, and 7. I am appealing on
Yes,
behalf
my
of the
My
respondent.
application. You're for the
Respondent.
Yes. You have the petitioner, what is that?
Yes, my lord.
Are you opposing?
Yes, my lord.
Yes, what is that?
The facility agreement, hypothecation given of the assets, guarantee given by the respondents. Now, my lord, it has defaulted. We have given them a notice, no response. And my lord, we
Show
have
me the
invo-
arbitration clause,
Yes,
please.
my lord, kindly, my lord, in item number
Now that
5.
the brief has arrived.
Yes, my lord, I'm sorry, my lord, I was just buying time. My lord, Lord,
the
kindly take page 27 of my application. Clause, my lord, 9.11. This, of course, my lord, it's an
Let me hear. Yes, it is an.
no, my lord, my lord, no difficulty, my lord. It's a unilateral arbitration clause, but lordship, my lord, now the
Maybe.
law is very
Let us hear them. What is their objection so that
Yes,
you can
yes.
answer.
Yes,
That will be
sir.
easier.
Yes.
Yes. What is your objection?
Objection, my lord, already they have filed this application against the respondent, my lord, on the personal case of the director, my lord.
On the personal?
But against the director, my lord. On instruction for my client, it was settled, my lord, by the company.
Achha. The agreement was with the company.
Yes, my lord.
Right.
Kindly takes page 37, the name of the respondent is given. That's the address of the borrower.
You are Shrey. Yes, that is the borrower. Borrower was not a company.
No, individual.
What are you saying?
No, my lord,
Shrey has filed this. Shrey is the company, which is a creditor. You at the borrowers, page 37.
Page 37, the name of the borrower is mentioned.
Yes. Customer. And the customer is what has been mentioned in the first page of
my
the
lord,
agreement.
on
Also.
instruction, yes.
Instruction is wrong. First instruction wrong. What is the second instruction?
And there is no, no sixth instruction.
This is
That's,
the only objection.
yes, my lord, my objection regarding the,
Chakraborty is the instructor.
no. But objection regarding the appointment of arbitrator, my name of the arbitrator.
That your lordship will appoint.
Suggest somebody whom you don't like. Let them oppose. Then I'll fix somebody else. Why not? That's an exercise we are happy with. So what should I record as your objection? You please check up once. Please check up page 37 of the application. 37 and page 10.
Yes.
Page 10, the agreement is between Shrey, which is the petitioner, and the customers as detailed in Schedule 5. That is page 10. And page 37 is the Schedule 5, which contains the names of the customers, which are the present respondents again. So what is the difficulty?
My lord, kindly taken up day after tomorrow.
No, right now.
Because one of the
No.
yes.
It will not be adjourned on this ground.
But only one thing may I point out, Manad, why my
Point out your worst point, yes.
no, worst point. Only thing is that there is a facility agreement and there is a deed of hypothecation. There are arbitration clauses in both the agreements. The arbitration clause in the deed of hypothecation is page 60, where Manad, it says the facility agreement will apply. The provisions of the facility agreement will apply.
Can be constituted as a part of the same.
Yes, Manad, that is what my submission is.
Show me page 61.
Page 60, Manad, clause 16, the last clause. Any dispute or differences arising out of in connection with this guarantee, subject to the arbitration and jurisdiction clause being numbered 9.10 and 9.11 respectively in the facility agreement.
Customers.
What is the valuation of the dispute? Value of the
My claim as per my demand notice is 23 crore 94 lakh 61,000.
So ex-judge would be better. Ex-judge of
My
the,
lord.
this court. Whom do you oppose?
Yes, my lord.
Whom do you oppose? Whose name do you oppose as arbitrator?
My lord, Ajay Krishna Chatterjee, my lord, my suggestion is Utpal Basu,
I won't accept either of the two. Very.
Swarnendu Ghosh, or
23 crores.
Swarnendu Ghosh.
23 crores, not Swarnendu Ghosh. The
Any,
value is 23 crores. Has
Eh,
to be some high court judge.
yes, my lord.
I mean,
I
ex-high
have
court
no-
judge. Learned counsel for the petitioner places reliance on the arbitration clause being clause number 9.11 of the facility agreement between the parties dated October 1, 2018. full stop. It is further submitted by placing reliance on a subsequent agreement. What was that agreement for?
Malad, the deed of hypothecation where the assets were hypothecated.
Acha,
Malad, page 47 is where that deed starts.
a subsequent agreement na kore, a subsequent deed of hypothecation dated October 1,
Same date.
না subsequent তাহলে বলবেন না, and a deed of hypothecation. এটা কি কমপ্লিকেটেড হয়ে গেল? একবার রিপিট করে দিন, আমি বলে দিচ্ছি। হ্যাঁ, such and such clause of the first agreement বললাম যে facility agreement dated such and such October 1, 2018 and a deed of hypothecation of event date, comma, in clause 36 of which any disputes or differences arising out of or in connection with the same have been referred back to be resolved within the contemplation of clauses 9.10 and 9.11 of the facility agreement, comma, to indicate that a dispute has arisen between the parties within the purview of the said arbitration clause. Full stop. Next para. Learned counsel also places the invocation under section 21 of the Arbitration and Conciliation Act 1996 annexed to the present application. Full stop. It transpires that despite an invocation having been made by the petitioner and the expiry of more than 30 days thereafter, comma, there has been no response from the side of the respondents to such invocation for the purpose of reference to arbitration. Full stop. Hence, comma, as the dispute is otherwise arbitrable, comma, AP 236 of 2023 is allowed, comma, thereby appointing Justice Topon Kumar Dotto, comma, a former judge of this court, as the sole arbitrator to resolve the dispute between the parties, subject to obtaining his consent under section 12 of the Arbitration and Conciliation Act 1996.
I'm grateful, Malad. Only thing is
It's
that
also
the
same.
tracking report, Malad, by which it will be proved that section 21 notice was served, that is not annexed to the application. I'm carrying the tracking report, Malad, separately. If your lordship so desires, I'll
File that copy. The original you'll file. Do you have the original?
Yes, Malad, I have.
প্রথম সেন্টেন্স যা হলো ঠিক আছে, একদম প্রথম সেন্টেন্সে একদম স্টার্টিং এ learned counsel for the petitioner hands over. This is a track report.
Yes, Malad, it's the tracking report, but Malad, it's not the, I mean, it's the printout copy, downloaded
It
copy.
cannot be original. It cannot be. It has to be.
It's downloaded
How will you
from
download the software?
Yes, Malad, it's the India Post website where Malad, it is downloaded.
কি বললাম? Learned counsel hands over a printout of the relevant track reports to indicate service of the invocation notice under section 21 of the Arbitration and Conciliation Act 1996. Let the same be kept on record. বলে তারপর
I'm
যা
grateful.
বাকিটা বলো। Thank you.
And next also, next
Similar?
6, 7 similar.
Similar, Malad.
5, 6, 7, the
Only
dispute.
difference, only the dispute is the same, the quantum is different, but only difference is instead of the deed of hypothecation,
The
here
quantum in the others is regarding in crores or
in crores, Malad, in crores. But it can be Malad, referred to the same arbitrator, Malad, same parties.
yes. So let the same order be passed in all, please. Justice
Let-
Topon Dotto, you cannot have it.
No, no, no.
The only difference is that Malad, there is no deed of hypothecation. In item 6, there is a deed of guarantee containing Malad, the similar arbitration clause, which
And in 7,
in 7, Malad, there is no deed of guarantee or hypothecation at all. It's only the loan agreement.
আচ্ছা, 6 sector 6A same order 6A as 5 শুধু একটা নোট করে রাখুন, হাইপোথিকেশনটা কপি পেস্ট করে দেবেন। হ্যাঁ, একটা জায়গাতেই হাইপোথিকেশন কথাটা পাবেন, সেটা তার বদলে গ্যারান্টি হয়ে যাবে। হাইপোথিকেশনটা কন্ট্রোল ফাইন্ড করে গ্যারান্টি করে দেবেন 6A, বাকিটা সেম। আর সরি, এটা হচ্ছে 6 হলো, আর 7 হচ্ছে প্রথম সেন্টেন্সে learned counsel places dates are the same of the
Dates are the same, yes.
facility dated such and such বললেন, যেখানে শেষ করলেন stop. Facility agreement dated such and such stop. ওই সেন্টেন্সে বাকিটা লিখবেন না, যা আছে সবে ঠিক আছে, মানে অন্য কোনো এগ্রিমেন্ট সঙ্গে দেয়নি। মনে থাকবে না, নোট করুন। 5 এ সব এক, ডিড অফ হাইপোথিকেশন, 6 ডিড অফ গ্যারান্টি, হ্যাঁ,
Loan
আর
agreement.
7 এ হচ্ছে প্রথম সেন্টেন্সটা ওই প্রথম ফ্যাসিলিটি এগ্রিমেন্ট অনলি।
Only loan agreement, the date is different. Loan agreement's date is 30th June 2020.
Should I term it as facility agreement?
It's termed as loan agreement. That is why I'm saying.
The others are facility.
All others are facility.
লাস্টেরটা আমি একটা অর্ডার দিয়ে দিচ্ছি, 7 একটা অর্ডার। Learned counsel for the petitioner places reliance on
39 last.
Page 33 is the arbitration clause
Hmm.
in item 7. Clause 17.
clause 17
Yes, 17, page 33.
of a loan agreement.
Dated 30th June 2020.
Where do I get the date?
So will kindly want to take page 1 of the loan agreement. One second.
Date is not given here.
Date is not mentioned, but that's
Then
only a loan agreement, Your Lordship, so mention.
June
It's mentioned
30th.
in my section 21 notice and
21 June 30th, 2020. That the loan agreement being numbers of page 46.
page 46, the loan agreement is 30th June 2020.
That's a different.
No, that is the agreement. The first line of page
Yes,
46.
30th June. Then.
Yes, madam, 30th June. That is
Acha, loan agreement dated June 30, 2020, comma, which contains an arbitral clause, comma, within the purview of which the present dispute between the parties has arisen. Full stop, the dispute is otherwise arbitrable. Full stop, hence, comma, AP 239 of 2023 of 2023 is allowed, thereby appointing Makita Ek.
I'm grateful, my lord.
the tracking reports in the other two matters, maybe. Well, that
আর বাকিটা এক, পুরোটাই এক, track report শুদ্ধ। All the others give copies of the tracking reports.
I have, my lord. I have. My lord, all three.
Huh?
In single page, Lordship, pardon.
I'm deeply obliged.
I'm grateful.
Item number 8.
Yes, sir.
The respondent.
Respondent, what is the objection?
No, objection is a peculiar situation. My lord, section 11 was filed by me. Arbitrator was appointed by Chief Justice. The petitioner participated.
Passed over in the first call.
Yes, the award passed.
Award passed.
Award passed. He participated. Now put in execution. Now another section 11 by suppressing everything.
For the execution.
No, for
Not-
11.
Execution cannot be for another arbitration.
No, I don't know what the. In the section 21 notice, they did not say anything.
The second call will
Yes,
will
yes,
consider.
yes.
Second call. Passed over in the first call.
Item 9.
My lord, I beg to appear for the
Yes,
petition.
Mr. Lordship. What?
Your lordship gave us the liberty, my lord, to file the supplementary affidavit.
I
My
have
lord.
received today, my lord, 79 copies.
When should I take it up? Tell me.
Anyway, lordship,
My lord, the only relevant letter is at page 66.
66.
Yes, my lord.
if that be the so, my lord,
Query fell from your
You're ready.
lordship.
I can make submission on this one.
A query fell from your lordship that before invocation, my lord,
Lordship,
did
let's see
we,
the
my lord,
last thought,
approach
last
the authorities?
Before
Before
invocation.
invocation, my lord, did we approach the authorities, my lord? These are the communications between the petitioner and the, my lord, the port trust authorities. And my lord, this
to
is, my lord,
exhaust that provision.
7.9.
my lord, my lord.
So you had.
My lord, to my understanding, my lord, we have, because my lord, the only trouble is, my lord, what is troubling us, my lord, the nomenclature engineer. My lord, they say as per the clause that we'll have to approach the engineer, but my lord, no engineer, my lord, supervise this work. It was always the general manager, engineering department of the port trust authorities. So all the communications, all the requests, prayers have been made before this particular authority.
Once more see the arbitration
My
clause.
lord,
86, 87, 7.9.
87.
Page 87.
Yes.
my lord, 87, 7.91.1.
So general manager has not been mentioned separately in this
My lord,
agreement.
My lord.
And he has to mention this clause that is mentioned here. He has to mention this clause.
Why?
Because, my lord, the letter they are referring, that is against the invocation of the bank act. That is not they are asking for.
Arises between the employer and the contractor. They are the contractor.
Your lordship can
contractor-
see that.
I'm looking into the arbitration clause first. With the before after repudiation of the term. First, it has to be referred in writing to the engineer.
Within 30 days.
Let us see whether the engineer has been defined in this
My
contract.
lord, it has been defined. It has been defined.
Let us see that. What is the definition of engineer here?
My lord, kindly comes to page 48, my lord.
48, the exit.
My lord, G, 7.1.2 G.
Appointed by the employer to act as the engineer for the purposes of the contract.
My lord.
So any indication of this in the body of the contract? Who has been appointed or whatever? Let's check up.
My lord, I have, my lord, there is, my lord, this general manager, my lord, engineering, this is the person, my lord, who has, my lord, terminated the contract. The
But you
work,
have to approach him first then.
my lord, to my understanding, we'll have to approach him, my lord. That we did after termination of contract, before invocation.
This is not an invocation.
And my lord, kindly sees the refusal letter. The rejection is at page 102, my lord.
Right, right.
100?
102. My lord, this is the rejection of the invocation, my lord. This is being issued by the senior deputy manager, P&E department, who is the, my lord, work order issuing authority.
Yes, yes.
So, my lord, he says that we'll have to approach the engineer. Now, my lord, after termination, we have approached this general manager, who is the, my lord, terminating authority. The general manager engineering at page 66. My lord, this is prior to invocation. And my lord, there is no other engineer that we, my lord, have come across during this work.
Yes, general man engineering must be an engineer also. And the clause is clear, Mr. Kushal. Clause is clear.
What is the letter? Invocation will happen.
Have to approach the engineer. After the engineer, straight away arbitration. If there is no settlement, obviously there was no settlement.
May I
Yes, Mr. Kushal.
may I respectfully submit, my lord?
Yes.
This was handed over, my lord, only yesterday, my lord, which was today morning, my lord. What we have gathered from the letter, my learned friend is referring to as annexure F to the supplementary affidavit, my lord. Page 66, my lord. Lord, will kindly take the next page, my lord. The last para. Lord, you will see, hence you are requested to withdraw the termination letter with immediate effect, along with providing necessary instructions to the bank, stopping the encashment of the bank guarantee, which is a performance bank guarantee, which they were supposed to, my lord, give in favor of the port trust, my lord, as the technical dispute to carry on the job remains unsettled, unanswered, and incomplete. But pausing here for a moment, my lord, if your lordship now takes clause 7.91.1, my lord.
Such reference shall state it is made pursuant to this clause.
Yes, my lord. Now, lordship will kindly take page 87 of their petition, my lord. May I read from the top only the first paragraph, my lord? If a dispute of any kind whatsoever arises, dispute has arisen, my lord, with regard to termination, my lord, between the employer and the contractor in connection with or arising out of the contract or the execution of the work, whether during execution of the work or after their completion, and whether before the repudiation or other termination of the contract, including any dispute as to any opinion, instruction, determination, certificate, or valuation of the engineer, the matter in dispute shall, in first place, be referred to in writing to the engineer within 30 days. Now, my lord, with a copy to the other party, such reference shall state that it is made pursuant to this clause. Where is that word, my lord, or phrase, my lord, in the letter my learned friend is referring to, my lord? Is this letter, my lord, which they are referring to, the letter of 3rd of February 2023, is made pursuant to the clause, my lord? That word, my lord, itself is missing, my lord. Although, my lord, on the last occasion, I made this submission, my lord, and I reiterate this submission, my lord, I'm not standing in the way of the reference being, of the dispute being referred to arbitration, my lord. If it is referred to arbitration, we are ready to proceed with the arbitration. I have no dispute. But, my lord, so far as the steps,
Substantial compliance. If you don't, I'll record that also, that in principle you are not opposing, but this step has not been taken by you. I'll record that submission.
well,
Order of the
instruction,
court.
order of the court.
Then I'll have to check up.
Well, my little understanding is that, my lord, they have not invoked, my lord. The 7.9.
You annexed a copy of the 9th of August order, Mr. Noshkar. 9th of August 2022. You have referred to that at page 66. Second last sentence, line. Check up for the.
You have read page
annexed several-
67, my lord.
Page 66, the second last line.
My lord.
The last sentence starts from, however, video later dated such and such, dated August 9, 2022. That is mentioned in the second last line of page 66. So there was a previous attempt also.
9th August. The reminder.
We're trying to fish out some mention of the clause. These are very technical issues.
My lord, at page 16, my lord, of the supplementary affidavit.
Yes, my lord, it is there, my lord. This letter is prior to termination, my lord. The only letter, my lord, which in my understanding that came post termination is the last letter my learned friend is referring to, my lord. Prior to that, my lord, everything is prior to termination, my lord. So as on date, my lord, the real issue is with regard to, my lord, the cancellation of the contract, my lord. That has raised, and that is the real dispute, whether the contract is is rightly terminated or not, my lord. That is the real dispute, my lord. That has to be adjudicated, my lord.
What is the value of the dispute? The claim?
My lord,
Claim is around 20 lakhs, my lord, roughly. Let them, I will just show it from the.
No, my lord, with regard to payments, my lord, we say that an amount of rupees 6,16,463 is lying due, apart from the bank guarantee that they have invoked, which is of 1,47,000. Roughly, my lord, 7,50,000.
Lords will kindly take paragraph 15 of their petition, my lord. Total billing was 6,46,000, my lord. Additional 12% GST was
Maybe a
added.
learned
my lord.
advocate of this court then.
I'm sorry.
Learned advocate of this court then. At all. A dispute has been raised between the parties pertaining to the purported termination of the contract between the parties. For next para, learned counsel appearing for the petitioner places reliance on clause 7.91.1 of the concerned agreement, comma, which contains the arbitration clause, comma, for the purpose of invoking such clause. It is argued that an invocation notice was duly sent under section 21 of the Arbitration and Conciliation Act 1996, comma, to which no proper response was received from the respondent. Next para, learned counsel for the respondent submits that it was contemplated in the arbitration clause itself that prior to any reference to arbitration, comma, the the party raising the dispute has to refer the same in writing to the engineer, E capital. Footstep, it is further contained in clause 7.91.1 that such reference shall state that it is made pursuant to the clause. Footstep, next para. Learned counsel appearing for the petitioner places reliance on a communication dated February 3, 2023, made by the petitioner to the
February 2, 3rd February, my lord. 3rd February, not 2nd February. Sorry.
To the general manager within bracket engineering of the SP Mukherjee port, comma, indicating that the said communication was in substantial compliance of such provision to refer the matter to the engineer. First up, it is submitted that for all practical purposes, comma, it was the general manager engineering who was the terminating authority as well as the person acting as engineer within the contemplation of the contract. First up, next para. Hence, comma, it is argued that there was sufficient compliance of clause 7.91.1 as regards prior reference to the engineer was concerned. First up, next para. Although the respondent is justified in contending that there was no specific reference to clause 7.91.1 of the contract in the communication dated February 3, 2023, comma, the same was addressed to the general manager within bracket engineering, bracket closed, comma, who had, comma, for all practical purposes, comma, acted as the engineer as contemplated in the said contract. Full stop. As per clause 7.1.2 within bracket small g of the agreement, comma, within double inverted E capital, engineer, inverted close, means the person appointed by the employer to act as the engineer for the purposes of the contract and named in the contract data, comma, or other person appointed from time to time by the employer and notified to the contractor under GCC clause number 7.1. Full stop. Next para. Since the said definition is fluid, F-L-U-I-D, fluid enough to cover the general manager, bracket closed, engineering, comma, who acted in terms of the said definition throughout the transactions between the parties, comma, such letter is deemed to be sufficient compliance of the clause in question, that is clause 7.91.1. Full stop. Insofar as non-mention of the specific clause is concerned, comma, the same cannot be an integral part of the agreement going to the root of the same, but is only an ancillary clause embellishing the arbitration clause otherwise envisaged in clause 7.91.1. Full stop. Next para. Hence, comma, for the purpose of invocation to arbitration, comma, sufficient compliance of clause 7.91.1 has been made by the petitioner prior to making the invocation. Full stop. Next para. Since the dispute between the parties falls within the purview of the arbitration clause and the dispute is otherwise arbitrable, comma, there cannot be any further impediment to appoint an arbitrator to resolve the dispute between the parties. Full stop. Accordingly, AP number 254 of 2023 is allowed, comma, thereby appointing Mr. Siddhartha Banerjee, an advocate of this court, as the sole arbitrator to resolve the dispute between the parties, subject to obtaining his consent stroke declaration under Section 12 of the Arbitration and Conciliation Act 1996.
No,
Grateful, Lord.
Yes. You don't know Mr. Siddhartha Banerjee?
I perhaps know him by his face.
Definitely you'll know.
Must be.
You know him. Anyway,
We'll
follow.
find out. Deeply obliged, my lord.
If you have any difficulty, just come and mention.
No, I
Yes, don't hesitate on that. Next matter.
Item number 10.
10. Yes.
May I please, your lordship?
Yes.
My lord, there was an agreement, my lord, for constructing and dismantling, my lord.
What about service on the respondent?
Must been served, affidavit of service.
I'll pass over on the first.
My lord.
Just keep it with you for the time being. Pass over in the first call.
Item number 11.
This is a content from your lordship's order.
Appearing for the first time.
No, your lordship, it has appeared on several occasions.
Who is appearing for the respondent?
Mr. T.M. Siddiqui, but the fact is that
Yes,
P.M.
come.
Siddiqui.
Yes.
Fact is that we have, he's already here. They have already got the appeal listed before the Chief Justice, but not sitting today. The lordship can take it up after vacation.
Very well. It is fairly submitted by learned counsel for the petitioner that the appeal taken out by the alleged contemner against the parent order has already appeared before the concerned division bench. For sub next para, in such view of the matter, comma, let the matter stand adjourned and shall next be listed in the monthly list of June 2023 for being taken up for hearing. Let the matter na kore, let the contempt application kore din Pintu.
This has happened after your lordship has passed the last order. That
Last order was a last chance.
There was not a last chance, my lord. An order was passed that I was not represented, my lord, inadvertently, my lord. And we are not taking, it was submitted that we are not taking any steps.
Then it will be heard in absence.
But subject to correction by my learned friend, my lord, there was an understanding between us because he has assured the learned honorable division bench that he will not proceed with the contempt application till the
It was in the
appeal
month of
is-
January.
and thereafter he
the matter
paid
was
for
not-
adjournment.
No, I never.
Yes, the order is there.
Never heard
Order is there.
thereafter. from
Order is
the-
there. I'm grateful, my lord.
Second call.
Second call, item number 4.
I appear on behalf of petitioner. The arbitration in connection with the railways, my lord.
Banerjee was agreeing. Now he's not there. Yes, Mr. Banerjee is there. Agreeing, Mr. Banerjee, I'll say that you sought to invoke, you sought to appoint one from your panel, but that is barred under section 12. So, what is the value of the dispute or the claim?
My lord, entire, my lord, cause of action subject to a lordship's kind sanction is in
Raipur,
because
why are you so shy in that? Take the point of territorial jurisdiction. Why not?
because
Take the point formally.
Lord,
Yes.
the entire, my lord, cause of action, my lord, in Raipur,
What is the cause of action?
because, my lord, the agreement was executed by and between the parties and the work is to be executed and that was being done by my learned friend is Raipur.
How do I invoke jurisdiction, Mr. Banerjee?
Baltikuri, Shurki Mill, Howrah, Amta Road is the place where we've got all the correspondence, including, my lord, the order. I have, my lord, the demands have been sent from my end for arbitration also for that purpose. Even prior to that, for the formation of cause of action, part of it surely arises here. And this is not that peripheral cause of action where, my lord, the crow flies. This is not that scenario.
At the outset, an objection as to territorial jurisdiction is taken by the respondent on the ground that the cause of action arose primarily in Raipur. Footstep. Next para, learned counsel for the petitioner, while controverting such contention, submits that several correspondence and other components of the cause of action arose within the state of West Bengal at Baltikuri in Howrah. Footstep. As such, comma, it is submitted that at least a part of the cause of action arose within the territorial jurisdiction of this court. Footstep. Next para. It transpires from the submission of parties that the respondent authorities sought to appoint a person from the panel of the respondent themselves as arbitrator, comma, which cannot be permitted in view of the provisions of section 12 of the Arbitration and Conciliation Act 1996 as the same stands till date. Footstep. Next para. Hence, comma, since an arbitrable dispute between the parties has arisen within the contemplation of the arbitration clause, comma, AP number 233 of 2023 is allowed, comma, thereby appointing value of the claim you said. What is the value?
12 crores.
12 crores. Thereby appointing, choose the name of a judge. 12 crore can be Supreme Court judge also, Justice Ashok Ganguly or Justice Indira Banerjee. These are the two available here.
Justice Ashok Ganguly.
Appointing Justice Ashok Kumar Ganguly, comma, a former judge of the Supreme Court of India, as the sole arbitrator to resolve the dispute between the parties, subject to obtaining his consent stroke declaration under Section 12 of the Arbitration and Conciliation Act 1986.
Obliged, Your Lordship.
For such reason, my lord, I did not take the
Point, right? No?
I'm great.
Obliged, Your Lordship.
Because of a contempt order, Mr. Banerjee, you cannot be precluded from all arguing matters in all cases.
Because, my
Because of
lord,
one contempt order passed in one matter.
I know, because, my lord, when, my lord, my client will not hear me, then, my lord, I have to.
Now your client can take the point of territorial jurisdiction, entitled under the law, without fear or favor.
I'm
Next.
grateful. Today also, my lord, another matter, contempt matter, I have also.
I'll take care of that in due course, Mr. Rest assured on that, without being influenced by this goodness. Yes. Call.
Passed over matter item number 8.
8.
I am the respondent for the respondent.
Who is appealing for the petitioner? I'll dismiss it for default, because should I record your submission? I'll record your submission, but not on that ground. I'll dismiss for default.
Yes.
In any event, I'll dismiss for default.
Yes, it's very easier for restoration for them. Otherwise, it will be a, I shouldn't stand in that way. It's easier
Learned
for
counsel, none appears for the petitioner when the matter is called on for hearing, full stop. Learned counsel for the respondent submits on instruction that in the said, in regard to the same dispute, comma, an arbitrator had been appointed previously and had passed an award.
on contest.
An award on contest, full stop. As such, comma, there cannot be any scope for seeking further appointment of arbitrator. Full stop. Next para, be that as it may, comma, since none appears for the petitioner, and this is the second such occasion, comma, AP 253 of 2023 is dismissed for default without any orders to cost.
Obliged.
Passed over matter item number 10.
Lord, may I please your lordship?
Yes, what is it?
My lord, there was an agreement dated 8th August
Actually,
2022.
Eastern Railway, they are not appearing. This is Eastern Railway or some
Yeah,
other company?
Eastern Railway Construction Department. My lord, it was an agreement for construction and dismantle. It has been served, my lord, in their office.
Yes, what is the matter?
Now, my lord,
Because I'm apprehending that tomorrow they'll file a recall application. They'll say it is heard
I
beyond
can
behind our
understand, my
back.
lord. Then, my lord, yes, my lord.
I think give another notice.
another
2 notices is sufficient. More than enough, I'll
Lordship
record
will
it.
keep it a week after vacation or on
Very well.
6th, my lord. 5th, the court is reopening. Lordship will keep it on 6th.
Very well. I'll keep
I
it
will
on
give
6th.
them a notice.
I think
my
that will be better.
lord. Yes,
because
yes,
these
I
are
can understand, my lord. They
government
will
concerns, and they'll come up indefinite, invariably they'll come up and they say
My
that.
lord, here what they have done, my lord, lordship knows standard contract.
Yes.
They have given us phone names, panel arbitrators to give a
Section
nominee.
12 comes in.
Section 12 comes in. Nominee arbitrator for the petitioner has to be appointed.
Should I keep it after the vacation or before the vacation? I can.
I think, my lord, before the
Very well.
vacation, even they will not come. Today is Monday. You can
Very well.
understand.
Despite service, none appears for the respondent. Full stop. An affidavit of service filed today be kept on record. Full stop. Next para. However, comma, the learned advocate on record for the petitioner is requested to serve another notice on the respondent indicating that the matter shall be taken up under the same heading on June 6, 2023.
I'm grateful, my lord. I'm grateful.
একটা line add করে দিন. It is made clear that in the event the respondent remains unrepresented on the next returnable date, comma, the orders may be passed ex parte in the absence of the respondent.
I'm extremely
Communicate
grateful.
the entire thing with the
Yes,
server
my lord.
copy.
I will communicate the server copy, my lord, with my covering letter.
Thank you.
Server copy to covering letter. I'm
11
grateful
হয়ে
to you,
গেছে?
lordship.
আচ্ছা। I'll take up the appellate side after coming back in 10 minutes.
না
একটু পিছিয়ে যাও।
না না হবে।
Mentioning now. Yes, mentioning.
Madam, may I have lordship sleep to mention one
বলো
matter
একটু
for
একটু
correction?
said mention তো কিছু বলতে হবে তো সবই তো আমি করে দিচ্ছি। Yes, please mention. Whatever slips, hand over.
Yes, correction.
This is content.
আচ্ছা ঠিক আছে। আচ্ছা
Appellate side, new motion, item 1.
Lordship, I
Sure.
appear
I
for
am
the
a-
respondent distribution company.
I'm appearing for the state of West Bengal, Lordship. On the last occasion, I filed the report of the district magistrate. Lordship directed the district magistrate to complete the hearing and file a report before your Lordship. Lordship, I have served the copy of the reports to all the parties. Upon notice to all the parties, a hearing was made, Lordship. And a joint inspection was also made. The report of the joint inspections are annexed at page 4 and 6, Lordship. Lordship, kindly see page 4 of the report, Lordship.
My lord, my instruction is connection has been given with the help of police help. Yes, that.
Lordship, page 4, Lordship. The inspection report is annexed. Upon considering the joint inspection report, an order has been passed by the district magistrate, which is annexed at page 11, Lordship. Lordship, may I indicate the relevant part of the said order, page 13, Lordship. The order sheet dated 4th May 2023, Lordship. Joint inspection report has
So
been
direction
placed.
was given to give connection to
Yes,
Shakti
Lordship. Yes,
that has
Lordship.
been given you. Sir.
Given yesterday.
You are for the petitioner.
I am for the petition.
Yes, Mr.
I am for
Bhattacharya.
the private respondent. Your lordship will kindly see the order passed by this court earlier. This is the old matter of 2018. By virtue of the order of the passed by my lord Justice Bhattacharya, as is her lordship then was. My lord, there is a hearing was held by the district magistrate on 18th of November 2018. There is no such mention to that extent. And the district magistrate was directed to pay the compensation to the private respondent because and that will be decided by the amicably. There is no whisper to the order with regard to that. Now your lordship kindly see the order passed by your order passed by the district magistrate. On second,
Let us see Justice Chatterjee's order first.
your lordship kindly see the
The
order
one you are relying on. Date. What is the date?
dated, my lord, 19th of June 2018.
Right.
My lord, Justice my lord Chatterjee, your lord, as the lordship, my lord, your lordship kindly see the order and the operative part.
There is no direction to give you compensation or whatever.
Well, not in this order. Pursuant to the direction, my lord, the district magistrate conducted a hearing on 28th of November 2018. And my lord, on that date, my lord, the district magistrate passed an order, my lord, to pay the compensation. My lord, I shall produce the document, my lord, with regard to my lord, the order of the district magistrate that is on 22nd of November 2018. In such cases, the petitioner will pay one-time compensation to the opposite party for using the portion of the
Have you got a copy of that?
My lord, I have the copy of the.
Read it out.
My lord, I am just my lord, in such my lord, this is a big order. In such case, the petitioner will pay.
No, in such case, we cannot start from there. What is the previous
And
sentence?
the case record is taken up today. The
Yes.
petitioner himself and the opposite party remain present along with their representative of the WBCL, BLR Muthurapur. Submission of the both parties were heard. The report of the WBCL and BLR Muthurapur 1 was considered. It appears from the both the parties occupied a single premises which has no partition deed in any way favor, in anyone's favor. There is an aged old mutual settlement between both the parties on the basis of which they are enjoying their proper respective portions. There is a common passage, the service connection of the opposite party have been drawn earlier. Now the petitioner intends to draw the electric connection through the same path. Opposite party has claimed that there is the injunction order of the Diamond Harbour Subdivisional Court against the change of any nature and character of that premises, but he is unable to produce any document in favor of this claim. As per the report of the WBC and BLO Mutra, there is no other way to draw the subject connection to the portion of the petitioner. While drawing the line through the existing plan, only a portion of the opposite party, semi-permanent construction, temporary rooftop set will be affected, and not this reason for the safety of the measure, the entire service connection will be drawn through the covered wire only. Considering all the aspects and the ground level situation, I hereby order that the opposite party cannot produce any order of the court or regarding the injunction which is applicable in this regard within 15 days from the date of receiving of the order. The WBC will give an order to draw the related connection in accordance with their existing plan. In such case, the petitioner will pay one-time compensation to the opposite party for using the premises or portion of the land which will be settled.
For
Portion of the land.
one-time compensation for?
Compensation to the opposite party for using their portion of the land and which will be settled amicably between them. These order were never mentioned in the subsequent order passed by in the report of the district magistrate. And now you'll also kindly
Order of the district magistrate.
no,
It was not finally decided, so it has been decided now.
But that was not disclosed in the report, my lord. And now you'll also kindly see the inspection was held on 2nd of May. And the hearing was, final hearing was held on 4th of May without behind our back, without coming. Initially, there is a hearing, they directed to conduct an inquiry. The inquiry was held on 2nd of May. Now,
What can be your objection? It's a common, I mean, it's an unpartitioned property. You are enjoying one, Mr. Bhattacharya. It's a joint property. You are enjoying one portion by amicable or mutual settlement. They're enjoying the other portion. So over a common passage, they're wanting electricity. What is the harm in that?
there is a partition.
But it's a question of paying compensation to, why should it be paid?
Because this line, overhead line, my lord, that is drawn over my premises.
It's over a common passage. You don't have any my premises. It's a common property.
According to them, this is a common passage of 3 feet. You also kindly see 3 feet common passage.
Where are you taking the connection through? Your connection has gone through.
You also
What?
kindly see the report, my lord. There is, my lord, in the report, my lord, the annex of sketch map.
Yes. You are Prashant Hallar.
My lord, Prashant Hallar.
It is going in between these things.
Well, this is according to them, this is the common passage, 3 feet common passage. There is an order of injunction passed by the civil court with regard
Common passage beside your kitchen.
well, this is the premises of Prashant Hallar and Sajol Hallar. You'll also kindly see, and they says that the 3 feet of common passage of Prashant Hallar and Santiranjan, that is not according to them. Just not beside the this is my lord, that portion, my lord.
Yes, 3 feet is a common passage of you and him.
According to them, my lord, I am my lord, objecting that portion. In respect of that portion, I am in beside the kitchen. I have no objection. But in respect of my lord, the in front.
What is the root of your connection? You are also enjoying connection.
My connection is not existing from the top, my lord. You will also kindly see that from that connection. And my lord, that is the common passage. It is not the common passage. I have a deed of settlement wherein specifically mentioned the my lord with regard to their property and my property. And even my lord, you'll also kindly.
There's a civil suit pending between you. Regarding common passage or the entire property.
My lord, including this portion, this landed property.
What is the relief claimed in that suit?
For suit for partition, my lord.
You have filed.
I have filed against them.
That will be decided whatever be the result of that.
But, my lord,
They
there
cannot
is
be
a-
deprived of
but,
electricity. They are admittedly.
Election of poll, my lord, you'll also kindly appreciate election of poll will change the nature and character. Subject to your lordship, my lord, approval. But with regard to my lord, there is a still injunction is subsisting, and my lord, in respect of that, my lord, I mentioned that, and I have produced the document to the district magistrate also. And in the final hearing, my lord, behind our back, my lord, the order was passed. On 22nd of May, the order of inspection was held, and 4th
Why
of
do you say behind your back no notice was given to you?
my lord, with regard to my lord, first hearing, the hearing was held, and it was decided inspection will be held. Inspection was held on 2nd of May. Now the final hearing was held on 4th of May, that is without serving any notice, without giving an opportunity of hearing.
Copy of the notice is annexed at page 3, Lordship.
The order sheet also reveals that, my lord.
You have not received this notice at page 3?
My lord, in terms of in response to the
Please come to the notice. page 3 of the report.
Yes, my lord, we have received the notice, we are appear. On 20th, my lord, on 27th of April, we are appear.
This is dated 19th of April 2023.
Directed me to appear on 27th of April,
Yes.
2023 at 4:30. We appeared. And
Right.
then it was decided inspection will be held on 2nd of May.
The date was fixed on that same date.
No, my lord,
Report to be submitted on May 4th.
yes, my lord, you'll also kindly see, my lord, the order dated 27th of April, my lord, is annexed at P4.
Yes, the last sentence of that says the inspection report is to be submitted on 4th May, which was the next date. That was sufficient notice of the next date.
Inspection report is to be submitted on 4th May.
Obviously, it's a date of hearing then also. It won't be given to the chamber or the residence of the district magistrate.
Well, inspection report is to be submitted on 4th of May.
No, this is sufficient, Mr. Bhattacharya.
On the 4th May, they have not taken this point that notice
We are
was not
appeared.
given.
We have not been appeared. You'll also kindly see the 4th May order. Kindly see the order of 4th May. There is no response that nobody has appeared. Not only me, the petition was not appeared. No, the WBC does not appear.
You are Sajol Haldar.
Yes, yes.
Sajol Haldar.
Sajol and Pusant. Pusant is my father and Sajol is my lord.
Respondent number 7 is present. Page 4. On 27th April.
27th we are appeared. But my lord, on the 4th of May, this is the final order. Where it was decided to give realty connection.
No further notice was necessary for each and every date notices.
No, nobody had appeared because on that date, the hearing, nobody had appeared. Not only me, my lord.
Lordship,
None was appeared.
kindly see page 5, Lordship. I find one attendance sheet is annexed. Dated 2nd May 2023. I find in serial number 9 the signature of Prashanto Haldar.
That is, we had to inspection on the spot, my lord.
Yes, he was present during the inspection. Page 5, Lordship, of my report, the report filed by them.
Inspection, my lord, we was present.
Serial 9, Prashanto Haldar.
No, Mr. Bhattacharya, this was sufficient. Your arguments were made on 27th.
27th we have made. My lord, you lost
You said that you had no objection against drawal of electric line through common passage, but you will not allow to erect PCC pole.
Yes.
That was your stand. That was made clear. That was considered. And after considering the report and the map, the district magistrate says that is not a violation of the.
My lord, our objection is with regard to erection of the PCC pole. With regard to not electric connection, my lord, we have no objection. My lord, it is not the case that he has not enjoying electricity. He has enjoying the electricity, but not this route.
Acha, where is the status quo order, Mr. Bhattacharya?
I have the status order of status quo, my lord.
Show me that. This is an information slip.
I have the order copy of the order also, my lord. Today,
Show me the order copy.
my lord, I have the order copy. Something my lord, was misplaced from me, my lord.
Well, can I keep this on record?
My lord.
This is not change of nature act. Electricity pole, no.
My lord, in respect of the same plot, my lord, 362 meter, my lord.
Even then.
But my lord, your lordship will kindly consider the earlier order of the district was not considered. And my lord, the second point, my lord, is 4th of May, the order was.
So your first point is compensation. That question was not considered. Lastly,
on 28, 22nd.
no notice of the last day's hearing, and the status quo has been violated. These are the 3 points. A report filed by the report filed on behalf of the district magistrate be kept on record. Full stop. It is evident from the said report that subsequent to the previous order of this court, a notice of hearing was given and the parties were heard on April 27, 2023. Full stop. On the said date, comma, an inspection was directed to be held in the presence of the parties, and the report was to be submitted on May 4, 2023. Full stop. Video order dated May 4, 2023, comma, the district magistrate, comma, South 24 Parganas ultimately held that the erection of a PCC pole in the common passage and another on the land in possession of the petitioner would not tantamount to violation of the subsisting status quo order passed in a civil suit between the parties. Full stop. Accordingly, the magistrate had directed the electricity connection to be given to the petitioner, comma, with police help if necessary. Full stop. Next para, learned counsel for the WBSCDCL submits that such connection has in the meantime been effected in favor of the petitioner. Full stop. Next para, learned counsel appearing for the private respondent contends that no further notice of hearing on May 4, 2023 was given to the private respondent from the end of the district magistrate. Full stop. Next para, that apart, comma, it is argued that the installation of a PCC pole for the electricity line being given to the petitioner amounts to violation of the status quo order subsisting in a civil suit between the parties. Full stop. Next para, it is further submitted that in a previous order, comma, the district magistrate had observed that due compensation is required to be paid to the private respondent, comma, which has not been complied with and or found place in the last order of the district magistrate dated May 4, 2023. Full stop. An information slip is handed over by learned counsel for the private respondent to support his contention as regards the subsistence of a status quo order. Full stop. Next para, heard learned counsel for the parties. Full stop. At the outset, comma, it may be noted that the district magistrate has duly complied with the direction of this court by giving opportunity and notice of hearing to the parties and concluding the hearing, as well as passing a final order on the same. Full stop. Next para, insofar as the information slip handed over by the private respondent is concerned, comma, the same records that the plaintiff and the principal defendants in title suit number 337 of 2018 are directed to maintain status quo in respect of nature and character of the suit property. Full stop. Next para, however, comma, the installation of a PCC pole, comma, for all practical purposes, comma, is merely to facilitate the supply of electricity connection to an occupant. Full stop. The installation of such pole by the distribution licensee cannot amount to a violation of the status quo order which is subsisting between the parties, comma, restraining the parties from changing the nature and character of the suit property in any manner. Full stop. Next para, inasmuch as the nature and character of the suit property is concerned, comma, the erection of a PCC pole for the limited purpose of giving electricity connection, comma, by the licensee, comma, is not in any manner, comma, a change or alteration in the nature and character of the property by any of the parties. Full stop. Next para, insofar as prior notice is concerned, comma, admittedly the hearing on April 27, 2023 was conducted upon giving prior notice to the parties. Full stop. In fact, comma, the present objector stroke respondent number 7, Swajal Haldar, SWAJAL, Swajal Haldar, was present with his advocate along with respondent number 6, Prashanto Haldar, comma, at the said hearing. Full stop. Next para, only upon hearing the parties and recording the objection of the respondents, comma, including that of erection of a PCC pole, comma, the district magistrate proceeded to direct an inspection to be held. For sub next para, the said inspection was also held, comma, admittedly, comma, in the presence of both sides, comma, which is also evident from the signatures of the private respondents in the inspection report. Full stop. Next para. Only upon such inspection and consideration of the arguments of the parties, comma, the magistrate accepted the said report and passed the final order on May 4, 2023 on the premise of such report and in full awareness of the arguments made by the parties, comma, directing electricity connection to be given to the petitioner. Full stop. It was rightly observed by the district magistrate that electricity is one of the fundamental rights for existence, comma, subject to compliance of other requirements, comma, the petitioner was entitled to get a right of electricity. Full stop. It was also observed correctly by the magistrate that the right to electricity would not be construed as recognizing any tenancy or other possessory right with regard to the subject property. Full stop. Next para. It is recorded, comma, even in the order dated April 27, 2023, that the private respondents present in the hearing stated that they had no objection against the drawal of electric line through common passage, but only were opposed to erection of the PCC pole, comma, which has been discussed above. Full stop. Next para. In such view of the matter, comma, there could not have been any further hindrance in the electricity connection being given to the petitioner. Full stop. Next para. Insofar as the question of compensation is concerned, comma, the order sought to be relied on by the private respondents was an ad interim order, and the finding regarding compensation was, comma, at best, comma, tentative, which merged in the final order dated May 4, 2023. Full stop. Next para. In any event, comma, the private respondents have not made any application for compensation at any point of time. Full stop. Hence, comma, the consideration of payable compensation to the private respondents is beyond the scope of the present inquiry. Full stop. Next para. That apart, comma, it is an admitted position that the property is a joint property and there was a mutual settlement between the parties, comma, pursuant to which they are enjoying their respective portions of the same. Full stop. Next para. The passage being common is also not disputed by the parties. Full stop. Insofar as the other objections are concerned, comma, the same has been dealt with correctly by the district magistrate as indicated above. Full stop. Thus, comma, there was no occasion for the distribution licensee to pay any separate compensation to the petitioner, comma, more so since the passage is common between the petitioner and the private respondent, and the private respondent cannot claim any special right over the same. Full stop. Although the private respondents have sought to argue that they have exclusive rights over the passage, comma, the same, comma, in any event, comma, is the subject matter of dispute before the civil court, where a partition suit is pending at the behest of the private respondent. Full stop. In such view of the matter, comma, WPA 2824 of 2018 is disposed of by directing the WBSCTCL to continue giving electricity connection to the petitioner over the newly installed electricity connection given to the petitioner at the disputed property, comma, subject to payment of regular electricity charges and compliance of other law by the petitioner. Full stop. However, comma, as correctly observed by the district magistrate, comma, it is reiterated that the electricity connection shall not, comma, per se, comma, operate to create any special right or equity in favor of the petitioner or the petitioner and or prejudice the rights of the petitioner and the private respondents in the pending civil suit between the said parties. Full stop, no otherwise to cause urgency.
May I only pray, let the matter where be drawn with safety measure, my lord. This is not, my lord.
Safety measure is there, always have to.
Not over my premises, my lord. This is.
Cannot be on your premises. It's a common passage.
No, the premises is not really effective, my lord. The roof of the.
I'm grateful, Lordship.
Thank
you.
And item number 2, my lord.
Item 2.
Before my learned senior friend starts, my lord, I have already intimated it. And Mr. Kaur is leading me in this matter, my
The
lord.
last occasion also you played for time?
Yes, my lord.
No, not on every occasion.
My lord, kindly take it up after vacation, my lord.
Why?
My lord, there is something in this matter, my lord. He has requested, if your lordship may kindly take
Depends
it up.
on Mr. Ghosh again.
No, I have intimated, he has agreed.
Not on the reopening day.
Oh,
My lord, may I make one submission, lordship? My lord, similar deed petition, my lord. Kindly heart together, my lord. Today we have been filed, my lord.
Hand over the number, please. Similar means the parties are same.
No, different party, but
All the writ petitions are similar, electricity matters.
kindly heart together, lordship.
No.
Only, my lord, this matter is related with the 33 kV and my is, my lord, 11 kV. Those are same.
Different property, different parties.
Different properties.
No, several matters are similar.
Very good, lordship, as your lordship.
On the prayer of the WBSCTCL, the matter is being adjourned for the second time and shall next be listed on June 12th, 2023, second week. June 12th, 2023.
Grateful.
This much.
I'm grateful, my lord.
Thank you.
A deep deference.
Item 3 and 4.
Your lordship, this is my application. I am for the petitioner.
Yes.
Previous occasion, my lord, the report was handed over by the CSC authorities. Private respondent.
CSC.
Report has been handed over.
Yes, my lord.
Well, I have
You handed over on the.
and circulated also. Hard
Achha.
copy. So 1-page
Oh,
report.
yes, got it. What is the dispute? Your dispute?
My lord,
praying for new electricity connection. The previous rate was also filed, but for granting connection to a particular property number 16/1.
That was erroneous.
That was it. According to my learned friend,
Yes.
Mr. Sanwarwala, it is not the premises where she is actually residing, it's his client's premises. Thereafter, this writ petition has filed after a couple of years. Previous one was
2020, my lord.
2020, this
During
is
the tendency-
23.
Both of you cannot argue together. When I asked you, did you keep mum? Yes, let me suppose submission.
My lord, this time they have
Yes.
changed the prayer is the same for new electricity connection. Premises number has been changed. So when there is when it was taken up on the first day, that is on 8th of May,
yes,
Lordship had been pleased to pass an order to inspect and file a report. Since there was a confusion, Mr. Sanwala said, I don't have any objection if it is given from any other premises, but I have objection if it is given extended from my premises.
His premises is number?
His premises 16/1.
But you have said that it is a part
Lord,
of 16/1.
there is what I find from the report that there is little confusion about the exact premises number. If your lordship is pleased to come, the report is very short. Lordship may be pleased to look into. 20 is a large commercial residential complex with boundary. The premises were from the petitioner is presently requesting. Then at present application is an occupier at a premises behind the mentioned complex, which she claims that this is also 20 round tank length. In this area, it's difficult for us to go into much details. We don't have any objection.
No, you don't. Yes, then
essential
why
service.
shouldn't it be referred to the district magistrate?
At present, the petitioner is getting supply from the neighbor.
No, you have to specify, because if they say, because they have a specific objection regarding 16/1. Now, you are residing as per the licensee also, it's a large commercial premises, and you are residing, your premises it is behind, just behind the complex.
My lord, may I hand over a map? Look, so far my instructions are concerned, my lord.
Take the microphone, please.
My lord,
What is your instruction first?
My lord, I am residing at 20 Round Tank Lane. When I previously when I applied for an electricity connection, my lord, the contractor had advised me to make it the application from 16/1 because it would be also feasible for the licensee distribution company to draw that electricity connection. And since several other meters are there.
Have you annexed anything to show that you have a right on 20?
Yes, my lord, I have all my address proofs, my lord, from there.
That are regarding 20.
Yes, my lord. Then,
Which
my lord, at
page?
page 23 also, my lord.
23.
The a certificate has been issued by the.
This is the Aadhaar card and all these are also.
Yes,
there.
my lord.
Very well. Yes, let me hear Mr. Sanawala on his. Yes, Mr. Sanawala.
Can you see the map?
Yes, map.
This dark portion, this is 16/1 round tank lane. And thereafter, your lordship will find 12 feet wide common passage. And thereafter, another huge property. This is the property which belonged to Hooghly Flour Mills. It has been now be converted into several structures. Now, before filing that report, my lord, I hand over your lordship another letter issued by CSC. Lordship will not ask me how I got that letter, but
I know the answer. I won't ask. Yes. Yes.
The CSC on that very day when the report was prepared, writing to the petitioner reference to your application, our authorized personnel were deputed at the above location for inspection, but we could not be able to carry out the inspection at the site since the address you have given through Annexure A found incorrect. Now, my lord, kindly come to your lordship's order, my lord, the last order which your lordship passed. In the earlier writ petition and in the present writ petition, their case is that they reside at 20 Round Tank Lane.
No, earlier writ petition. Oh,
The
yes.
difference is in the earlier writ petition, they wanted the
16
supply
by 1.
from 16/1.
Right.
And in the subsequent writ petition, they wanted supply from 20. This is the difference. Your lordship's order, my lord, was that there are certain on page 2. But the first your lordship recorded and there was direction. However, there are certain other issues involved in the present writ petition, as such the CSC Limited seeks to have an inspection at 20 Round Tank Lane to ascertain the feasibility of giving such connection and the modality of giving such connection. Hence, the CSC shall hold an inspection at premises number 20 Round Tank Lane. This was your lordship's direction. Now your lordship will see the CSC's report which they filed on the last date.
Paragraph 4 of the report. Paragraph 4 of the report.
Basically, you are not sure as to whether she's living in 20 itself or not. So you are not sure of that, because during such inspection, petitioner apprised us that her occupied portion belongs to 20, but local inquiry revealed that same is part of 16, and you are not specialized to hold that inspection. How can you?
No, but my lord, there
And
is
you've also
one point
stated that, yes,
I would, my lord,
entire thing is she has claimed.
no, my lord, I'm not on that. There is the last sentence, paragraph 4. There is underground service exists on the right hand side of the main entrance with connected meter number such and such, such and such. From our metering database shows that the address where the meters are installed is 16/1 Round Tank.
That is the gate, my lord.
My lord, I read the report, my lord, and your lordship will compare.
No, I'll come to you, Mr. No, Mr. Bose, one thing. So it is seen from your report that the connections have already been given to 16/1. Yes. They are in 16/1. That is probably not disputed for the time being. Now, the disputed question is whether they are actually residing in 20 or they are claiming to reside in 20, but actually wanting the connection in 16/1.
Well, if it is 20, we can provide separate.
No, this at present, the applicant is an occupier at a premise behind the mentioned complex. Does that fall within 16/1?
That's difficult for us.
My lord, what is behind?
Yes, I don't understand.
I handed over your lordship a map. Kindly see the size of the property. One side it is 16/1, another side is 20.
No, that's
separated by a 12-feet wide common passage. And CSC writes behind.
Outside that.
Who should decide such questions, Mr. Bose? Read court cannot. Which is the authority? District magistrate. Under which provision? I don't.
But the first point is, my lord, they could not.
No, they are in occupation of some premises. They are required to get electricity.
My lord, I have been residing there since last.
So where they are residing, that has to be ascertained first.
May I come back day after?
Why? In the meantime, what will you do?
Let me have a
This
word
behind.
with this district engineer. If I could have a word with him. Some odd days they're.
If it is not on 16/1, then wherever they are residing, I'll direct you to give connection without creating any equity in their favor. If it's in 16/1, then it's difficult because they are claiming right.
That distinction we probably.
Yes,
But they could not enter into premises number 20 round tank line. That is the letter, my lord, written by them.
So if she's not residing in 16/1, then you cannot have any objection.
That they must come clean where actually they are residing.
No, they are not.
But I have shown you
They
lot.
are not want, Mr. Sharma. There are two things here.
In my lord.
As insofar as section 43 is concerned, they have to prima facie show they are in settled. Now here there are two things in their favor. One is that they have applied now in respect of 20 only, not 16/1. And on the other score, they have produced other cards, although these are on unilateral statements made. Even then, they have prima facie proof they have. Those say they are residing at 20 such and such. Now, if that be so, on the basis of the other card and those possession proofs, why can't it be given to them at 20?
I have no objection, but they could not take the CSC personnel to their residence in 20. That is what the CSC is saying.
How do they say that? Read me that portion.
Yes, I was reading, my lord.
Yes, please.
20 round tank lane is a large commercial cum residence complex with boundary. As present, the applicant is an occupier at a premises behind the mentioned complex, which she claims. That is, this is also 20 round tank lane. At present, the petitioner is getting supply from neighbor. Which neighbor, my lord? The neighbor at 20 round tank lane or neighbor at any other premises. Because if the neighbor is supplying electricity, that neighbor must have a bill which must have mentioned the address of the property. The plot where petitioner presently living is approximately 3 bighas. Now that the map I have given you, the size of the plot, which is a part of the land belongs to Howrah flour mill. Now this is, my lord, the HON'BLE flour mills. Wrong, it is wrong, wrongly mentioned Howrah flour mill. There is no such entity named Howrah flour mill. This HON'BLE flour mill was the owner of 20 round tank. Now it has been converted into complexes. And one more information I can share with your lordship. This consumer forum, my lord, is situated in this 20 round tank. Howrah Consumer Forum. At the front side, there are 2 numbers of very old buildings, and inside the one of such buildings, the petitioner is in occupation. There is an underground service exists on the right-hand side of the main entrance with common meter number so and so. From our metering database, it is showing that the address where the meters are installed is 16/1 Round Tank Lane, Howrah 711. Which premises they are referring to? If they are referring to HON'BLE flour mills, then it is 20 round tank lane. And if it is 20 round tank lane, my lord, then the address cannot be 16/1 round tank. During such inspection, the petitioner apprised that the occupied portion belongs to 20 round tank lane. But
In what
local,
capacity you are residing there?
My lord, the husband of the petitioner was an employee under the Hooghly Flour Mills Limited, my lord.
Under the flour mills?
Yes, my lord.
I'll give them connection at 20.
My lord, we are residing there since 50 to 60 years, my
Let
lord.
Hooghly flour mill come out. Or the consumer from here.
yes, in 20, your lordship. I have no
20,
objection on
Maybe please to give me time. Let me have a word. With personally, I have.
No, they have produced other cards regarding
Previously,
20.
my lord, when one
Wherever they're residing, give them connection, sir.
Lord,
Wherever they
let
reside.
me, since it is admittedly there.
my lord will kindly come at page 26, my lord.
During hot summer days, my lord. So
Yes, exactly. They cannot go on. Her husband was a labor.
Let me have a word with the my lord.
My lord will kindly come at page 20.
Her husband has expired. He was the water of the
long back.
She's
your-
residing in the premises. Probably Mr. Bose unlawfully. So let a connection be given. Unlawful occupier is entitled.
Kindly provide me a case time, my lord. Let me
Why?
My lord, only one thing, my lord.
About this 20 and thing. If
You have said what you had to.
No,
You
no,
have
I
said
have
you cannot do it.
I can't do it from 20.
No, you have said that you cannot ascertain the premises. At present, the applicant is an occupier at a premise. You have held your inspection elaborately. What else will you submit? Your engineer cannot improve the matter.
No, not improvement. My lord, my instruction is from 20s cannot be given. That's why I'm.
My lord, the first letter I have handed over your lordship.
Mr. Bose, they
so
were in
they could
occupation
not
of something
enter.
at a premise. You have stated at present the applicant is an occupier at a premise behind the mentioned complex. Give it there. Let the address be shown as 20.
Whether this can be extended from the complex also, that I need.
From where you will extend it, that's your headache.
Or a new service connection.
Whatever you hold an inspection for that purpose, I'll direct you to. But I'll crystallize their rights on getting electricity connection there, wherever they reside.
I am not standing anyway in the on it. I'm not going to standing.
My lord,
anyway.
ask the petition.
Interfering with their getting connection. But only thing, my lord, let me have a. It is a technical nature. Let me have a word with my engineer. That's all.
Further inspection won't help.
No, not inspection.
What will your engineer do?
My lord, I need to understand if there is a little gray area for me.
It's a very gray area. That much I have understood. You will understand the same thing again if your engineer says something to you. Suppose you cannot improve that situation. Her position is very gray. So let it be gray.
No,
Give her
no.
electricity connection.
The only thing the
Let the
petitioner.
gray people
My
also
lord,
have electricity.
my lord, the petitioner should come clean before your lordship, where exactly she is residing.
My lord, as per
Where the problem is,
as
my
per
lord,
records,
the
my lord,
Maybe please to take it up at 2. I have just been instructed.
2.
Let me have a word over the telephone.
Absolutely.
May I
Thank
come?
you very much for that.
May I?
And please thank your officer for the new regulations handed over to me. Yes.
If you oblige, my lord.
Please come back at 2.
Yes.
Already, Mr. Bose, the mill is closed. She's without any job, without any husband, without any income. So at least let her have electricity in some manner or the other.
he's also suffering, my lord.
If
He's an old aged lady, my lord. Previously,
a new service, then it will be an.
Let some illegality be done for equity.
No. I'm not on that. If
Yes.
it is has to provide with a new service connection, then it will be costlier. I'm trying to have that whether it can be
So
connected.
for that, I'll permit you to have an inspection. If you get instructions at 2, then Mr. Bose, the problem is solved.
Well, I'm coming back.
Very well. Thank you so much. Next.
Item 5.
I am for the petition, Lordship. Lordship, on the last occasion, the CSC authority has filed a report, Lordship. I am praying for filing exception to the report, Lordship.
What
Sometime.
will the exception do? I'll refer it to the whichever authority you say. Because during inspection, they say not suitable, technical suitable space.
Lordship, kindly then.
Who has it to be? The GRO?
GRO, Lordship.
Mr. Mukherjee, the GRO then. These are dispute beyond the, district magistrate, no question of district magistrate.
Lordship, GRO.
Learned counsel appearing for the petitioner seeks to file an exception to the report filed by the CSC Limited. First up, it is seen from the inspection report that, as per the CSC Limited, no technically suitable space was found for installing a new service inside the showroom of the petitioner. First up, next para, the CSC has further taken a stand that, for safety reason, it doesn't provide service inside the shop in case of fire loss of property and personnel. Full stop, next para. In view of such specific stand having been taken, comma, even if the petitioner refutes such report by way of a further rejoinder, comma, the situation will not improve insofar as the limited scope of the disposal of the present writ petition is concerned. Full stop, the writ court is handicapped, comma, in the absence of any provision or scope of taking evidence and deciding the issue on merits, comma, despite the contention raised by the petitioner with regard to the stand of the CSC Limited. Full stop, under the existing regulations, comma, the grievance redressal officer concerned is the competent authority to decide such disputes. Full stop, accordingly, WPA 10003 of 2023 is disposed of by granting liberty to the petitioner to approach the concerned grievance redressal officer to resolve the dispute arising between the parties. Full stop, next para, if such an approach is made, the GRO shall decide the dispute in accordance with law upon giving opportunity of hearing to all concerned as expeditiously as possible, comma, preferably within a fortnight, within 8 weeks from the date of such reference being made to the grievance redressal officer. Full stop, adequate opportunity of hearing shall be given by the GRO, comma, if so approached, comma, to both the parties. Full stop, no orders to cause certain settlement.
Grateful.
Item 6.
Well, and for the petitioner in the last question.
Yes.
But I'm for the respondent of 6.
Right. Mr. Basu, you are for the WBSC. Yes. Yes.
Well,
Yes, Mr. Mondal, what is that? Private respondent has been served, your appeal. Yes. What is the matter?
The matter
New
is,
connection.
correction, shifting of PCC pool. Well, what happened, my lord? I am beseeching your lordship attention, page 70. Page, my lord, page 70. Earlier order of this honorable court
In their favor.
in their favor. And my lord, what happened? The order was that operative portion 18, page 18. For these agents, I dispose of the petition ordering as follows. The company shall decide the petitioner's application for supply within 4 weeks from the date of communication of this order, after making inquiry, recording proceedings and hearing parties. The company shall give a reasoned decision that shall be communicated to all at once. If it is found that supply can be given without using any disputed property, and particularly any part of the private respondent's property, then supply shall be effected without any delay. No,
You are the private
I
respondent.
am the customer. My upon my property, my lord, the service line has been given. For that matter, I am unable to use my property.
Yes, what do you say?
It has been passed through common passage.
No, my lord, no comment.
Is any civil suit pending between you?
My lord, our title suit is pending, my lord.
My lord, no. My lord, after
I'll hear you. Yes.
after getting notice from this honorable court, they have filed an application for intimate suit. And
About that
I have
property.
got the copy of it.
So any order has been passed there?
Nothing.
In criminal court, my lord, SDJM has passed an order to effect that order. My lord, may I hand over? I don't know, it is.
Waiter, take out a negative photograph of this and hand over to me. Take out a negative photograph. The negative will be easier to read. Or you can read out for me also.
Seen the petition filed by the Bhubaneswar Panda.
Read the ordering portion, please, Mr. Yes.
The station, last paragraph, my lord, ultimate, the station manager, Mukundapur CGC, is directed to comply the order of the Honorable High Court, Calcutta, in this regard, and provide the electric connection with the help of the police at the
That is pursuant to
dwelling
Justice Biswas.
house of the petitioner at the early date and submit a signed report to the petitioner.
That does not add anything to the issue basically, because it is in pursuance of the order of the court. But the question is whether you have violated that order.
Well, the sketch map provided, it is also here. Well, this is the blue line.
We cannot decipher that.
It has been passed through that common passage.
Very well. I'll record your submission. It's a common passage, your submission. But this will be decided in the suit, sir. Before the suit is heard out, I mean, they have a right to get electricity as an occupier. The passage regarding the passage, you are right on that. You may have a dispute, but in this suit, it will be decided by the civil court. This is in any event as private dispute between you, whether it's a common passage or your private property.
My lord, there is no common passage. As per instruction, my lord, there is no
That is your instruction. Their instruction is there is a common passage, and they also say so.
Had it been so, they could not have filed, my lord, the suit for easement right. And that is also filed in the month of March.
So,
even.
a common passage may mean right of user also. Common passage, it's a passage. By definition, a passage is a property over which people pass. And common means both of you have right. Now, whether it's common or not, that will be decided in the suit. But even if it's your property exclusively, if you have title over the property, if it's the only passage, they have a right of easement over that. Although Easement Act is not applicable in West Bengal, but the principles apply, you know that. So they cannot live without electricity. Whether it's a common passage or not, that will be decided by the court, civil court. It's pending there.
My lord, that is true, my lord. The civil code is there. They have filed the easement suit in the month of March 2000.
After, yes, that I can. Suppose if they did not file the suit, then also I might have directed that the parties to approach a civil court for your canvassing out your civil disputes. So in any event, they have done that already. So you can't say.
My lord, my humble submission is violating this honorable court's order.
That violation cannot be ascertained here because of the reason we don't know whether it's a common passage or not unless there is a verdict by the civil court. That is a difficulty. Suppose ultimately the civil court holds it's a common passage. They have a right of easement over that. Then we cannot say there is a violation.
That time, my lord, that might be, but today, but at the present moment, nothing is there.
And my lord,
I'll make it subject to the result of the suit.
The magistrate has also directed BLRO to inquire into the matter and submit report.
That was given
in the order.
That was submitted.
No, it is a recent order, my lord. This is March. I think I don't know whether
You
it
were a
has
party
been
there before the BLA.
Yes, yes, he against him. It has been filed against him. Bhuvaneshwar Panda versus Kanailal Naik.
Learned counsel for the petitioner contends that VDA order dated September 5, 2011 passed in WP number 13606 within bracket W of 2011, comma, the present private respondent had obtained an order from a coordinate bench of this court where it was recorded by the court that the distribution company shall decide the application for supply of the petitioner therein within bracket present private respondent bracket closed, and after making inquiry, comma, recording proceedings and hearing parties, comma, the company shall give a reasoned decision that shall be communicated to all at once. Full stop. If it was found that supply could be given without using any disputed property, and particularly any part of the private respondent apostrophe S property, comma, then supply shall be effected without any delay. Full stop. Next para, it is submitted that in violation of the said order of the coordinate bench, comma, supply has been given subsequently to the present private respondent over the property of the petitioner. Full stop. Next para, learned counsel for the private respondent contends that subsequently a suit claiming easement rights of the petitioner of the private respondent has been initiated, which is now pending. Full stop. Learned counsel for the WBSCDCL submits that in the meantime, comma, a proceeding has been initiated before the concerned district magistrate where an order was passed directing the BLLRO to submit a report. Full stop. Next para, in the meantime, comma, electricity connection has been directed to be given to the present private respondent. Connection has been given already. Full stop. Pursuant thereto, comma, connection has been given to the private respondent. Full stop. Next para. It is clear from the order of the coordinate bench dated September 5, 2011 that the said direction stipulated that if it was found that supply can be given without using any disputed property, and particularly any part of the property of the present petitioner, comma, then supply shall be effected without any delay. Full stop. Next para.
Respondent, present petitioner.
Any কি বললাম? Any part of the particularly
Present petitioner.
that I've stated.
Yes, sir, present petitioner.
Then supply shall be effected without any delay. Full stop. Next para. However, comma, there is a still hyphen subsisting dispute as to whether the supply has been given over the exclusive property of the petitioner or whether the property is a common passage, comma, which is the subject matter of dispute in the civil suit pending between the parties. Full stop. That apart, comma, although the judgment of the coordinate bench contemplated a situation where supply can be given without using any disputed property or any part of the present petitioner's property, comma, if it was not so found, comma, or if it was found impossible to give supply over without using any disputed property or the present petitioner's property, comma, the solution has not been provided in the said order. Full stop. Hence, comma, at this juncture, comma, it cannot be said conclusively that the coordinate bench restrained the supply, the distribution licensee to give connection to the present private respondent altogether if it was found that supply could not be given without any disputed property or a part of the private respondent's property. Full stop. Next para. Particularly, comma, since a proceeding is pending before the concerned district magistrate between the parties with regard to the same issue, where already a direction for filing of report by the concerned BLLRO has been given, comma, it would be premature for the writ court to interdict the supply of electricity given to the present private respondent within the limited scope of the writ petition. Full stop. Hence, comma, WPA 10081 of 2023 is disposed of by granting liberty to the petitioner as well as the private respondent to canvass their respective disputes with regard to the property through which the connection has been given to the present private respondent before the court of the district magistrate, comma, where the matter is now sub judice. Full stop. Next para. Inasmuch as the civil rights of the parties are concerned, comma, the same shall be subject to the outcome of the civil suit pending between the parties. Full stop. It is made clear that nothing in this order shall preclude the magistrate and or the civil court from passing appropriate orders in accordance with the decision arrived at by the said authorities. Full stop. The electricity connection to the present private respondents shall not per se confer any special right or equity in favor of the private respondent, which the private respondent otherwise does not have in law or equity. No rest to cause urgency.
Instead of my lord, district magistrate, it is before the subdivisional executive magistrate.
Subdivisional
Executive magistrate.
Acha, I'm
It is
sorry.
144%.
District যেখানে যেখানে বলছি subdivisional executive. Thank you very much.
And the proper authority is Mukundapur.
Mukundapur. The concerned station.
Election.
WBSCDCL is very general. Whoever is in the meantime, if the zone is changed, then you will be in difficulty again a modification of my.
Item 7.
My lord, item 7, I am for the petitioner. My lord, initially.
What is the criminal element?
No criminal element, my lord. In fact, I am perhaps a little in my lord, uncharted waters.
No, not at all.
My
What
lord,
is in uncharted waters?
My lord,
11th of August 2018, my Lord Justice Somapti Chatterjee passed an order at page 27, my Lord, remanding the matter back. Thereafter, my Lord, a final assessment was passed.
Back to which authority?
My Lord, WBSCDC.
Acha, acha.
My Lord,
126. Section
no,
1.
against final assessment I have come, my Lord.
That
Yes,
is under-
126.
Yes.
My Lord, the final assessment is at page 29. There, my Lord, your Lordship will recollect at page 33. The final assessment was SL before your Lordship, principally on the ground of violation of natural justice. Now, my Lord, at page 37 is the operative part of your Lordship's order. My Lord, your Lordship's order is of 2nd of March 2023. Starts at 33, relevant part at 37. My Lord, at 37, my Lord, the second paragraph, your Lordship, my Lord, has said that if I have a grievance against the final assessment, I'll be at liberty to take out an appeal in terms of 127. Now, my Lord, your Lordship will kindly come to page 106 and 107. My Lord, your Lordship passed the order, my Lord, on 2nd of March. My Lord, on 31st of March, I went to, my Lord, deposit that pre-deposit amount of 50%. My Lord, the final assessment was about 1,18,794. My Lord, the 50% comes to 59,397. My Lord, initially that was not being deposited, not being allowed to be deposited at page 106. After, my Lord, we made a written representation, my Lord. Then, my Lord, on the same day at page 107, the amount was received. Now, my Lord, once we paid the amount, my Lord, we went to Krishnanagar, my Lord, where, my Lord, the appellate authority is situated. My Lord, the appellate authority is, my Lord, the respondent number 5. Now, my Lord, the appellate authority straight away, my Lord, I have recorded a GD to that effect at page 108. Twice I went on that day saying that I have deposited the 50%. The High Court has given me liberty to apply for under appeal in terms of section 127. My Lord, orally that he had said it, if you have gone to High Court, don't show me High Court, you do whatever you have to do.
So they're not accepting.
They are
the
not
appeal.
accepting, not even giving me a number of the appeal. I've even annexed my memo of appeal with this.
So, like, what do you say to
That's all, my Lord. That's
My
my
Lord,
prayer.
I am representing Lordship ACDCL. Up to the my Lord assessment officer who has received my Lord has complied my Lord's order because they approach for depositing my Lord.
I'll dispose of the writ petition. The appellate authority is a party here.
Yes, my Lord. Respondent number 5.
By TCL. TCL, my Lord, they are the appellate authority. So, my Lord, why they
TCL, you have served properly on them.
My Lord, I have served the superintending engineer, my Lord, Krishnanagar.
Respondent number 5, Lord.
Yes, service.
Yes, yes.
Despite service, none appears for the respondent number 5, comma, who is the primary appellate authority concerned in the present case. First up, learned counsel for the petitioner places reliance on an order dated March 2, 2023, passed by this court in WPA 4434 of 2023, wherein liberty was given to the present petitioner to challenge a final order of assessment in an appeal under section 127 of the Electricity Act 2003, subject to compliance of due process of law. First of next para, it is contended that although the petitioner, comma, pursuant to the said order, comma, tendered the appropriate pre-appeal deposit required to be made, comma, the same was initially refused. First up thereafter, comma, upon a written complaint, comma, the same was accepted. First up, however, comma, the appeal of the petitioner is not being registered formally by the appellate authority, that is respondent number 5, comma, nor is any number of the said appeal being provided to the petitioner. First up, next para, in the absence of the private of the respondent number 5, despite service, comma, there is no other option but to decide the writ petition in the absence of the said respondent. First up, WPA 10377 of 2023 is allowed, comma, thereby directing the respondent number 5 to immediately register the appeal preferred by the petitioner against the final order of assessment and deliver and issue a number of the said appeal upon generating the same. Full stop, such number shall be communicated along with the next date of hearing to the petitioner by the respondent number 5 within a fortnight from the date of communication of this order to the said authority. Full stop, the petitioner shall communicate a server copy of this order along with a covering letter of the learned advocate for the petitioner to the respond number 5 for the purpose of compliance of this direction.
Milord, one additional relief, if your lordship will kindly consider, Milord. Your lordship will also direct the respondent number 5, Milord, to consider my application for condonation of delay. Because of this, there is a delay, Milord. Otherwise, he'll dismiss my appeal on the ground of limitation.
Next para, it is made clear that along with the said appeal, comma, the appellate authority shall also consider and decide in accordance with law the application for condonation of delay filed by the petitioner in preferring the said appeal. Full stop. Next para, it is made clear that adequate opportunity of hearing shall be given to the petitioner on the application for condonation of delay and, comma, if allowed, comma, thereafter on the appeal itself.
One indulgence, lordship, to pay the registration charges, registration fee they have not paid. If lordship kindly allow.
Registration fee, I guess, is a minuscule.
After the hearing is over,
Yes.
Mr. Nayak, I won't entertain any arguments.
I'm grateful.
Sorry.
I'm grateful.
Grateful, lordship.
October matter
Yes.
fixed at 2 p.m. Item 3 and 4.
And for the
Okay.
same, my lord, item 3.
Right.
You. But I have taken instructions. Your lordship, can you take the trouble?
Mr. Bose, please use the microphone. Yes, microphone.
Oh,
Yes.
yes, now it is there.
Yes.
If your lordships kindly take the trouble of coming to the report once again, my lord.
Right. Report.
My lord, there is a paragraph 4. In the first, second, third line, underground service exists. 2 meters number there, metering database install 16/1 tank, round tank length. We can provide with the police help if necessary, a new meters, supply in the same meter board position.
That's a different premises.
But my lord, these she is already enjoying, as we have stated, she is already enjoying.
So that is must be an illegal supply.
No. If it is fixed there, she is already enjoying.
She may not be getting from 16/1. She's. You have said that at present the petition is getting supply from neighbor. Neighbor may be one.
Neighbor is my lord. I'm submitting my lord that out of these two, one she is getting. So we can provide.
These two means 20 and 16/1. Oh, out of these 2 meters.
These 2 meters.
Achha.
We can fix in the same meter board position 1 meter. That is one way. And the other way is in 20/1, that complex is there.
New service connection.
In 20, that building is there. We can provide there. Then she will have to draw the line from that premises up to her.
Suppose then you check the feasibility of both of either of the two. I mean, or check the feasibility of both. I'll take it up after the vacation, file a report on that. I'll specify it that this offer has been given by you, either from 16/1, the meter board position, or 20.
Where these 2 meters exist. Whatever the premises number.
But that they have some objection regarding that. Mr. Sarwal has some.
My lord, let me, with your lordship's leave, my lord, can I have a word with him?
Why not? Absolutely. Please.
Just.
We want to resolve the issue.
Yes.
If you can, definitely.
গরমের মধ্যে কষ্ট পাচ্ছে এই দুটো মিটার 16/1 বলছে এগুলো কি তোমার ঘরে?
আমি জানি না, আমি তো রিপোর্টটা পেয়েছি।
ঠিক আছে, তোমার ছেলেকে আগে দিয়েছিলাম, তুমি জিজ্ঞেস করো এই দুটো মিটার তোমার এই ঠিকানা।
ওদের পিরিয়ডটা হচ্ছে 20 তে থাকে।
ফোনে ও এই দুটোর একটা থেকে পাচ্ছে, ও বলছে এখানে যদি বসিয়ে দাও আর একটা মিটার, তাহলে তো অসুবিধা হবে।
সেটা ব্যাপার,
এইবারে তোমার অবজেকশনটা হচ্ছে যে এই দুটো যেখানে আছে টার্গেট অ্যাবাউট দিস নাম্বার,
ও যদি 16/1 এর অ্যাপ্লাই করে, 16/1 এ চায়, আমি তো ডিফারেন্ট ব্যাপার, আই হ্যাভ আ ডিফারেন্ট কথা। ও বলছে আমি 20 তে থাকি, 20 তে মিটার দাও।
এই মিটার
তারপরে
কোথায় আছে তুমি জিজ্ঞেস করো।
না, ও কোথা থেকে পাচ্ছে সেটা আগে জানতে হবে।
এই দুটোর একটা থেকে,
মানে সেটা বললে তো
দুটোর থেকে একটা থেকে পাচ্ছে,
সেটা তো আমিও
ফোন করেছিল।
সেটা তো আমি জানি না।
না
আই হ্যাভ টু অ্যাসার্টেন।
তুমি অ্যাসার্টেন করো এই দুটো আর এই দুটো কোথায় আছে, তোমার এরিয়ার মধ্যে আছে কি না আছে।
This he has been in possession, my lord, since last 50 to 60 years. He has a family, everything. The problem has been created by her. She holds a document of 20 and tom-tomming everywhere that she is resides as 20. If my lord asks them to come clean, then we will have a different submission to make.
My lord.
So my lord, your lordship has
to come clean means, Mr. Sarwala, they are residing in 16/1 itself.
First, my lord, they will have to admit that, my lord. Then I will make submission. If, my lord, they are, my lord, in the entire area saying that this is 20. And that is the case they made out in the earlier writ application and in this writ application. They will have to come clean. They are annexing, my lord, a document issued by HON'BLE Flour Mills in favor of her husband, where he was paid HRA. That means he was not residing in that premises as a licensee. He was residing elsewhere, And that is why he was receiving house rent allowance.
My lord,
But they should come clean first, my lord. If they approach the court with unclean hands, my lord, how can I help?
my lord, my possession was never disputed, my lord.
That is why me.
Possession at?
Possession at 20 round tank lane, my lord.
This is the whole difficulty.
As per, no, my lord, CSC has also accepted my outstanding dues against the 16/1 round tank lane, my lord. It is appearing at page 23.
You are complicating matters. 23. If you are in possession of 20, how could they take outstanding dues regarding 16/1?
My lord, at page 26 of this writ application.
23 or 6?
26, my lord.
Yes.
There, my lord, a previous connection was there in the name of Abdul Salam Khan. And
That is not you.
No, no, my lord, but previously when I have applied for from 16/1, at that point, CSC also took that, my lord, CSC realized those amounts.
Outstanding dues. Outstanding dues.
Outstanding of 16/1 was taken on the ground that since common meter is at 16/1, you will have to take at 16/1. So that is the mistake committed by me that I applied in the name of 16/1. Although possession is also 20, not disputed anywhere, my lord, and all the documents of 20 I have. This is the position. I have cleared for 16/1 since CSC.
No, from the documents, prima facie it is seen that they are in occupation of 20. And
Well,
CSC says,
document-
Mr. Sarwala, that they are, the meter connection can be given from 16/1. If they have charged outstanding dues for 16/1. I mean, what is the difficulty from 16/1 and connection is given to
My lord, the
20?
report says she is not residing in 20. That is the report of the CSC, my lord, has seen.
Not exactly.
But that is
Occupier at a premise behind the such and such complex. But it is not an inspection or investigation, local
That
investigation.
is what I am also, my lord, that is why I also disputed that.
And they decide.
They say Howrah floor mill.
And record your dispute, they'll give the connection from 16 to 20. 16/1 to 20. Because that's the existing.
Lord, their prayer is that they want connection from 20 to their residence in 20. That is the prayer in their.
Not from 20, at 20. At 20. Prayer is, they want electricity connection at 20. That is the only prayer.
And the prejudice is not clear. What is their prejudice? They have not. That is not.
No prejudice.
Prejudice, my lord, they should come clean that where they are residing.
That's as a good citizen, you may say that. How are you affected for that? Suppose they're dirty.
My lord, if
How are you affected?
My lord, if they say I am residing at premises number 20, but how on earth, my lord, a supply can be given to premises number 20, which is a huge property?
As a headache of the CSC, they'll do it.
No, it's not the headache of CSC, my lord. They
Why
cannot.
is it your headache?
My headache because 16/1 is my property. Lord, I cannot allow either CSC, my lord, or anyone else to take connection from my property to their property. My lord, CSC prohibits that you cannot.
Suppose if a connection is given from 16/1 to 20, but wherever she is residing, I mean, the billing will be independent. They will not be charged for it, anything. Only the location will be common.
Not kindly come to the writ application, my lord. Their new prayer, their new application, and the writ application.
The writ petition prayer, yes.
Common meter board. That is the common meter.
Provide a new electricity connection in the name of the petition at 20 round.
Prayer C.
B. Oh, C is, you say, complete an installation of a.
Yes. That is what they changed from the earlier writ application. That is how this writ
They'll give
application
connection
came.
at 20 from wherever possible. If necessary from 16/1. What is the difficulty?
This is, my lord,
This is what? How are you
giving, how I am the owner of the property, my
So
lord.
what? Owner is not entitled to dispute an occupier's electricity
Of
connection.
course not. If the occupier is of
You
the,
also come with
if
clean
the
hands. If you say you are the
my lord,
owner
if the
and you have an objection, if you have an objection in the capacity of an owner, I'll overturn that. I'll
then, my lord,
record that.
my lord, allow me to file affidavits.
No.
Then
For what?
Affidavit that they are not the occupier of 16/1. They are wanting connection in 20. I am the owner of the property.
You, for the purpose of disclosing in your affidavit in opposition that they are not occupiers of 16/1, that is the only purpose.
That is what they say, my lord.
That is the purpose of your filing.
My lord, that is what they say. If they claim
No,
that
no.
I
Why
occupy,
do you want to file affidavit in opposition, Mr. Sarwala? What will you
if
disclose?
suppose if consumer of
What do you
premises-
want to disclose by
But
way of your
what-
affidavit?
my lord, what 20? Let CSC say
I am asking a simple question.
my lord,
What do you want to disclose by you have your affidavit?
that there is a separate service installation in 20 premises number 20 round tank lane. If there is a service connection in 20 round tank lane, then why the CSC will give connection from 16/1 round tank lane? This will be on your objection.
Provide from 20 also.
Yes,
Provide from 20.
provide from 20.
The petitioner's contention is that the petitioner is a widow lady whose husband had been working in an adjacent jute mill. Full stop. The petitioner has annexed documents including
Flour
Aadhaar card,
flour mill.
jute na flour.
It's
Sorry.
no more there, but it was.
The petitioner has enclosed documents, enclosed to the writ petition. Her Aadhaar card and other proof of possession with the writ petition, comma, in respect of premises number 20, comma, round tank lane. Full stop. Next para. It appears from the report filed by the CSC Limited that during inspection, the CSC Limited found that the petitioner is at present getting electricity supply from a neighbor. Full stop. However, comma, the location of such neighbor has not been specified in the report. Full stop. It is also disclosed in the report that 20, round tank lane is a large commercial cum residential complex with boundary, and that the petitioner is an occupier at a premise behind the mentioned complex, comma, which she claims to be 20, round tank lane as well. Full stop. Next para. The CSC Limited has further disclosed that there is an underground service existing on the right hand side of the main entrance with connected meter numbers 4509987 and 5331266. Full stop. From the metering database, comma, the CSC also found that the address where the meters are installed is 16/1, round tank lane, Howrah 71101. Full stop. Next para. A dispute has arisen as to whether the petitioner has any right to get an electricity connection from premises number 16/1 round tank lane, where she is not even claiming any right of occupancy and or possession. Full stop. Next para. Learned counsel for the private respondent seeks to file an affidavit in opposition disputing the possession of the petitioner in 16/1 round tank lane, and also seeking to disclose that there is an independent electricity service connection at premises number 20, round tank lane, which can very well cater to the need of the petitioner. Full stop. Next para. Irrespective of the private dispute regarding title and possession between the parties, it is clear from the report that the petitioner is in occupation of a premises in the close vicinity of 20 round tank lane as well as 16/1 round tank lane. Full stop. Paragraph Roman 4 of the report of the CSC Limited discloses that there is an underground electricity service on the right hand side of the main entrance with 2 connected meters which are installed at 16/1 round tank lane. Full stop. Next para. The petitioner, in view of having annexed sufficient primary documents to show her prima facie possession with regard to 20, round tank lane, is very well entitled to get an electricity connection at her present premises. Full stop. It is well settled that an occupant cannot be denied electricity at her premises within the contemplation of Section 43 of the Electricity Act 2003, read in conjunction with Article 21 of the Constitution of India. Full stop. Next para, even if there is a dispute with regard to the electricity connection being given to the petitioner from premises number 16/1, the report of the CAC Limited says that there is an underground service which caters to 2 meters at premises number 16/1. Full stop. Next para. However, the main line of electricity which provides supply to the said service, which in turn caters to 16/1, can also be tapped for the purpose of giving electricity connection to the petitioner's occupied premises. Full stop. Next para. Such connection can very well be given without intruding into the possession of from outside the precincts of the premises number 16/1, taking the connection from the underground service, which is existent in the locality and belongs to the CAC Limited. Full stop. In any event, the CAC Limited can also give a connection to the petitioner, a metered connection to the petitioner from premises number 20, Round Tank Lane. Full stop. Next para. In such view of the matter, even without disturbing the possession of the private respondent at premises number 16/1, electricity connection can be given to the petitioner, either from outside the precincts of premises number 16/1, but from the same main connection which caters to the service which provides electricity to 16/1 CAC Limited and not to the owners of 16/1 exclusively. Full stop. Next para. As such, the question as to whether there is existing separate electricity supply at premises number 20 becomes redundant. Full stop. In any event, the private respondent has no business in having any lookout regarding whether there is a service connection at premises number 20 in the event the private respondent's possession with regard to 16/1 Round Tank Lane is not disturbed. Full stop. Next para. In view of the above discussions, WPA 9235 of 2023 is disposed of by directing the CAC Limited to raise a quotation in favor of the petitioner, indicating the estimated costs required to give a metered connection to the petitioner at her existing premises, in or near premises number 20, Round Tank Lane. Full stop. The CAC Limited shall explore the least expensive means to give such connection, without in any manner disturbing the possession of the residents of premises number 16/1 and or taking any electricity connection from inside premises number 16/1. Full stop. Such estimate shall be raised by the CAC Limited and served on the petitioner at the earliest, preferably within, today we are on 15th, preferably within May 22, 2023. Full stop. Upon compliance of all formalities by the petitioner, including the payment of necessary estimated costs, such connections shall be given to the petitioner without disturbing the residents of premises number 16/1 at the petitioner's premises, preferably within a week after the compliance of all formalities by the petitioner. Full stop. Next para. It is made clear that nothing in this order shall create any right or equity in favor of either the petitioner or the private respondent, and shall not operate as conclusive finding on the possession of either the petitioner or the private respondent with regard to any of the premises concerned. No rest to cause urgency.
WPA 10412 becomes infructuous because previous
The second item number 4.
Item number 4.
previous street. This was a previous street.
In view of the order passed, ওটা বোর্ডে দেখাতে হবে। In view of the order passed in WPA 9235 of 2023, comma, WPA 10412 of 2020 is disposed of as infractuous. No rest of it.
One line. If necessary, we shall be able to approach the local help of local police.
আচ্ছা আরেকটা লাইন অ্যাড করিন ওই জাস্ট নো অর্ডার আছে যেখানে প্রথমটা ডিসপোজ অফ করলাম তার ঠিক আগে in the event any obstruction is faced by the CSC personnel in doing so comma it will be open to the CSC personnel to approach respondent number 4 the inspector in charge of the Shibpur police station for adequate police assistance which will be given by respondent number 4 by acting on a server copy of this order at the cost of the petitioner cost of the petitioner.
One.
Yes,
What?
Mr. Bose.
One, my lord. In both cases, whether from 20 or 16, it
Not from 16. An underground connection is going to 16. From that, if you
from the
can,
existing meter board position may be added.
no,
That
there is no
that
existing.
is our choice.
That is your choice. I leave it on your choice.
As your
It may be a service connection. It may be whatever.
lordship. as
Whatever
your-
way, whichever is the cheapest mode,
My lord, my
ascertain
lord.
and just.
Lordship has indicated.
My lord,
Lordship.
I led by Mr. Sushanto Pal, my lord. He is engaged in courtroom number 25.
ঠিক আছে, দিয়ে দেন নামটা।
I'm grateful, ma'am.
Please give his name also. Thank you.
Deeply obliged, my lord.
The order before giving.
Item 8,
My lord, I'm appearing for the petition, my lord,
560.
on the my lord, on the earlier occasion, your lordship directed us to serve a notice upon the learned advocate who is appearing for the private respondent before the learned court below, my lord, in a civil suit, my lord, which is pending between the parties.
You are appearing for the private respondent.
My lord, I'm for the private respondent number 5.
My lord, may I?
Yes,
And,
you have served.
Yes, my lord, I have served. This is the.
I'm for the
affidavit of
CSC,
service,
my
my lord. My lord, this writ application pertains to new connection, my lord. My lord, the petitioner herein has sought for a connection in respect to her matrimonial home, my lord. This matrimonial home has been inherited by her husband, my lord. And my lord, we in the month of March, my lord, 2023, my lord, put out an application, my lord, seeking this connection because, my lord, in the month of February, my lord, the connection which we were drawing from the common meter, my lord, has been severed by the private respondent, my lord. Thereafter, we have also took out a written complaint before the concerned police station, my lord. My lord, thereafter, we have been communicated with, my lord, Annexure P6 appearing at page number 35, my lord, whereby we have been intimated that objection has been raised against my application, my lord. My lord, though it has been stated that they are enclosing the objection, my lord, but it has not been served to us, my lord. Subsequently, we issued a letter, my lord, the learned advocate of the petitioner, my lord, issued a appearing at page number 37, annexure P8, my lord. My lord.
Why didn't your husband apply?
My lord.
Why didn't your husband apply?
My lord.
My lord, make this.
My lord.
To avoid what?
My lord, that I do not. My lord.
Don't be over enthusiastic. Please let him say.
My lord, to that effect, I do not have any instructions, my lord. My lord, but if I may make a
The
humble
application was
submission,
made by your husband to
my
the
lord.
SP.
Yes, my lord. But my lord, though
you have
the
no local-
petitioner is residing with her family, my lord,
How
even
is he
with her
barred?
son, my lord.
How is he barred from taking electricity connection? Your husband?
My lord, it might be decided amongst both two, my lord, that in the name of the wife, may the,
Acha, very.
my lord, I am not privy to that information, my lord, but this is my assumption, my lord. My lord,
So they are objecting now.
now they are objecting. They have objected, my lord. There was a restraint order passed by the learned court below, my lord, in the title suit, which they violated, my lord. Thereafter,
Who filed the suit?
The suit has been filed by
Suit for
the
declaration
husband of the petitioner, my lord.
Declaration injunction.
Declaration injunction, partition, my lord. Partition suit, my lord. Where a restraining order has been passed against the private respondent
to not to interfere with the, or maintain the status quo per se. My
Where
lord.
is that?
My lord, it is appearing at page number 25, my lord. The certified copy of the certified at 24, the order is appearing at page 25, my lord. May I read out the operating portion?
Change nature and character and transfer element.
My lord.
Right.
My lord, thereafter, my lord, they were they were violating this order, my lord. We took out another application, my lord. In that application, order was passed against
them
upon the police authority to provide the necessary help, my lord. My lord, police authority
How
never,
were they violating?
my lord,
How were they violating?
my lord, they were entering into the portion in which we were residing, and they were, my lord, creating other hurdles, my lord. They were breaking away things, my lord.
Right.
My lord, for which we filed a writ petition, police in action, my lord. Our order was passed, my lord.
How are these relevant?
My lord, these are not relevant, my lord.
Then don't say those.
My lord, the only thing, my lord, the son of the petitioner is due to appear in the high secondary, my lord. My lord, and in this scorching heat, my lord, they are suffering immensely due to non-availability of electricity.
When
My
is
lord.
the higher secondary scheduled?
My lord, next year.
Next year.
He just in class 12.
You will get a winter before that.
Before
What are
that,
you
my-
trying to suppress? Tell me that. Why is your husband not the petitioner?
My lord, I am not privy to that information. I have not.
Let me hear from them then.
My lord.
Yes.
My lord makes right question because my lord
Now, I know I made the right question. What is the right answer?
husband does not reside on that property.
Then she is deciding she has applied.
She also does not reside on that property.
That kind of.
My lord, this is our second marriage. This is his second marriage.
So how is he barred
My
by
lord,
law?
No. As per Muslim law, it is valid. But my lord, the lady does not reside on that property. Lady
She has
resided
obtained an
by-
injunction restraining you from disturbing whatever.
My lord, no one has none the petitioner, none his husband.
So
No
she is
one
more
reside-
unfortunate that I was thinking. She had a bad landlord only. Now she has a bad husband also. She is
My
more
lord,
entitled to
my lord,
electricity.
this is the
Absolutely.
picture
No,
of
no.
the total property. My lord, kindly go through the property.
Why
They
should I
have
go
not-
through the property?
My lord, why? My lord, suit has been filed for partition against 26%. 26% reside on that property. There are two buildings. In two buildings, 26%.
She is one of the residents there. She wants a connection.
No. She never reside on that property ever. She never reside on that property. My lord, kindly go through once. My lord, kindly
Go through what? Give
take
them
the
copies
picture.
first. Give them copies first. Don't cite anything before court without a copy.
No. I'm showing the picture of the property.
How can I know ascertain whether that's your house or my house or the property?
This is the
Picture showing a picture. This habit is very bad, Mr.
My lord,
A picture. How do I know out of the blue you are handing over a picture? How do I know which premises that is?
now, my lord, then my lord, kindly consider.
What
They
are you
have
trying to
filed-
convince me from the picture?
From the picture, it is appearing there is two buildings. In one building, it is a hut. There is only 3 rooms, and one building is a constructed 2-floor, say 1-floor building. There is only 8.
They are residing in the hut.
They are not residing on any portion of the property.
So why is that relevant? That photograph?
My lord, now, my lord, he say that a partition suit is going on. In the petition, they have stated in paragraph number page 4, para 2, that they are annexing the plan, but no copy of the plan has been annexed. My lord, from the plan, your lordship would consider that how many person would reside on that property.
How many are
It is
there?
appearing at
My
page
lord,
number
there are
15.
22%.
Have you been to Kolabagan? Have you worked in any capacity in the Kolabagan Bosti? Do you have any idea how many people can reside within, say, 5 by 5 feet
My lord,
on bunks?
yes.
What is the area? I mean, what is the area?
My lord, the area as per the plenty.
Howrah? I don't know.
Pachpara,
I
my
don't
lord.
have it. Anyway, I
79
mean, there may be
decibel.
many residents of a property.
My lord, many residents of that property, and neither the husband nor his wife, neither of them reside
Husband
on
is
the
enjoying an injunction order from a civil court. You are saying
injunction.
that
My lord, kindly go through the injunction order. What is the injunction order? Not to transfer the property. My lord, kindly.
And from changing nature character.
Yes, not to transfer and changing.
Not
the
regarding
nature-
possession.
My lord.
Right.
So if that be so, then I am not changing.
Don't
The
change.
property as it was previously, it remained the same. Now if they would reside on that property, then they could have when the police have come.
Are you trying to say that the lady is applying for electricity to establish her possession there?
My lord.
What is their plaint? Show me, since they have not shown.
Plaint is not annexed, my lord.
They are giving a copy.
My lord, the injunction application.
Neither in the plaint nor in the injunction application.
Show me your injunction application. That has been annexed.
Appearing at page number 15, annexure P2, my lord.
It has not nowhere written
Show me
that
your,
he is.
show me your averment regarding possession only.
My
lord.
He says nahi.
No, my lord. He must be mistaken, my lord. My lord,
Show me.
before that, my lord, if I
Correct his
may
mistake.
draw your, invite your attention to annexure P1, my lord. P1.
No,
is the-
show me your possession from
My-
this injunction application.
My lord,
Your
this is the-
husband's injunction application.
My-
Your averment regarding possession,
My-
nothing else.
My lord, at page 18, paragraph 7, if I may read it out, my lord.
7, yes.
That in the record of right, there was an erroneous recording of the name of 225 of the defendant numbers 18 to 22, who have not initiated the share as record in the RROR. The said recording is an illegal and void document, and the share of the respective parties are required to be adjudicated in this.
What is the averment regarding possession?
My lord.
There is no averment regarding possession. Have they filed their written statement there or written objection to the
No, my
injunction?
lord. No, they have not. In
They are
fact-
saying yes, you are saying no.
No. My lord, what has happened? That's why earlier I
I
mentioned.
don't know what has happened. I am asking a simple question. Have they filed any written objection or written? If you have filed, please hand over. You admit the property to be joint.
I admitted.
Then every
Property-
co-sharer's possession is the others.
My lord, I admitted that he is my brother. I admitted that he should have to take
Entitled to
share on
electricity.
that property.
Entitled
But-
to electricity. Why not? Co-owner entitled to electricity.
Yes, I admitted that he is the owner.
They
but-
admit, let him get the electricity connection.
But where? If
From-
he does
from your
reside
Peterwood
on that
question.
property, where in my he can always.
Now let me hear the license. Yes, what is your stand?
My lord, the difficulty
I've got your
is
point.
initially the application was for enhancing the capacity, the load. That means assumably he was getting a supply.
But
Now,
she's not.
Now, my lord, when we went for inspection, we found that it was a different story. It is not for enhancing the load and they require a fresh new connection. Now they have to rectify that. They have to make a fresh application.
Oh, they have not even made an application.
No, because that's a wrong application.
Very well.
And then, my lord, they have to arrange for the inspection. And if it's feasible, we shall.
My lord,
You have applied for enhancement of load
my lord,
in respect of a meter where you are not even the consumer.
I apologize, my lord. I have been instructed that it is for a new connection, my lord.
Show me your connection from your application.
My lord.
Let me ascertain from
the
that.
application is not there, my lord, but they are.
Apart from that, everything else is there.
It is as per our
My lord,
records.
annexure P6, my lord, refers to our offering new supplies, shifting service, strengthening service, lying. This is the document. This is the letter issued to me, my lord. My lord, I have accepted it also, my lord. My lord, it is the same address. I received this notice, my lord, at the.
No, at page 36, you have said something. Please.
Yes, my lord, but as per our records, what transpires is they wanted to.
No, you have stated that with reference to your
Objection.
application through annexure A form number such and such. You have given the form number also for providing estimate, etc. for supply of electricity
My lord.
at the above address.
My lord.
Submitted through our website.
My lord.
Together with, you have admitted that.
So there are options.
My lord,
And you
there are
wanted to carry
options here because it says new.
No, at page
ownership.
36, please come to page 36.
36. 36.
35, yes, you are right. I've seen that. Several options. But this is your acknowledgement,
Yeah, but this is.
your regional office.
This is for the supply.
Application for every, application.
For yourself, please read it out aloud, then you will understand.
You with reference to your application through annexure form A, so and so for providing estimate, etc. for supply of electricity at the above address submitted through our website together with self-certification form. We would like to inform you that we intend to carry out an inspection at the above address between 9 AM to 1 PM.
Just, George Sharp ke bolo, eta dekhi, request for extension of road.
My lord, at the top portion, at page 36 itself, request for extension of load. It's written there. For existing consumer.
So I'll
within
give them liberty
brackets.
to apply for a fresh electricity connection, but you cannot have any objection to that. They are co-owners, they are entitled.
If they
Wife
want
of
to
co-owner
reside-
is
My lord, if they want to reside in our place, they always can.
always.
Always can, because it is, he is our brother and he is our brother's wife.
That's why the
They
suit
always
is pending.
can.
That's why a suit is pending. They had to obtain a status.
They have filed a suit only for partition. For their share.
You are
only
challenging,
share.
disputing their possession. I mean, a few minutes back. Is their co-owners? They're automatically in possession through you.
If I may
My lord,
only
I am
indicate, my lord,
challenging with regard to that, he is not in possession.
my lord, I am in possession. In fact, I received this letter at this
File
particular.
an application, proper application. They'll hold an inspection. If they think you're in possession, they'll give the connection.
My lord, only the police cell, my lord, they are creating.
No
they are-
police cell. No police. You have not got any application on record.
My lord,
She's right on that.
my lord.
A peculiar predicament has arisen in the present case. First up, the petitioner apparently applied for enhancement of load of electricity, although the petitioner does not have any electricity connection in her name at the premises in question. First up, it is submitted by the petitioner that despite the petitioner seeking a new electricity connection, due to objection by the private respondents, such connection cannot be given to the petitioners. First up, the petitioner also places reliance on an order of injunction dated June 13, 2019, passed in title suit number 256 of 2019 by the Civil Judge, Senior Division, Third Court at Howrah, whereby the defendants in the partition suit of the petitioner's husband, being the present private respondents, were restrained from transferring, alienating and encumbering the suit property in favor of any third party stroke stranger and or also from changing the nature and character of the suit property. Full stop. Next para, learned counsel for the CSC Limited submits that the petitioner has not yet applied for a new electricity connection in her name. Full stop. As such, the present writ petition may be premature. Full stop. Next para, by placing reliance on annexure P6 and P7 respectively at pages 35 and 36 of the writ petition itself, it is pointed out that the petitioner's representation was only for strengthening of the electricity service, to be specific, a request for extension of load within bracket for existing consumer. Full stop. Next para. However, on instruction, since it is submitted now by the CSC Limited that the petitioner does not have any electricity connection in her name at all at the premises, no question for extension of load can arise at her behest. Full stop. Next para. Learned counsel for the private respondent, while controverting the writ petition, submits that neither the petitioner nor her husband, although her husband is a co-owner, are in actual physical possession of the disputed property. Full stop. Next para. Hence, the petitioner in this method, is seeking to gain a foothold as regards possession in respect of the disputed property. Full stop. It is further pointed out by learned counsel for the private respondent that the order of injunction does not carry any restraint order regarding the possession of the petitioner's husband, comma, who is the plaintiff in the suit. Full stop. As such, comma, it is clearly evident that the petitioner or her husband are not in possession of the property. Full stop. Next para. Upon hearing learned counsel for the parties, comma, it is clear from the records that the CAC Limited is right in pointing out that the present writ petition is premature, comma, since no application has yet been filed by the petitioner for getting an electricity connection at the premises. Full stop. Next para. As such, comma, the remedy of the petitioner lies in making a fresh application for getting a new connection of electricity. Full stop. If such an application is made, comma, the CAC Limited shall scrutinize the same and process the same, and upon holding an inspection, comma, shall ascertain as to whether the petitioner is in prima facie settled occupation of the premises and whether it is feasible to give electricity connection to the petitioner. Full stop. Upon such inspection, comma, if such application is made by the petitioner at all, comma, the CAC Limited shall raise a quotation and give the estimate. Full stop. Upon compliance by the petitioner of all formalities, such connection shall be given to the petitioner. Full stop. Next para. It is made clear that in the capacity of a co-owner, comma, the petitioner's husband is entitled to get an electricity connection at the premises, comma, since it is well settled that the possession of one co-owner operates as a joint possession of the others as well. Full stop. Be that as it may, comma, since electricity connection requires the actual settled occupation of the proposed consumer to be satisfied, comma, the CAC Limited, while making inspection, comma, shall also ascertain such aspect of the matter. Full stop. Nothing in this order shall create any special right or equity in favor of either of the parties. Full stop. WPA number 10577 of 2023 is disposed of in the light of the above observations. They will be entitled to make an electricity new application connection. Then whatever you will ascertain settled occupation, everything. Estimate.
My lord, if it is not feasible, then we shall communicate the same to the petitioner.
I've not put that in my order.
But
That in any event you do.
My lord, only indulgence if I may seek, my lord, in the order itself, my lord, I just refer to
Only
the-
one thing in your favor in the order, which is
My lord.
common occupation.
My lord, it has
But
been-
they have to ascertain he is right. They have to ascertain actual settled occupation.
My lord, it has been stated in our plaint. If I may read it out for two line, my lord, my lord. My lord, the learned lawyer on behalf of the plaintiff submits that both the plaintiff and the defendants are the joint owners and the occupiers of the suit property, my lord. I am occupying the property along with them, my lord.
But no injunction regarding possession has been granted to you.
My lord, restraining them only, yes, my lord. No,
Why
only
was
restraining
that?
them from
Why was
entering-
that not granted? No injunction possession. No injunction regarding possession. Only nature, character, and status quo. Nature, character, and transfer alienation. Why?
Subject to
Possession is the
correction.
first thing which has to be given.
Subject to correction, my lord, there is a.
Anyway, let us call on the next.
My lord, may I
Much
maybe
obliged.
come back the WS?
Anything else?
Grateful, your
Much
lordship.
obliged, ma'am. Mediation.
Thank you. Yes.
Much obliged, ma'am.
আবার চলছে? আপনি একটু বলেন না কেন ইয়েকে রেজিস্টার লিস্টিং কে বলবেন আবার বলুন তাহলে আর কি ডাকুন
Item 9.
Item 9, my lord, I am for the petitioner, my lord.
I'm for the CESC, my lord.
I have applied for a new domestic electric connection. Previously, my mother was applied.
Your surname is Luthra.
No, it's Mitro.
It was recorded in the last order. I was rather surprised. I knew Ms. Mitro, but is anyway. Yes, Mr. Odikar, what is it?
My mother was previously application.
Please take the microphone towards you.
My mother was taken applied for domestic electric connection that was not given in the year 1996, my lord. After that, my lord, in the year 2000, after the death of my mother, my lord, I have applied for electricity connection in the year 2000.
Service on private respondents affected. What about service on private respondents?
My lord, there is a dispute with regard to the passage. And
my lord, from the 2018
Before going to 2018, let us see the current track record.
item received, 2 has been received, my lord. Item delivery confirmed to the CSC.
4, 5, and 6 whether they have received.
4, 5, and 6. Actually, my lord, 4, 5, and 6, he is not filed any objection, my lord. His mother has
They
been
are parties here. You have implemented them.
implement there, my lord. Is a delivery missent. It is
Then serve properly and come back.
My lord, actually, my lord, what happened, my lord, the private respondent's mother was now he's expired, my lord. My lord, in the year 2018, raising objection, my lord. And nowadays, my lord, they are not raising any objection, my
Serve
lord.
properly on the private respondents.
My lord,
They shared the genes of their mother.
yes, my lord.
To serve on them also.
moreover, my lord, the
They may also
passage
object.
has to be
Has to be.
the passage that is the main objection. There are so many people objecting to this.
Are
this
these
has to
people
be-
also objecting?
My lord, we have to excavate the land. Now, for that, we have referred the matter to the municipal corporation. We
Since
have not received the permission from them also.
11 December 2018, my lord.
passage has to
They
be
have
worked
written the
out first.
18, page 31, my lord.
Well, let us first see the objection of the private respondents. Proper service has not yet been effected on the private respondents. You are filing an affidavit of service today.
Yes, my lord.
Affidavit of service filed today be kept on record. Full stop. However, comma, in view of non-appearance of the private respondents, service shall be effected afresh on the said respondent, that is respondent numbers 4 to 6, and an affidavit of service shall be filed in that regard on the next returnable date. Full stop. The matter shall be returnable in the monthly list of June 2023. Serve fresh copies on 4, 5, and 6, and come back with this service.
Grateful, Your Lordship.
Please reiterate your objection when the matter is called on, that it has to be excavated and all.
Item 10.
এখনো বোর্ড শো করছে না?
I am for this.
শো করছে? Yes, Chakravarti, what is the matter?
I served my private respondent, but they have left returned, my lord.
They have
Returned. They are
written
not
with what endorsement?
endorsement left.
Then you have to serve again.
Left means?
You have to serve now again.
Well, they are the main because we.
If they have left, you have to serve again. If they have left the premises, how can they object?
No, they have not. There is no objection.
Who are they?
Well, our
landowner.
Yes, there is a dispute between them but our stand is different.
No, what is the basis of your address as given in the cost title? They have left from here, ascertain their correct address and serve them.
No, I have no, not.
What can be done without service cannot be. Why did you implicate them in the first place? Why did you make them parties?
They have
Why
made
did you make them
agreement and give position of the flat. Yeah, I have the agreement and position of the giving.
Show me in
position
your
of the flat.
petition the averment in respect of these respondents. Please show me that.
No, that is there in the police report.
Achha, they are
Fact is-
objecting.
Fact is, my lord, they have, my petitioner made an agreement with that gentleman and subsequently they denied to register the flat. That's that
He is in occupation of the flat.
No.
He is not in occupation.
That is, my lord, that's not clear because neither report.
Hey,
and we are
position, my
simply asking for submitting the valid document so that we
Where
can.
is your communication?
So that we can give effect connections.
Where is your communication, Mr. Kule?
My lord, that is, my lord, at page
26.
26.
Page 26, my lord.
Nothing else because we have no way connected with those gentlemen and all others.
Have you annexed something regarding your land ownership? They may not. Possession they have to.
Position there, my lord.
Whatever.
In fact, position letter, my lord, I have annexed.
Where is that?
My lord, position letter, my lord. Page. First, page 13, my lord.
Position letter.
Position letter, 113.
Certificate of possession.
Yes, my lord. And they have only not giving registered.
There was an agreement to sell the property to you.
Yes, my lord.
They did not execute a sale deed.
Yes, that's.
Yes, my
Have you
lord.
filed any suit?
Agreement for sale.
No, keep it. Have you filed any suit for specific performance?
No, my lord.
If you haven't filed, then there is no right in the property. You don't have a right.
Yes, but they have,
But you are in occupation, you are saying.
I have want of electricity, my lord. So I am made application, my lord, proper application, page.
একটা order record করুন।
Uh,
Learned counsel
16.
for the petitioner submits that
Page
the
16.
petitioner is in occupation of the premises. Full stop. It is submitted that despite having handed over possession of the flat in question to the petitioner, comma, the private respondents stroke owners, comma, who had to execute sale deed in favor of the petitioner, comma, failed to do so. Full stop. It appears from the affidavit of service that the service sought to be effected on the private respondents has returned with the endorsement within double inverted left, double inverted close on the envelopes. Full stop. Next para. Although proper service has not been effected on the private respondents, comma, it is not the contention of the distribution licensee as well that any objection is being raised specifically by the private respondents. What the WBSCDCL has sought in a written communication annexed at page 26 is production of the applicant apostrophes valid land ownership document within bracket registered purchase deed stroke tax receipt stroke possession letter possession letter from developer
I
in
have
favor of applicant bracket closed. Full stop. Next para. It is apparent that the requirement of the WBSCDCL, comma, although captioned as within bracket within double inverted land ownership document double inverted close, comma, is actually document regarding the possession of the petitioner. Full stop. Next para. The petitioner has already annexed a copy of a certificate of possession within single inverted certificate of possession issued by the private respondent stroke owner in favor of the petitioner with regard to the property in question. Full stop. It is submitted by learned counsel for the petitioner that an agreement of sale has also been executed in favor of the petitioner, comma, the original of which is in custody of the petitioner. Full stop. Next para. Hence, comma, the requirement of the WBSCDCL as communicated in its letter dated February 2, 2023 has to be read down, read down to mean any document of possession of the petitioner in respect of the property. Full stop. Since a certificate of possession has already been annexed to the writ petition and the petitioner submits that the petitioner carries documents to show prima facie possession of the petitioner with regard to the property, comma, such documents are only required to be produced by the petitioner before the WBSCDCL gives such an electricity connection to the petitioner. You have to provide something else also, not only some third party, because you may have a collusion with this person. So produce something, some Aadhaar card or something, some voter identity card or anything there, a medical shop receipt, whatever, manufacture something and
Well, that should be indicated here. Lordship.
accordingly, WPA 10742 of 2023 is disposed of by directing the petitioner to produce prima facie documents of prima facie possession of the petitioner with regard to the property in question before the WBSCDCL, comma, for the purpose of the WBSCDCL processing the application for new connection of the petitioner. Full stop. Such production shall be effected by the petitioner within a week from date. Full stop. An estimate, comma, subject to such production, comma, shall be raised by the WBSCDCL within a week thereafter. Full stop. Subject to compliance of all formalities by the petitioner thereafter, comma, the electricity connection shall be given in the name of the petitioner by the WBSCDCL as expeditiously as possible, comma, positively within 1 week after the compliance of all formalities by the petitioner. No rest to cause urgency.
Grateful. Right.
Item 11,
Lord, in this matter, my lord, the dispute is between the private respondent and the petitioner, my lord. We are ready to supply the electricity connection, provided we have the access. We went for inspection, installing the meter, we could not. My lord, I have a matter in court number 5. May I just take your lordship's leave? Because the next matter is.
May I indicate, my lord?
Brief, yeah.
Yes.
May I indicate that this matter, we try to move the matter on a previous occasion when there was some issue with regard to the pagination. Thereafter, I've served copies of the petition on all the parties. My lord,
Before that, I'll have to indicate one more thing, which I also got to know now. We have filed an application for addition of party. My lord, not we, I was representing the private respondents. Your lordship, I had shown that letter by which it was recorded by the electricity company that inmates had obstructed.
You were the other inmates.
I was one was impleaded, the other inmates have filed an application for addition of party, have come in. I am only going to represent them, so it otherwise won't make a difference. So I don't think I need to take
That
an
application
adjournment
is
on
there already in the list.
No, it has not been served on us.
It's just been filed, it's not been served. But
if I may only indicate, this is a short issue with
Let
regard
us hear what is your objection, then we will decide on that.
Yes,
Madam,
yes.
it is a very
Otherwise, it
yes.
won't make a difference.
Right.
I am only going to appear, so its point will be the
What
same.
is the objection raised by you?
Objection
It is
is
a new connection application.
Yes,
it's a
madam.
new connection
Let me hear their objection, then you'll give the.
new connection application. The objection by the inmates is this is a G+5. G+1 is declared to be commercial. This is a property that has been purchased by way of a surface sale. It was sold as residential. This rest of the building is residential. The predecessor in title of the petitioner had purchased the property where in his deed that also we've disclosed.
They have purchased within G+1.
No, above. That is the objection. That in a
They
residential,
want a commercial connection.
they're taking commercial. That is my objection.
And I will just indicate from the mutation certificate that has been issued by the KMC. My lord, it is reflected as this same premises was being used for as an office premises. My lord, P2, page 39, if my lord comes, is where the mutation certificate starts. My lord, at page 41.
Okay.
My lord, this is in respect of the same premises. And the property is indicated nature of use office. This is in respect of the person who was prior in possession, pertains to the year 2017-18, and the particular nature of use is in respect of office. Exdent Ishpat Private Limited. So this particular premises, the assessment is at the page prior to that, where my client's name has been brought in dated 13th of October 2022. So it was taken over and it is being used as office.
My house.
That's the inspection. That's the inspection book. My learned friend will point that out.
It's
He'll
from
have
the
to show
inspection
that he has a
it
that's the
indicates that
IB. That's
it's
an
No, if it's an office, and
Yes,
if it is mutated as an office,
Let
Mr.
him show that.
He has annexed something.
No, that's the inspection book. That's the basis on which he's that non-residential use. Page 40. That's the inspection book. That's on basis of which he's paid tax. Not he. He's purchased it. The sale notice says it's a flat. Residential. He'll have to today come and show to your lordship that there's a sanction by which it's a commercial space. He's purchased it as a flat, purchased it as residential. How does the IB help him, Milon? He doesn't have a sanctioned
purchased the
plan.
flat and it
We
was
will
already
not
there
argue
in-
parallel. It will be difficult for all three of us.
I would only indicate, my lord, that this was for office use and it was previously in office use, the same premises, before it was mutated in my name. The objection,
What a mutation certificate.
my lord,
End of story. That will finish it.
one of the mutation certificate is at page 39, P2.
Nothing with regard to.
It doesn't speak about whether it's
It
residential
cannot.
or
I'll tell your
commercial.
lordship, Lord, if the property is sanctioned as G+1 is commercial and 2 onwards is
So, Mr.
residential.
Banerjee, they have annexed the mutation certificate.
Lord,
with regard to the same property.
That's right. It
SSC
doesn't
number.
show it commercial. He's
No, doesn't.
utilizing the,
But he is also annexing in connection with this, in conjunction with this, for the purpose of a writ petition inspection book, which
for the
indicates that
purpose
it's
of
an office.
valuation for payment of property tax. I'm showing to your lordship that he
He's
his
not
right
wanting to use it for any industrial purpose or something
for
like
commercial. He wants to use it. He
that.
takes a
Commercial has
commercial.
many connotations.
My lord, I'll show to your lordship from documents that his predecessor in title had a specific clause that he has to use it for residential. He cannot use it for office. I'll show that deed. I'll show his document that he purchased it by way of a surface action, a residential property. Today, it's a complete issue of law in a residential property where he can get a commercial. Otherwise, he'll have to show this deduction by showing a inspection book. That cannot that cannot help him, my lord.
Mr.
Admitted,
Banerjee, file your objection.
I'll file
Objection.
my affidavit.
My lord, the same SSC number is indicated, and my lord, in case he has any objection with regard to the commercial use, he cannot restrain me from getting in electricity connection.
No, not that, but you are asking for a commercial connection. That has a different connotation.
If he wants residential, we'll all
If
agree.
you wanted a residential connection,
Then
they
I'm
have
agree.
they'll be out of
There
court
is
in
no
this.
such, my lord,
Their only objection is that.
If
My
he
lord,
wants
the-
residential,
Get a
I'll concede.
commercial. If you get a commercial.
the consumer number is in respect of does not indicate commercial in any manner.
No, it does. It does. It
Well,
does.
subject to
Where
correction.
is your application for?
My lord, my application is at
Page 42, your lordship
42.
will see.
42.
Page 42 is commercial.
No, I
Stand corrected.
I stand corrected. My lord, I'm not sure. It indicates COM. The load indicates COM, which my learned friend is indicating as commercial.
Full form of COM is residential.
No, it may be then. It may be. I will not try to argue something which is irrelevant. Residential.
No, this is commercial.
This is commercial. My learned friend wants
Well, I'll just-
residential, no one will have a problem. This is the issue. In a residential thing, he wants to start
No,
an
it is
office space.
It is commercial. Page 45.
Even his predecessor in title never used it as an office. His deed says so. I can show that deed. It's part of
The
my application for
mutation-
petition of party.
The mutation, my lord, reflects it was for
Mutation al-
office use.
Anything.
Electricity connection, they cannot oppose. You ascertain
correct.
whether you want a residential or a commercial connection.
I will do that.
If you will be satisfied, if you can run your office by way of a residential connection, then it's your headache. They cannot raise objection at this stage. Of course, they can later on,
Yes, my lord.
but that will be a civil dispute then.
I'll just take instructions on that one. My lord, would my lord be pleased to keep it tomorrow? And in that case, after that, my lord may direct affidavit if need be. If I
Yes,
can,
if necessary, I'll direct affidavit. If it's residential or agreeable to that, then no
I will
question of
take
affidavit.
instructions.
At the outset, an objection has been raised by the private respondent to the effect that the flat at which the petitioner is seeking electricity connection is seeking commercial electricity connection for the purpose of running an office, was designated all along in all the transfer deeds as a residential property. Full stop, next para. Although out of the different stories of the building, the ground floor and the first floor were designated for commercial purpose, the present flat of the petitioner, where the petitioner is seeking electricity, is situated above such above the first story, making it a residential premises. Full stop, next para. Hence, the private respondent, being one of the inmates of the property, objects to the commercial connection being given to the petitioner at such premises. Full stop. Learned counsel for the petitioner places reliance on the mutation certificate, read in conjunction with the an extract from the inspection book of the corporation to indicate that the property has been designated as an office. Full stop. Be that as it may, since a dispute has arisen as regards whether the property can be used for commercial purpose, by taking a commercial connection to the premises, the respondents would otherwise be entitled to controvert the allegations made in the writ petition by filing an affidavit in opposition. Full stop, next para. However, at this juncture, learned counsel for the petitioner submits prays for a day's adjournment to take instruction as to whether the petitioner is agreeable to take a domestic connection at the premises, full stop. In all probability, comma, if such a consent is given by the petitioner, comma, the issue which has arisen in the present writ petition may be resolved. Full stop. Hence, comma, to enable learned counsel for the petitioner to take such instruction, the matter is adjourned till tomorrow. So I've recorded it. If you agree, then I'll dispose of the writ petition. Otherwise, affidavit will be done.
My lord will record one line in my submissions, my lord, that the deed in the present case does not reflect that it is restricted to residential use, because the
No, I'll not
purchase deed
I'll
does
not be elaborate on that because that will prejudice the final hearing. But let us come back. If you don't have instruction
No,
to
my lord, I'm only indicating that submission because my lord had recorded my learned friend submission.
যেটা সাবমিশন বলেছি রেসপন্ডেন্ট ইন্টার আলিয়া ওটা করে দিন learned counsel for the respondent inter alia sub. So the inter and the alia will be taken care of later on, if necessary.
Very well.
Can 1.
Yes, please give the slip.
I'll just, can 1 of 2023.
একটা লাইন অ্যাড করুন, let can 1 of 2023, comma, a connected application filed by certain persons seeking to be added as parties be listed along with the main writ petition tomorrow. First.
No service has been effected on us.
Please, during the course of the day,
Yes, yes, sir.
positively do it. I'll add them obviously if there are other inmates.
Item 12. I appeal for the petition.
Yes, what is the matter?
The petitioner is the landlady, my lord, let out a shop room to the private respondent. My lord, may I hand over the service, my lord, on the last question?
Good service.
My
Private respondent?
private respondent, my lord, complete service, my lord.
Very good. Yes.
What is the track report is concerned, my lord? I being the landlady, my lord, let out a shop room to the private respondent.
Right.
I'm enjoying commercial connection in the said shop room since 1993. Now in 2017, I let out the shop room. That private respondent committed theft of electricity. 135, 138 Electricity Act was booked, but in that FIR, I was named as an accused. Subsequently, my lord,
Meter is in your name.
meter is in my name. Subsequently, my lord, I have been not sent time in the charge sheet.
You have been?
Not sent time in the charge sheet. And the statements of the electricity officials also shows that I am not involved in the said theft of electricity. My lord, since my electricity connection has been disconnected, my lord, I pay for reconnection, my lord.
What is the law, Dr. Chahara?
My lordship will find that, I don't know, there is a absolutely suppression of material fact, with due respect. Your lordship will find that on 5/7/2021, we made an inspection in the said premises. There were 2 meter, 2 industrial meter, I will rather say. One in the name of the petitioner and in the name of the private respondent. But there was a hooking by bypassing the meter, and there was a direct connections. And on that basis, provisional order of assessment was passed and final order of assessment was passed against the petitioner as well as against the private respondent. And that order was passed on 22/7/2021. It was duly served upon them, where in the final order of assessment, it was specified that they are jointly and severally liable for the same. There was a 29 lakhs odd assessment order, out of which the private respondent on a pre-condition of bail paid 5 lakh rupees. There was another writ petition was taken out before this honorable court, and this honorable court that was taken out by the private respondent on the same final order of assessment. It was the observation passed by your lordship that since a final order of assessment has not been challenged and it attains finality, until and unless the entire amount is paid,
That
restoration
petition was filed by whom?
by the private respondent. And in the final order of assessment, both name is there, of the petitioner as well as of the private respondent. Now, on that basis, your lordship,
What about their discharge by the criminal?
so far the discharge is concerned, your lordship knows that final report has been given by the police authority, and your lordship knows that in the process of FRT,
They've been acquitted there.
no, it has not been acquitted, and your lordship knows under section 170 the Naraji petition can also be filed on behalf of the CS.
Compounded, can be
Yes, but so on that basis, they cannot absolve this liability. This is my humble submission. But this is the last order passed And this is the final order of assessment. May I hand it over?
Now
to
they have
the-
challenged the final order of assessment.
No. They haven't challenged. It has
They're
pa-
asking for restoration of electricity.
Yes, restoration, my lordship will find. This is the final order of assessment. I'm handing it over to my that was passed on. Your lordship kindly see on 23/7/2021.
This was served on both of
Yes. On lordship kindly see.
Shamul Shah is a private.
Yes. I kindly say they are jointly and severally liable in the final order of assessment. No appeal has been preferred against that order.
Yes, you have been set up. You have set yourself up in support of your private respondent.
This is, my lord, the fact, my lord. Both the 2 meters has been booked for, my lord, theft of electricity. Now, my lord,
You are also responsible in one.
but,
How can the restoration be given if you are liable for?
now then, my lord, when it comes to page 30, my lord. Entire allegation is against the private respondent. Even, my lord, the electricity officials, I have annexed the statements. Electricity officials, my lord, statements from, my lord, page 26.
Cannot look into the
Yes.
records of the criminal case for this purpose. Prima facie, they have raised an assessment. Unless this is settled, how can you get a reconnection? If you have not challenged this, you had to challenge.
My lord, I don't know, my
Your
lord, whether,
involvement has been. You have been also roped in here.
Lord, I don't have that instruction, my lord, whether this final order of assessment, my lord, has been.
Both Shamul Shah and you have a plastic granule manufacturing factory. That is
Yes,
their
yes.
allegation.
That was not my lord. I have not been instructed over this issue, my lord. My lord.
Naturally. No. This petition, writ petition does not lie. Sorry. The petitioner stroke landlady has filed the present writ petition asking for restoration of electricity connection to the petitioner's electricity meter at the premises. Full stop. Next para, it is alleged that the petitioner was not involved in the alleged action of pilferage of electricity, comma, for which charges have been leveled against the private respondent stroke tenant. Full stop. As such, comma, the petitioner ought to be relieved from the disconnection and the connection be restored immediately to the petitioner's meter. Full stop. Next para, learned counsel for the distribution licensee submits that a final order of assessment has been made in the meantime, comma, where the petitioner has been castigated on an equal footing as the private respondent for the alleged unauthorized use of electricity. Full stop. A previous writ petition filed by the private respondent tenant with regard to the same allegation, comma, bearing WPA 7626 of 2023, comma, met with a dismissal vide order dated April 10, 2023, whereby liberty was given to the petitioner therein to clear off the entire outstanding dues in lieu of assessment. Full stop. Next para. It is rightly pointed out by the CSC Limited that the present application is to bypass the liability of the petitioner regarding payment of the finally assessed amount, comma, which has never been challenged by the petitioner under section 127 of the Electricity Act 2003. Full stop. On such score, comma, the petitioner stands on equal footing as the private respondent, comma, who lost his writ petition on April 10, 2023 on similar grounds. Full stop. As such, comma, there is no mitigating circumstance to permit the petitioner's supply to be restored unless the petitioner, comma, who stands on an equal footing as far as the allegation of unauthorized use of electricity is concerned, comma, to restore electricity connection of the petitioner. Full stop. Hence, comma, WPA 10899 of 2023 is dismissed without any orders to cost. Full stop. However, comma, nothing in this order shall prevent the petitioner from clearing the entire outstanding dues and the requisite payments of the CSC Limited for the purpose of getting back the electricity connection of the petitioner.
Deeply
Great.
Rest to cost certain. I'll come back in 5 minutes.
Certain Lordship, I am for the petition.
What is the matter,
Service
please?
of the private respondent is not
Under the
effective.
WBSCDCL, madam.
Not complete.
No, sir, Lordship.
Come back. When did you send it?
I have sent this letter on 8 May.
So we'll wait for after the vacation then.
Oh, yes, Lordship.
It is fairly submitted by learned counsel for the petitioner that the service on the private respondent has not yet been completed. File your affidavit of service.
Yes.
The affidavit of service filed today be kept on record. Full stop. In view of the above submission, comma, the petitioner is directed to serve afresh a copy of the writ petition on the private respondent, indicating that the matter shall next be listed in the monthly list of June 2023. Full stop. The petitioner shall file a fresh affidavit of service in that regard, annexing the fresh service and or the track report regarding satisfactory service on the prior service on the next date of hearing. If in the meantime this service is affected, annex that, the track report. Otherwise, you also take attempt to serve again on.
Yes, Lordship.
So either of the two services will do.
Yes, Lordship. Great, Lordship.
Thank you.
Item 14.
Yes.
My lord, item number 14, I'm led by Mr. Firdaus Shamim, my lord. In this matter, my lord, the petitioner.
Led by Mr.
Firdaus Shamim.
Yes. What is the matter?
My lord, in this matter, the petitioner, a provisional assessment against the petitioners were issued by the Electricity Board, my lord. And then a final assessment was issued in 2016, but the petitioner was not given an opportunity of hearing here, my lord. And then in the year 2019, my lord, the petitioner was taken into custody, and the bail, he received bail on the ground that 50% of the money he should have to be given. He gave, my lord, and then later on he was acquitted in this matter in 2022. Right now, my lord, the petitioner is praying for, my lord, the restoration of the electricity. My lord, his wife is extremely ill and he has a son who's a student, my lord.
Yes, what do you say?
Madam, but theft was detected.
Did you raise a final order of assessment?
Yes, yes. He did not appear. That's why in 2016 we raised final assessment order that has been admitted. Now, my lord.
Where admitted where? In the writ petition?
In the writ petition, they said that they have received the final in the writ petition. But kindly see once. In the writ petition.
No, they are saying that final assessment order was served on them, but without hearing them.
But they choose not to appear.
My lord, the petitioner is a security guard, my lord. He's a extremely layman.
And that's why, my lord, huge amount, my lord, direct hooking. Now, my lord, not only that, in this writ petition, what he has paid, kindly see, my lord. Now, my lord, they are saying that as my issue a writ in the, kindly see the page 11.
Yes.
Kindly see the prayer, issue a writ of or in the nature of mandamus, commanding the respondent, each one of them, their servants, agents, or assignees to forthwith recall and or resigned and or set aside and withdraw provisional assessment order and impugn final assessment order dated 30th July 2016. In 2016, they choose not to prefer any appeal in terms of 127. Now, what they have done, they are proceeded in the criminal proceeding, and ultimately, according to them, they have been discharged. Now, on the last occasion, the submission was made that they have been discharged, therefore, they are not liable to pay. Now, I am to that extent, if your lordship permit me, I can show you a judgment before your lordship, the similar.
Show me the either the provisional or the final order of assessment. What is the nature of allegation?
Nature of allegation is, my lord, detected and direct hooking from LTOH line.
Sorry, ma'am.
My lord, if an opportunity is given to me,
how can
to be
I?
heard.
Because this is 2023. In 2016, you lost the opportunity
My
for
lord,
filing an.
he is a security guard, my lord. His
I can
monthly
appreciate-
salary is
I can
just
appreciate fully.
8,000, my lord.
But even then, what can be done? I mean.
My lord, if they give us an opportunity of hearing, my
that
lord,
opportunity could be given probably in 2016 or 2017 at best. Now we are in 2023.
my lord, then if
Taking
you-
advantage of the acquittal,
if
now you're coming in.
my lord directs that if the payment of the money is made in small installation, my lord, such a big amount for a person earning only 8,000 and his wife is extremely sick.
What is the sickness?
She's
Have you annexed? I mean, mentioned.
that has not been specified to me, my lord.
Then
And he's a security guard, my lord. His earning is only 8,000 a month, my lord. if it's just restored, and if your lordship directs in small amounts, if he could make payment on monthly basis, that is also, my lord, if
Yes, Mr. Mukherjee.
that is allowed.
If that is accommodated for all security guards, there are several others. similarly
Kindly see it
placed.
is in service,
Cannot be.
occupation.
If my lord just considers, my
Kindly
lord,
see
then
the
I would be
occupation,
deeply
page
grateful, my
30.
lord.
Service as a security guard.
Service as security guard.
Is it not stated in the writ petition?
No, my lord, in the
Yes, my lord,
petition-
I have annexed his, my lord, page 20, his document that he's a security guard.
But in 2019, when he has granted bail, in 2019, he came before your lordship for any other forum. Since 2019, now we are 2023.
Bail was also granted in 2019.
Yes,
Why did you wait for so long?
My
50%
lord,
deposited.
he came before us a few days back, my lord. He's a
That is-
layman, my lord. That is why I'm requesting, my lord.
He is not a layman anymore after obtaining the bail. He now knows what to do in a court of law.
My lord, if
Have
the
full-
electricity is restored, my lord,
That's why Mr. Shamim is not there.
then my lord, kindly grant me a pass, my lord, then if I can get my
Now
senior.
record the name of Mr. Shamim. The petitioner claims that the petitioner is a security guard and earns a meager amount of livelihood. Full stop, next para. It is submitted that the petitioner was initially assessed as an unauthorized user of electricity and a provisional order of assessment was raised. Full stop, subsequently, comma, without hearing the petitioner, comma, a final order of assessment was passed. Full stop. Thereafter, the petitioner had obtained bail in a connected proceeding under section 135.
My lord, may I just say one more thing, my lord? My lord, in the provisional
Finish my
assessment,
sentence first. 135 of the Electricity Act 2003 and was subsequently discharged from the said criminal case. Full stop, it is submitted that the petitioner is entitled to be the petitioner is entitled to restoration of her electricity connection in view of such acquittal on similar ground. Yes, what other submission, ma'am?
my lord, in the provisional assessment, the officer who signed the provisional assessment, he's the same person who did the final assessment, my lord.
Rightly
How-
so.
My lord,
Assessing officer.
he's the same person.
Under the law, he has to be. If it was a different person, we could have considered. What's the next para? It is further submitted that the person signing the provisional order of assessment was the same as the one who signed the final order of assessment. You want to add anything?
My lord, I don't know what is the submission, my lord, but since the petitioner, my lord, is without electricity, my lord, since the petitioner,
I feel submitted.
yes, my lord.
The child is a student, submitted.
Yes, my lord.
Provisional order of assessment, no hearing, submitted.
Yes, my lord, that is,
What else?
my lord,
Acquitted in criminal matter,
yes, my
submitted.
lord, 135, he has acquitted, my lord, but I want, my lord, restoration of the electricity.
That has been
connection, my lord.
submitted first, restoration.
Yes, my lord, kindly, my lord,
Against it.
consider, otherwise, my lord.
After
And my lord,
considering only, I am rejecting your application.
and my lord, 50% amount of the total final
bail,
assessment
yes.
is that has
Also
been
submitted.
submitted, and my lord, petitioner got
Submitted
only.
by your learned friend also, not
Yes,
only
my
your
lord.
client.
Yes, my
So
lord.
we have
and,
covered all the points.
The
Please don't-
petitioner only get, my lord, 8,000 per month, my lord.
That also has been submitted.
If the any installment or otherwise, my lord, petitioner will or many years.
You're reading from the same notes. Exactly same has been submitted. by her. The same thing. Both of you have prepared very well. I have full sympathies for you, but not your client. I'm extremely sorry. Nothing doing. কোনখানে ছাড়লাম? Same person signed. Full stop. Next para. Learned counsel for the petitioner also contends that the petitioner's wife is extremely ill and his son or daughter,
Son.
his
Junior
son is a student. Full stop. As such, severe difficulties are being faced by the petitioner due to the disconnection of electricity. Full stop. Next para. Learned counsel for the WBACDCL contends that the assessments were made in the year 2016. Full stop. Despite service of notice of the provisional assessment order, the petitioner chose not to appear at the hearing for the final order of assessment. Full stop. Even the final order of assessment attained finality in the year 2016 when no appeal was preferred against the same by the petitioner. within the provisions of section 127 of the Electricity Act 2003. Full stop, next para. In fact, comma, in the year 2019 itself, comma, the petitioner had obtained bail in the criminal proceeding upon deposit of 50% of the assessed amount. Full stop. Waiting for so long for the petitioner's acquittal, comma, the petitioner did not take any step thereafter against the final order of assessment and has now come up with the present writ petition only in the year 2023. Full stop, next para. A consideration of the submissions of parties reveals that the petitioner is hopelessly time-barred inasmuch as a challenge under section 127 is concerned. Full stop. Even if the petitioner was justified in arguing that the petitioner was not heard before passing the final order of assessment, comma, the said plea is negated by the long abstinence of the petitioner, comma, for about 7 years from challenging the final order of assessment before an appellate authority, even on such ground. Full stop. The ground now being sought to be raised was available to the petitioner all along in the appeal, comma, if any, comma, preferred against the final order of assessment. Full stop, next para. More so, comma, if it is debatable whether any further opportunity ought to have been given to the petitioner, since a notice of the hearing on the provisional assessment was allegedly served on the petitioner and the petitioner could not, for some reason or the other, comma, attend the final hearing. Full stop, next para. Hence, comma, it cannot be said that the final order of assessment is flouted for any contravention of the statute, that is the Electricity Act 2003 or the connected regulations. Full stop, next para. Insofar as the acquittal of the petitioner is concerned, comma, the same was on the standard of a criminal trial that is beyond reasonable doubt, comma, which is different from that of a final order of assessment under section 126, comma, the yardstick of the latter being preponderance of probability. Full stop, next para. As such, comma, the acquittal of the petitioner, comma, in the absence of any challenge whatsoever being taken out against the final order of assessment since 2016, comma, does not benefit the petitioner in the present context in any manner whatsoever. Full stop. In the event the petitioner is to obtain electricity connection, comma, the petitioner has to fulfill all formalities, comma, including payment of outstanding dues, comma, which situation cannot be improved at this belated stage, comma, 7 years after the final order of assessment was passed. Full stop. Hence, despite having full sympathy with the petitioner on the other aspects of the petitioner, comma, WPA 11160 of 2023 has to be dismissed as it is. Full stop. There will be no arrest to cause urgency.
May I take back the judgment?
Take back
The judgment.
so cited a judgment for what?
But the 126 135 acquittal.
Call on the next.
Not affidavit of service.
Call on the next.
Item 15. I am for the.
You're for the respondent. Who is the petitioner?
But just now I have received the copy. It has been served just now.
It has been served.
My lord, in terms of private respondent, service has not yet been effected. I'm praying
Should
for
I take it up after the vacation?
or day after tomorrow, my lord.
Very well. On the prayer of the petitioner, the matter is adjourned till May 17, 2023. Come back.
Grateful, my lord. May 17 means Wednesday.
Yeah. 17th, day after tomorrow.
Open event.
16.
I am for the petition.
Yes, please.
I'm for the CSC, my lord. একটা copy পরিষ্কার দিয়ে দেবেন আপনাকে file দিয়ে দেবেন তাহলে last occasion I submitted although the copy which was served is not legible, but I could not find my learned senior friend. That's why I could not serve the notice to him for service for a fresh copy. I just made a request to him, but however we have no objection because there is a dispute between landlord and tenant.
What about service on the private respondents? Service of the writ petition?
I have service.
Good service. Please check up whether good service on. You have checked up good service?
Yes, sir. Good
Yes.
service. Both the parties are made meeting at the PS also.
Then what happened?
That was,
They are the landlords.
they are the landlords.
I'll direct sir.
let a copy kindly take some
Okay, আমি এটাই দিয়ে দেবো।
একটু আমি জেরক্স করে আপনাকে দিচ্ছি দিন দিন আমাকে
Affidavit of service filed today be kept on record. Full stop. Despite service, none appears for the private respondents. Full stop. Learned counsel for the CSC Limited seeks a fresh copy of the writ petition on the ground that the copy served on the respondent is illegible. Full stop. Let a fresh legible copy of the writ petition be served by the petitioners on the learned advocate for the CSC Limited during the course of the day. The matter shall be taken up under the same heading tomorrow.
and day after tomorrow can
Oh, tomorrow, come back tomorrow. It's short matter, not getting electricity, tenant, landlord is refusing. I'll give to you.
কপিটা একটু জেরক্স করে দিন আমি 6 নম্বর পারে
17 and 18.
My lord, I am appearing for the petition and.
Yes, what is the matter?
instruction আছে
Why two writ petitions connected?
My lord, connected writ petitions, my lord. My lord, this is the second round of litigation. My lord, and the petitioner is a government sponsored college.
Hmm.
And my lord, we have received a bill
Madam,
for the,
can I interfere, my lord, once? My lord, what happened, my lord, initially they came up against the bill, they came up before the lordship court. The lordship says that, my lord, in terms of 53(2), we cannot raise the bill after lapse of 2 years, my lord, your lordship direct the GRO to decide the matter. They preferred and the GRO passed an order. The order is not in terms of your lordship's order because that limitation has not been considered. But I have taken the instruction. If your lordship might send back the matter to the RGR for deciding within 7 days or 10 days, my lord, subject to correction.
my lord, one thing, my lord, I am grateful to my learned friend for that.
No, need not be.
My lord, but
He knows that will be the order pass, that's why he is. Need not be.
My lord, another point is that this is a college, my lord, and so we have built another building.
Why two writ petitions?
That is why I'm answering that. We have built a building, my lord, and in respect of that building, we have prayed for a connection increase in bulk connection because we have to build some laboratories and there. We're citing the pendency of these 30 lakhs, which is a disputed amount. They are not granting us connection therein. For that, we have preferred the second writ application. And
No, they are right. They have a right to say that. Because if you are a defaulter, the premises are the same.
premises are the same.
Then
But
the same-
lordship has, on the earlier round of litigation, lordship has expressed to lordship's mind whether it can at all be claimed or not. That's the
that
first
is a
point.
different thing. If you are absolved on this, that will also go.
And second point, my lord, is that lordship, this is actually, it's an admitted point that the meter reader did not take the meter reading for properly for more than 5 to 6 years. He used to take it as 6 digits, which they claim actually 7
Which
digits.
has to be resolved by the JRO. We cannot prejudge that.
My lord,
Which writ petition is which? 11480 is the first.
11480 is the first one challenging the order of the GRO.
And 581 is the
Is
second
for
one.
the connection, my lord.
In WPA 11480 of 2023, the writ petitioner has challenged an order passed by the concerned RGRO, whereby the RGRO decided the dispute raised by the petitioner without considering the condonation of delay prayer of the petitioner. First up, it is submitted that such act tantamounts to contravention of the order of this court. Full stop. Next para.
My there is no
In
My lord, there is no condonation of delay, my lord.
oh,
52 within time I can raise the bill.
My lord, 56.
acha, sorry, without condonation of denial, I'm sorry. Without considering
56(2), my lord.
without considering the applicability of section 56 within bracket 2 of the Electricity Act 2003, তারপর in contravention কি বললো? না ওটা বলো কি বলো, আমি বলে দিচ্ছি। ওই সেন্টেন্সটাই বলো। রাইট। হ্যাঁ হ্যাঁ এই পর্যন্ত বলেছি। it is alleged that the same was in contravention of the order of this court, remanding the matter to the RGRO. Full stop. Next para. WPA 115.
There is another point, my lord. Lordship on the earlier round of litigation has expressed lordship's mind that whether the mistake was at all bona fide or not, that point has also not been considered. Whether the mistake,
Whose mistake?
the mistake on the part of the licensing authority. Institution, my lord. But that point was also
WPA
not-
11581 of 2023 has been filed challenging a subsequent demand of the WBACDCL for payment of the entire alleged outstanding dues with regard to the consumer number which is involved in WPA 11480 of 2023, for the purpose of giving a new electricity connection to the petitioner for construction of an additional wing of the college. Full stop. Next para. Learned counsel for the petitioner, in support of the writ petitions, further submits that, by its previous order, this code had also directed the RGRO to consider whether the mistake was bona fide or not.
My lord, kindly takes, my lord, let me show you lordship's
Page,
order
page,
for the point.
page.
It's at page number 63, my lord. Paragraph 2. Although the WBACDCL might have some justification in arguing that the Supreme Court has consistently taken the view that bona fide errors can crop up for licensee to claim an amount even after the time stipulated. in
Sentence,
section.
last sentence, submitted in next para. A perusal of upon hearing learned counsel for the parties and the perusal of the order dated November 21, 2022, passed in WPA 23646 of 2022, it is clear that this court had inter alia observed that it was doubtful whether the petitioner's claim was at all maintainable in the year 2017 in view of the specific bar stipulated in section 56 within bracket 2 of the 2003 Act. Full stop. It was further observed that although the WBACDCL might have some justification in arguing that the Supreme Court has consistently taken the view that bona fide errors can crop up for the licensee to claim an amount even after the time stipulated in section 56 within bracket 2, in the present case, it is doubtful even as to whether the error admitted on the part of the distribution licensee was bona fide in the sense that the meter readings were all along available to the distribution licensee, but there was apparent negligence on the part of the licensee in taking the meter readings and stroke or supervising carefully on the reading by superior officials. Full stop. Next para. Learned counsel, should I record your fairness? Learned counsel for the WBACDCL, hard learned counsel for the WBACDCL as well. Full stop. Next para. A perusal of the impugned order of the RGRO indicates that the same was passed in contravention of the order of this court dated November 21, 2022, as indicated above, inasmuch as the RGRO did not consider the questions which were directed to be considered in terms of the order dated November 21, 2022. Full stop. Next para. The RGRO did not consider the question of section 56 within bracket 2 of the 2003 Act and or whether the mistake committed by the distribution licensee in making the calculations was bona fide. Full stop. Next para. Hence, WPA 11480 of 2023 is disposed of by remanding the matter to the concerned RGRO, directing the said RGRO to rehear the parties and decide the dispute afresh in terms of and in consonance with the order dated November 21, 2022, passed in WPA 23646 of 2022 in the light of the observations made herein above. Full-stop, such re-adjudication shall be conducted upon giving adequate opportunity of hearing to all concerned as expeditiously as possible, comma, positively within a month from this date. Full-stop. Next para, insofar as WPA number 11581 of 2023 is concerned, comma, the same is consequential with the outcome of the decision of the RGRO in WPA 11480 of 2023, comma, as the WBSCDCL is otherwise justified in terms of the existing regulations to claim the outstanding amounts, comma, if any, comma, in respect of the same premises, comma, if a consumer applies for a fresh electricity connection. Full stop. Accordingly, WPA 11581 of 2023 is disposed of with the observation that the WBSEDCL shall revisit the claim for clearance of all outstanding dues, comma, if any, by the petitioner for getting a new electricity connection, comma, in consonance with the outcome of the decision of the RGRO and or the outcome of any challenge, comma, if preferred thereto by any of the parties. Full stop. No rest to cause urgency.
May I hand over the affidavit of service?
Affidavits of service filed to be kept on record. So you will decide within 1 month, and consonance with that outcome, you will just decide the other.
Instead of 1 month, can it be, my lord?
It is sufficient.
Great.
Old matter, item 19.
My lord, in this matter, I am appealing for WBSDCL, my lord.
Oh.
The previous occasion, my lord, your lordship directed me, my lord, to give a notice to the petitioner's advocate, my lord.
Yes.
For appearance in the today, my lord. I have given the notice, my lord. But my lord, I have sent my clerk, my lord, to his office, my lord. I came to learn, my lord, he died, my lord, 5 to 6 years ago, my lord.
Who has died?
My lord, the advocate, my lord. This is the
Serve a fresh copy on the fresh notice on the respondent then.
respondent. I am the respondent.
Oh, on the petitioner then. Directly on the petitioner. Let us hope she is living.
Most important. Directly, my lord, to the
These matters, most of the matters, this is the difficult.
But my lord, they have got the connection, man.
They have got the connection.
Yes, man.
This application was for that only.
Yes, my lord.
So how did they get the connection? There was a dispute. Why did you give the
Lord,
connection?
This is the misconceived application, my lord. We have given the connection, my lord, in the year 2003, my lord. If you lost to says, my lord, I can.
No, they then need not. I'll record the submission, but I'll dismiss it for default so that they can come later if they have it. The service of notice sought to be effected on the learned advocate for the petitioner could not be so effected as per learned counsel for the petition for the respondent stroke licensee, comma, in view of the demise of the learned advocate appearing for the petitioner in the meantime. Full stop. Next para, it is submitted by learned counsel for the distribution licensee that the writ petition is misconceived, comma, as an electricity connection has already been given to the petitioner. Full stop. Next para. However, comma, since the petitioner is not represented, comma, WPA number 26419 of 2006 is dismissed for default without any orders to cost. Interim order, if any, shall stand vacated. Full stop. Please keep these with you. I mean,
yes,
if necessary, subsequently challenged, it may be necessary.
Item 20.
20
My lord, I appear on behalf of the CSC, my lord, in this matter, I have done one mistake.
What mistake?
My lord, on 8th, my lord, there was a direction passed by your lordship directing me to serve upon the learned advocate, my lord. My lord, I have served upon the party, my lord, but I could found out Mr. Haldar is there. My lord, I have intimated him today in the morning, but there is no written communication. If my lord may kindly take it up tomorrow, and my
Prayer of the CSC Limited, the matter is adjourned till tomorrow.
and we have already, my lord, installed the meter in 2007.
Inform that tomorrow. Indicate to Mr. Haldar so that he also appears then.
Yes. my lord.
After knowing this, he may appear.
My lord, I'll intimate. I'm grateful.
Item 21,
Yes, please.
Your Lordship, I'm appearing for the respondent.
Respondent.
Yes, CSC Limited. Your
You are for the petitioner?
No, my lord. I am told Mr. Sojourner Bandyopadhyay is appearing.
Yes.
He wants a Passover.
Passover at this point of time, I'll make it not,
Not
today.
today,
I'll make it not. On the prayer of the petitioner, the matter is adjourned for the day. Acha, on the prayer of the petitioner, Corona. I'm not recording any order because your name cannot be recorded. You are a senior advocate. But her appearance has to be recorded, Mr. Sarkar.
Yeah,
How can it be done?
Of course.
Give a solution. Acha, none appears for the petitioner at the time of call, although the distribution licensee is represented through counsel. Full stop. Let the matter stand adjourned till tomorrow. Please give your name then. Call on the next one.
22,
Your Lordship, I'm appearing for CSC Limited in both 22 and 23.
Same order.
23.
23 are appearing, I'm saying. Same order না দাও। Appear করছে বলছি তো দেখছি। আমি তাড়াতাড়ি করে Yes, what is the matter?
23 I got
23?
already connected.
22 তো হয়ে গেছে। এবার 23 তুমি ডাকলে 23 what has been done?
Connection already done.
Pardon?
Meter already been installed.
So no cause of action.
No.
23.
It's infructuous. Okay.
Learned counsel for the petitioner submits that the writ petition has become infructuous in the meantime in view of the dispute raised having been resolved. First up, accordingly, WPA 12038 of 2008 is dismissed as infructuous. No orders to cost. Thank you. Good.
24 and 25.
My lord, I'm for the petitioner, my lord. My lord, on the last date, there is little recording. Perhaps I could not say properly. It's not at the verge of being settled out. What happened?
Achha.
They raised a claim of 36 crores.
This is the order dated?
This is of 10th of April 2023. Lordship is recorded that the matter is on the verge of being settled out of court.
Achha.
Actually, what had happened,
Yes.
they have raised a claim, theft and other cases altogether about 36 crores. My client had a claim of about 6 crores. We came up before this honorable court. This court cannot decide. You name an authority, we'll send it to it. Then both the parties suggested let it be West Bengal Electricity Regulatory Commission because they are connected to electricity. So it was sent to Electricity Regulatory Commission. Before Electricity Commission, Commission raised a lot of questions to them. Then they approached our client and said, very well, Shodh bodh. Yeah, nothing is due to you, nothing is payable by you. Then WBRC passed an order. Based on that WBRC's order, a high power committee took a decision that this one of the dispute that has been already been settled. Now, in that view of the matter, unfortunately, that WBRC's order we could not find with us. I appeared in that matter, but unfortunately, that order I couldn't get.
So, what is now surviving in the matter?
According to me, nothing survives, but I don't know whether learned friends have taken instructions in the matter.
Because there was a report on the last day we handled.
Yes, because
But on the
on
last,
22nd of February 2022, the chief engineer distribution, he has I had placed on record on the last occasion.
My lord,
Or may I give a copy?
instruction we have, my lord, taken. May I hand it over to lordship for.
May I have a copy?
Yes, definitely. Give a copy to them, Mr. Naik.
আগে দিন দিলেন না তুমি?
These are subsequent developments.
No, my lord, on the last occasion when my lord.
No, after the affidavits were exchanged, this has happened.
Yes. This
Because when the last occasion.
this
matter was taken up-
28th of April 2023.
Yes.
This is a matter of 2014.
2014 years.
My lord, Mr. Sarkar submitted that, my lord, it is about to be settled because there is a high power committee, therefore they have taken cognizance of the entire issue. So my lord, please to direct us, you take clarification as to what stand you are going to take in the matters. We said it's a case of theft, it's a separate matter, so that has to be taken up separately. So my lord was pleased to direct us, you take clarification, we come back. This is our clarification. And settlement, my lord, that was correct, but settlement with regard to the regular unpaid bills. They are having huge number of my lord towers, so there are a lot of my lord regular unpaid bills.
This is regarding pilferage.
Pilferage.
Not regarding that.
No. Our stand is, my lord, with regard to the pilferage, my lord, there is no
They
settlement.
have challenged what? They are asking for restoration.
Yes, ma'am.
Why two writ petitions, Mr. Sarkar?
Two separate centers. We have about 4,800 towers.
These are regarding two different centers.
Two different
towers.
Towers, Lordship.
So you are challenging, you are asking for restoration of connection. What about the pilferage? What happened to that?
I don't know, my lord.
In fact, they have challenged
Lordship
the
has
final order of assessment.
22nd February.
Final order of assessment has to go before the GRO.
Yes.
Before the appellate authority.
127.
No, my lord. Their committee meeting, which is circulated by the chief engineer distribution, says at a copy there.
Mr. Sarkar, either you say that it has been resolved, you don't want to proceed with the writ petition. They are saying that the dispute is still there. There is a resolution is regarding something else.
My lord, their own record speaks. That K, logically see. It has been gathered and FIR lodged in industrial.
You have to give a copy of this to them also then.
Of course, the last occasion we have given.
It is annexed to what Mr. Naik has handed over. It has already been filed by Mr. Sarkar last week.
Right.
Yes.
At the time of arbitration process through WBRC, as per the court order, same amount has been nullified. And currently there is no dues against the service connection. So that has to be, have meaning for this. And which Jhikirhati, consumer ID, CCC is Panchthupi, division Kandi. If there's no dues, and recommended to submit the case separately for further discussion found if okay, norms reconnection may be effective.
Yes, Mr. Naik, what do you say to this? Please take back this copy. I've got a copy. They have annexed to it.
My lord takes up our clarification, last clarification, because we are submitting on instruction, lordship. So all these are considered, and my lord kindly see our the report, the clarifying the situation. Dated, my lord, 28th of
Are
April.
you disowning this thing? This?
Yes, it is clarified that the theft matter has not been taken into consideration at all.
You are not saying that here. In K, you see it has been gathered that an FIR was lodged. FIR can only be in connection with the theft.
Theft, lordship.
FIR was lodged and Messrs. Indus Tower and then the entire amount was considered in their central bill amount. That entire amount has to be in connection with the FIR, which can only be in connection with sections 135 to 140.
Sarkar is referring, my lord, their note dated 22nd of February 2022. Right?
You have annexed that to your
Yes,
statement.
But considering all this is the
No,
instruction.
we cannot fudge up the thing.
My lord.
K is very clear. It has been gathered. I'm repeating it again and again.
My
to say.
lord.
Please look into that.
My lord.
Look into that.
Lords.
That clearly says regarding the FIR has to be of the theft. The entire amount was considered.
Give us a
Arbitration was there. Mr. Sarkar is right on that. Nullified. Same amount can only pertain to that FIR.
May I suggest one thing, my lord? Difficulty is possibly some assistant engineer or lower authorities instructing my learned friend. My lord, I will make a representation to the whoever the senior most chief engineer distribution or somebody, my lord, and he will consider it in the light of these minutes. Lordship, can he direct them to consider within 2 weeks after vacation?
My lord, may I in humble submission?
Are you suggesting, Mr. Sarkar, that I'll dispose of the writ petitions with that?
Subject to my lord's convenience.
Yes. Dispose of the writ petitions, that this dispute, you say that it has been resolved, which is disputed by them. Relying on whatever this is.
There is a minutes of the high power committee circulated by the letter.
They will consider it within a limited period and then decide on this, revisit the reconnection issue.
Lordship.
Yes, Mr. Nayak, what is it?
My lord, I respectfully submit, my lord, this is a writ petition. My lord, based on specific cause of action, they have filed this writ petition. Now, in between these discussions and all they're going on, if that be so, let them file one affidavit and we shall file our reply to that. Then lordship will take up the matter for hearing. Otherwise, my lord, on stay report is coming, we are giving one report, and my lord, I believe, lordship,
have you disputed this report?
My lord, I am not completely not convinced with all this, because what my instruction is and what the report is, these are different. Now we are in a writ petition, and where we have filed our affidavit and reply is also there. Let that be decided, and other dispute will not go as it is.
So you have submitted a statement of facts on the basis of this report, Mr. Nayak, which I have already kept on record.
Yes, that is on report.
That clearly refers to this.
Well, that is it. But I believe I will not.
Well, Mr. Sarkar, I'll direct
come by affidavit.
supplementary affidavit. Let it come on supplementary affidavit.
And we shall.
If it is resolved from here, we can resolve from here also then.
Lordship.
And we shall also reply to that.
The learned senior advocate appearing for the petitioner places reliance on a committee report in respect of settlement of various energy bill related disputed cases of the petitioner. First up, at the said committee meeting, held under the aegis of the WBACDCL, it was recorded, inter alia, in clause small k, that it was gathered that an FIR was lodged and the petitioner and the FIR was lodged and the entire amount of the petitioner was considered in their central bill amount. First up, at the time of arbitration process through WBERC, as per the court order, the said amount has been nullified and currently there are no dues against the service connection. First up, it was further recorded that the consumer has prayed for reconnection time and again, but same has been regretted. First up, the committee, it was recorded, has deliberated the issue and recommended to submit the case separately for further discussion. And if found okay, within double inverted okay, as per norms, reconnection may be effected. First up, by placing reliance on the same, it is contended by the petitioner that nothing remains in the way of the reconnection being given to the petitioner, since the entire dispute has been fully and finally settled between the parties by way of arbitration. First up, next para, learned counsel for the WBACDCL refutes such contention. First up, although within double inverted statement of facts, double inverted clause, have been filed today by the petitioner, by the WBACDCL, annexing the purported minutes of the committee meeting, the WBACDCL, as of today, disputes the veracity of the submissions of the petitioner. First of learned counsel for the WBACDCL insists that the submissions made by the petitioner be affirmed on oath. Full stop. In such view of the matter, comma, the petitioner is directed to file a supplementary affidavit indicating the relevant facts and subsequent developments after the exchange of affidavits in the present writ petition, comma, annexing all relevant documents, comma, including the committee report sought to be relied on by the petitioner. Full stop. Such supplementary affidavit shall be filed within a week from date.
Lordship, on the reopening.
Very well. Such supplementary affidavit shall be filed on June 9, 2023. Full stop. Reply, if any, shall be filed by June 16, 2023. Full stop. The matter shall be listed for hearing next on June 19th.
Deeply.
আর একটা লাইন অ্যাড করতে, the statement of facts filed by the WBACDCL today be kept on record.
But fixed on 16, 20, 26.
19th.
19th. How blessed to Lordship.
My lord, both the matters, my lord.
Same order in both the, yes. Joint act order করতে হবে। ওটা plural করে দিয়ে joint।
But the findings of the committee in respect of the second matter is little different. So that set out portion may be different.
তাহলে এটা প্রথমটা করো। আর সেকেন্ড একটা অর্ডার রেকর্ড করো, let this matter appear along with WPA অন্যটা on June 19, 2023.
I am deeply on that.
Lord, I beg your pardon, Lordship. The last item 40, my Lord, in person was likely to appear, he is appearing, but that may not reach to the Lordship.
Pardon?
Item 40, my Lord, personal appearance was directed, my Lord.
What happened?
It may not reach, Lordship.
Oh, item 40. Yes,
Lordship, 40.
Remind me if before I rise, if I can't take up the matter, please remind me at 4:15. I'll take up the matter.
I'm grateful.
Contempt application, item 26 and 27.
My lord, I beg to appear for the alleged contempt, my lord.
Yes.
Lordship kindly recollects, my lord, that over the self-same issue, my lord, there was a matter pending before the Honorable Division Bench, my lord. And the development before the Honorable Division Bench, my lord, may I just, my lord, get the indulgence to just hand over a copy of the order passed before the Honorable Division Bench, my lord, on the last occasion on 8th May 2023. Compliance almost has been made over there. So regarding these, Lordship kindly sees me, Lord, once, Lordship. It is submitted, learned advocation, that out of 487 persons, 427 persons will be granted the benefit for purpose will have to be funded in the bank account. Next, out of 60 remaining persons, 10 persons have already been granted benefit, and the balance 50% have been included in the final list.
This is in an appeal against the parent order.
No.
Another.
Your Lordship, here we are concerned with 22 heads. There it was 487. So now 487, my lord, is on the verge of completion, my lord. And next date, my lord, fixed before the Honorable Division Bench is on monthly list of July 2023. And regarding this,
why not include these 22 people also?
Already, my lord, Lordship, on the last occasion, Lordship kindly takes up your Lordship's order, my lord, dated 24th April, my lord, 24th April, your Lordship's order.
Yes.
On the last occasion, Lordship was pleased to take on record one written communication dated 13th March 2023 to the Joint Secretary by the ADM. Next, my lord, on 19th April, pat on the point on 22 heads. This was the, my lord, this requisition given by the DM to the Principal Secretary Housing. Now, off the record, if I may say this, that now Principal Secretary, my lord, day before yesterday, he has sent the matter to MIC Housing. And DM also has been called, and my lord, we have had a discussion in the Chamber of Learned AG, my lord. So he has also taken the responsibility. Today, my lord, one thing we may do, my lord, the name of the DM has to be replaced. Now it is not Ulganathan, but Shumit Gupta. I am giving the particulars to my learned friend so that he can correct the cost title, lordship.
Has he been named in the?
Yes, lordship, it's a contempt.
Very well, yes. Please do that and I'll keep this on record also, 19.
And kindly keep this on record, Lord, 19th April, Lordship.
Very well. Learned counsel for the alleged contemner hands over a copy of a communication by the district magistrate to South 24 Parganas, to the principal secretary, housing department, government of West Bengal, dated April 19, 2023, indicating
Last
the-
line of the letter, release the amount for
and requesting for release of the amount under the Gitanjali scheme to be disbursed for 22 petitioners, who have preferred the instant contempt application and the connected writ petition. Full stop, next para. It is further submitted by learned counsel for the alleged contemner that what else should I record, Mr. Galip?
let the matter be, my Lord.
When should I keep it?
Since before the Lordship kindly keeps on reopening once, Lordship.
Is further submitted by learned counsel for the alleged contemner that the matter may be placed.
Because before Honorable Division in the monthly list of July. So before that, we can think of 22.
Yes. This is
No, not August. We should push them. Kindly keep, no.
no, I'll keep it in the monthly list of June.
Once, yes.
Very well. That the matter be placed in the monthly list of June 2023 for further consideration of the
Lordship,
said communication to the principal secretary.
Lordship.
Full stop, next para. There being justification in such prayer, the matter is adjourned and shall next be listed in the monthly list of June 2023.
And my Lord, the cost title be corrected, Lordship.
Acha. Arekta line add kore daw. It is further pointed out by learned counsel for the alleged contemner that the present incumbent has changed in the office of the alleged contemner. Full stop, necessary corrections in that regard be carried out to the contempt application by the learned advocate for the petitioner, subject to the name of the present incumbent being furnished by learned counsel for the alleged contemner.
Here and now I am forwarding. Lordship.
Right now do that.
Here and now I am forwarding.
Any correction ta kore debo ajke naamta diye diche kore.
No, Sri Shumit Gupta IAS, DM, so and so.
Thanks.
Lord, I forwarded, Lordship.
Thank you.
I am trying hard and fast, Lordship.
Thank you so much, sir. This is absolutely fair.
Lordship.
Thank you.
Lordship.
Using your good office really in
Lordship.
a good fashion.
Lordship.
Yes. Thank you.
75,000 per head into 22. Hardly comes to 15 lakh.
Thank you so much.
Item 28 and 29.
My Lord, I appear on the behalf of the petitioner led by Mr. Siddhartha Banerjee.
Yes.
He is on his legs before a division bench, my Lord, courtroom number 8.
No, Mr. Chatterjee, you have to start today.
I am not Mr. Chatterjee, my Lord.
Oh, you are Mr.
Homojit Mujumdar.
Oh, Mr.
Mr. Chatterjee is also engaged in some other court, my Lord.
Maybe not today. I'm for the respondent number 5, quarter number 5. Fresh notice has been served.
Contempt application.
Yes,
Should I
my
keep
lord.
it after the vacation?
No.
You will be engaged tomorrow also, tomorrow and day after tomorrow and there. On the prayer of the petitioner,
Yes, my Lord.
the matter is adjourned till
Just immediate after the vacation, my Lord.
adjourned till after the upcoming summer vacation of this court. Comment লিখে দিয়ে দি। Please give your name, Mr. Mojumdar. Somojit Mojumdar.
Homojit Mujumdar.
Somojit Mojumdar. For petition.
Item 30 and 31.
Yes, Mr. Banerjee.
Very embarrassing.
You have committed a contempt.
No, yes, I am appearing for the alleged. I am appearing for the alleged contempt.
Yes, obviously.
But an appeal is pending. We are trying very hard. It's very embarrassing. I don't know what to say also.
No question of embarrassment. What can you do? So when should I keep it, Mr. Banerjee?
Keep it that side. Now 1 week this side. So keep after 2 weeks after the thing.
On the prayer of the alleged contemners, in view of pendency of an appeal against the parent order, the matter is adjourned and shall next be listed in the monthly list of June 2023.
Only thing, my Lord, we have been suffering. That's only my.
তাহলে for the petitioners না করে for the sufferers করে
Monthly list of June will come out on 5th.
after the vacation.
No, 5th. No, so you'll have to give me after some time because after this I won't get an opportunity.
On the other side, you said other side of what?
No, no, I'm saying at least 2 weeks after vacation.
Very well.
Did we fix, my lord?
Very well. Adjourn till তাহলে ওটা না করে adjourned till
6th of the reopening.
give me the date, Mr. Banerjee. Give me some date.
Anytime, not 15th, 20th, as is convenient to your lordships, man.
Adjourn till June 19th, 2023.
As is convenient.
2 weeks after that.
Because the monthly list will come out immediately after the summer vacation.
True, true.
32, 33.
I am for the fix.
Yes. Reply? You have to file reply.
Reply given, my lord.
Time for filing reply was extended. Yes. Yes. What is the contempt?
My lord, kindly have a look to paragraph 4 of my reply. Paragraph 4.
Of your contempt application?
Yes.
Oh, that. Yes, what do you say? Mr. Bandyopadhyay?
My lord, initially, my lord, in terms of your lordship's order, dated 18th August, we have given him hearing on September 28th, 2022. Thereafter, that order was communicated to him. But he said in the previous content that he has not received the communication. What happened, my lord, regarding Pujali, my lord?
Regarding
Pujali area.
Yes.
Police station Pujali area.
Pujali, right.
Whether the Muslim manager register post is vacant or not, that we have to ascertain from the law department. And after ascertaining, we communicated him to keep contact with the office. If we receive any information, we shall give him further hearing. On 30th, my lord, of December, we have received the communication from the law department that the post has been created. Thereafter, we have called him on 9th of February.
Why so long after? 30th December?
30th December, 30th.
30th December?
December 2022.
Very good. Why do you wait for 1 month? Anyway, that may be official.
We have called him, he went there. And thereafter we have...
Which year? This year? 2nd day February?
23. And we have passed an order that the matter has been notified. You please apply. And he has not applied for.
All these have been annexed in your opposition?
Yes, madam. A previous, second time he has come to the contempt, my lord, before this court, that the previous order was not communicated. All the orders were not communicated to him. That is his main grievance. Pursuant to the second order of your lordship, passed on 27th, in the first contempt, we have communicated the order.
Yes, what do you say?
My lord, notification has been issued already.
My lord, evidence.
Notification issued, they have given you a notice on that. So why did you apply?
My lord, kindly consider, my lord, evidence in reply, my lord, paragraph 4, my lord. Evidence in reply, my lord.
Evidence is reply.
Paragraph 4, my lord.
Yes.
My lord, first of all, my lord, I made an application 24th November 2020. They did not take any action, keep it silent, my lord. My lord, then, my lord, on 18th August, my lord, I filed a writ application, and on the writ application, this honorable court was pleased to direct to dispose of my representation and communicate the decision taken by them. No action was taken by them, my lord, pursuant to the order of this honorable court. Only, my lord, the matter was heard on 28th September 2022. My lord, the matter was heard, but no communication was made. Then I filed a contempt application, my lord. And during pendency of the contempt application, on 9th February, they called me and I appeared. But, my lord, they did not pass any order percentage. First of all, the ad was 28th September.
Again on 9th of March, then my lord was pleased to direct to communicate them the result of the hearing of 28th September and 9th. They kept it silent. Then I again, my lord, filed an contempt application. In spite of positive direction of this honorable court, they kept themselves silent and no order was passed.
So pursuant to the order dated February 27, 2023,
My lord, we have communicated, kindly
Yes,
come
I
to
have
our
communicated.
proposition, my
you have
lord, page-
annexed that.
Page 13, my lord.
Yes, my lord, I have
You have
Page
annexed that.
13, my lord, we have communicated. This
Where is the
postal
contempt
receipt.
then? If they have communicated to you, there is no contempt then.
My lord, they did not communicate. My lord, kindly
Well-
page 18, my lord, see, my lord.
You have stated that within but as on the no result of hearing was communicated.
Of both the hearing. No one, my lord, kindly
On
page 18, my lord. Page 18, my lord, again I filed the contempt application and this honorable court. The alleged contemptor, however, shall communicate the outcome of the hearing given to the petitioner at the earliest within 2 weeks, my lord. But no communication was made by them regarding the hearing of 8 September 2022 and 9th February 2023. This,
My lord, kindly come to our opposition, page 13, my lord. This is,
let me complete.
oh, all right,
the
all right,
issue.
all right. Yourself useful and
My lord.
What else? You finish your submissions? Yes. Then I'll hear him. This is the contempt.
This is the contempt, my lord.
Let me hear him now.
Yes.
Yes, Mr.
Lord, we have communicated, my lord.
Page 13 of opposition.
Page
Let us
13.
see that.
This is first, second, third, fourth one, postal receipt. And page 12 is also, my lord, there. 16th of March.
What is the communication? These are postal receipts.
16th of March, my lord, page 12, my lord. And this is the postal receipt in page 13, my lord.
The result. My lord, what is the result? Decision should be communicated. What is the decision?
Please read out. Read it out, Mr. Bandyopadhyay, your communication.
In response
You
to
have to
some-
communicate the outcome of your decision. I mean, outcome of your consideration. Please read out loudly.
My lord, I have.
No, please read out.
In
Read out this
response-
communication.
In response to the.
Use the microphone, Mr. Bandyopadhyay.
In response to the subject and reference mentioned here and above, undersigned is directed to forward a copy of the recent order dated 28 none passed by the Inspector General such and such, First Time Revenue, West Bengal, in compliance with the direction as content in the order dated such and such passed by the in the above matter. This is for your kind information, my lord. With it,
What does
my
it
lord,
mean, Mr. Bandyopadhyay?
my lord, it is not stated clearly, my lord. This is the order, my lord, page 9. 22nd of.
Did not communicate. Now you have annexed to your opposition. Why? Repeatedly you are being directed to communicate. These are ordinary people, that's why. You are a
No,
deputy commissioner or something.
No.
Deputy commissioner of stamp revenue, that's why.
That is not, my lord.
Yes, Mr. Bandyopadhyay. Is this a communication of your reason? Is this your understanding of English? Deputy commissioner of stamp revenue, what is he or she? A WBCS officer?
Yes, my lord.
So he or she doesn't understand English, basic English. What is the meaning of this communication? In response to the subject and reference, you are just quoting certain words without any meaning. Everybody is an idiot, Mr. Bandyopadhyay, that they won't understand.
It should
There is nothing here. This is
Enclosure-
patent contempt. I'll issue a
enclosure-
rule of contempt against this deputy
Enclosure
commissioner.
is there, my lord. Enclosure should be written.
Every time they have to come before this court,
My lord, in
let 2 months salary of this person be attached, he will understand immediately. He understands only the language of money. Because this is not a moneyed man, an ordinary person applying for a Muslim marriage registrar.
my lord, page 9.
What is this communication?
Communication is wrong, my lord.
This is no communication at all. In response to the subject and
it
reference,
should be
understand
that
this
the enclosed order has been.
Where is the order?
Order is at page 9, my lord.
No, you have not communicated. It was not there with this. Order might have been passed later on also.
My lord, upon giving him hearing on 9th, my lord, order has been passed.
You are writing this order in your office. What is the outcome? Let us see. If it's in similar language. After 3 pages, your ordering portion comes. Please read out.
Heard.
Page 11, yes, heard from there.
Heard the petitioner, this said his petition and the director register on Atom at around 12 p.m. considered perusal of the records, informed the petitioner and the concerned district registrar about the receiving of the communication from law department with regard to the creation of MMR post for the newly created Pujali police station area. Informed the petitioner that the director will take immediate necessary measures for initiating proceedings for giving appointment to the post of MMR for the police station area. Also informed concerned district registrar to initiate proceedings in this regard immediately. And when the matter will be taken up due to contemplation, his prayer or application shall be taken into account usual. The petitioner will be at liberty to collect information under application.
Why should you take information every time?
My
This
lord,
is absolute contempt of court. You should be behind the bars. Mr. Bandyopadhyay. What do you think? Usage of this sort of jargon will fool the court.
Not thereafter, my lord, application.
You have to change your habit on this, Mr. Not you, I mean, your client.
Yes, my lord.
This has become a habit now. Let him come to court and explain.
It should be.
This is
clear.
the reason we call these officers, and later on they complain. Courts are always calling us. Our work is being disrupted. This is the reason. This is their work. Being hugely paid from the public exchequer. This is the reason. This is their work, Mr. Bandyopadhyay.
Yes.
This is palpably contempt. I'll issue rule.
My lord,
Yes, why not? Tell me why not.
my
Your
lord, we-
affidavit in opposition, I'll quote your affidavit in opposition. I'll quote your sentences.
my lord, we have communicated actually, the order has not been.
Despite repeated directions of this court on each occasion, comma, the petitioner has been compelled
My lord,
to
may I-
approach
may I-
this
my lord,
court
my lord,
by
may-
way of filing
May I
contempt
file a
applications,
supplementary affidavit, my lord?
by filing contempt applications on several occasions. First up, next para, the last such instance was when this court had directed specifically the alleged contemner to communicate the outcome of its decision on the petitioner's representation to the petitioner within a limited period. First up, in answer to that, comma, in the affidavit in opposition filed by the alleged contemner, comma, a communication dated March 16, 2023 has been annexed, comma, which states as follows, colon দিয়ে affidavit in opposition page 12. এখান থেকে এই পর্যন্ত কোট করে দেবে in response থেকে এটা এটা next para. However, comma, in the very next page, comma, copies of postal receipts and track report has been annexed. However, comma, the meaningless jargon vomited in the said communication, communicated double inverted removed. Communication does not have any implication or meaning whatsoever, comma, let alone indicate any outcome of a consideration of the representation of the petitioner. Next para. As an afterthought, comma, a copy of a purported order dated February 28, 2023 has also been annexed to the affidavit in opposition of the alleged contemner, comma, which also contains precious nothing, dummy, precious nothing. The short ordering portion of the said order is quoted herein below, page 11. Page 11 এর এইটুকুনি hearing থেকে এই পর্যন্ত. Next para. It is clear from the above facts that the alleged contemner did not even care to pay lip service to the repeated directions of the court. It is not expected that an officer of the stature of the Inspector General of Registration and Commissioner of Stamp Revenue, comma, West Bengal, comma, who is entrusted with the fate of several official transactions of the public, comma, to act in such a nonchalant manner merely because the petitioner is an ordinary citizen. Full stop. Next para. This court is not satisfied at all with the explanation sought to be given by way of the affidavit in opposition, comma, in view of the vague and meaningless language of the communication of the alleged contemner to the petitioner. Full stop. Hence, comma, a prima facie case of contempt has been made out. Full stop. Accordingly, a rule be issued to the alleged contemner in terms of the contempt application bearing CPAN 354 of 2023, which shall be made returnable on June 19, 2023 at 2 p.m. Full stop. The alleged contemner shall be personally present to explain his conduct on the said returnable date. First. After rule it terms have.
But I'm sorry, troubling your lordship.
Yes, thank you.
My lord.
Yes.
I beg to apologize, and my lord, I tender my unconditional
For what,
apology,
Mr. Naik?
because on the last occasion, my lord, I used or I also referred one document which was applied in the name of the writ petitioner, which was very bad, which was not likely to be
I
done.
don't understand.
My lord, on the last occasion, the registration.
Last occasion is today or
Friday, lordship.
Friday? I forgot what happened in Friday.
Now,
What happened? What
it's
did
a
you do?
matter regarding my lord, recovery of outstanding dues, where we relied upon one document.
I am not supposed to remember that, Mr. Naik. Whatever happened, happened. If you
The order
misled
is
the
there.
court, you misled the
Order
court.
is there. Our officer applied for the requisition certificate. Why he did not put his name?
Mentioning in this manner won't do, Mr. Naik.
He has come, my lord. He had direction was that he must be present in the court
Today,
today, lordship.
item 40.
40. That's the my lord, only reason of troubling your lordship at this fag end.
কালকে কি আছে? কালকে 2 p.m. fix করে দাও। একটা order record করো 40 তে। The matter is taken out of
He is
turn.
the station manager. He tender unconditional.
The matter is taken out of turn in view of paucity of time to take up the matter today. Full stop. Personal appearance was directed in the matter. Full stop. However, comma, today, since the court hours are over, comma, let the matter be listed tomorrow for being taken up sharp at 2 p.m. when the alleged contemner shall be personally present to explain his conduct to the court. First. Come tomorrow at 2.
Grateful.